Good morning, Mr. Chairman.
By my watch, it's 6:01, and, or not 6:01, 8:01.
8:01.
Sorry, been up since 5. And I see we have a full quorum. We also have the addition of Representative Nicholas. So with that,
Mr. Chairman, I noticed we also have Senator Steinmetz in the audience today as well.
okay. Senator Steinmetz, welcome. Good to have you here.
Mr. Chairman, this meeting has been noticed as a regular meeting for the State Loan and Investment Board and the State Board of Land Commissioners. As you mentioned, we have a quorum, so we may proceed. Mr. Chairman, it was my understanding that you wanted to, before we get into the agendas for the boards, that you wanted to handle one of the Board of Land Commissioners agenda items first. And if that's still the case, that was matter D14, and I'd be happy to introduce that.
Very good. Without objection, Board, I've asked for the convenience of the Cushmans that they have the opportunity to present first. Is there any objection from the Board? We are taking things out of order. Thank you, ma'am.
Mr. Chairman, this is matter D14 on the State Board of Land Commissioners agenda for today. It's to consider a grazing and agricultural lease expiration. Here are the facts. On August 25th of 2022, OSLI staff mailed a renewal application to the address on file for the Cushmans related to State of Wyoming Grazing and Agricultural Lease 1-8817. We attempted to contact the Cushmans on November 1st, as at that point in time, we had not yet received their application and wanted to make sure that the renewal deadline of December 1st was coming. Unfortunately, we were unable to connect with them. We then did receive the renewal application from the Cushmans on November 18th, and it was timely pursuant to the requirements of Wyoming Statute 365104 and Chapter 4, Section 5 of the Board's Rules and Regulations. After review of the application, we determined that the application was incomplete. The lease was held in the names of Danny Cushman and Barbara Cushman. The lease renewal application was only signed by Danny Cushman, and the answers provided in Section 1A, Romanet 1, did not match the current lessee information on file. It indicated that they were renewing as a general partnership. We again attempted to contact the Cushmans on November 22nd to clarify about the discrepancies in the application with what we had on file. After many unsuccessful attempts to contact the Cushmans at the number we had on file, staff did then try to contact the Lusk Police Department to see if they perhaps had any additional contact information for the Cushmans, because all we had was the one telephone number. We didn't have an email address. We didn't have an updated telephone number. The application itself has a space for an applicant to update their contact information. There was nothing provided in that box. Unfortunately, the Lusk Police Department only had the number on file that we had been utilizing to try to contact the Cushmans. So therefore, we were unable to contact the Cushmans, and their lease expired on January 1st of 2023. On February 28th, OSLI staff sent the Cushmans a certified letter informing them of OSLI's determination that a complete lease renewal application had not been timely received, and lease 1-8817 expired pursuant to its terms. Mr. Cushman then called OSLI after he received the letter, and staff was able to provide him an explanation of the issues concerning the application. On March 29th, OSLI received a document entitled Notice of Appeal, in which Mr. Cushman's attorney sought to appeal to the board OSLI's February 28th determination that a complete lease renewal application had not timely been received. Mr. Cushman's counsel was informed that there's no law that affords a grazing and agricultural lease renewal applicant the right to a contested case before the board to challenge OSLI's determination. The board's rules only authorize contested case proceedings for conflicting applications and lease cancellation appeals. Instead, it was OSLI's position that the February 28th letter was a final administrative action, which was subject to judicial review under Wyoming Statute 16-3-114. OSLI's determination that the lease was incomplete was because the lease that was being renewed was in the name of Danny Cushman and Barbara Cushman. When you renew a lease application, or when you renew a lease, it must be renewed to in the same capacity as to which the lease was held prior to the renewal. So in this case, since it was held by Danny and Barbara Cushman, it would need to be renewed to Danny and Barbara Cushman. It could not be renewed to a general partnership, as the general partnership did not hold the lease at that time. So the notice of appeal contended that the Cushmans were a general partnership and they felt that they were still a husband and wife, and so therefore OSLI should accept the application that Mr. Cushman was authorized to sign for the general partnership. But again, as I mentioned, we determined that those conclusions were insufficient. Also, we had no information demonstrating a general partnership between the husband and wife pursuant to several Supreme Court cases. The Supreme Court has determined that the existence of a general partnership between a husband and wife must be clearly proven. But as I mentioned, the bottom line here is that the lease application, they were trying to renew the lease in a capacity in which the existing lease was not held. After we declined to push the notice of appeal to the Office of Administrative Hearings for a contested case, the Cushman's counsel then sent a letter to the board members asking that the matter be placed on the board's June agenda. I was then directed by a board member to place the matter on the agenda. And so that's where we are today, Mr. Chairman.
Thank you, Madam
Mr.
Director.
Chairman.
Mr. Treasurer.
I want to look at a timeline omission. And from, you started in November 1st. I see in the material we have that there was a letter sent on August 25th by OSL staff. And the question I have, was that letter, was it returned to the Office of State Lands, returned to sender, no address found?
Mr. Chairman, Mr. Treasurer, no, I do not believe it was. I believe it was sent certified and it was signed for.
Okay, so we knew one thing as far as the Office of State Lands, that you could contact the Cushmans via the U.S. mail. And so, but for several times you tried by the phone and you knew you couldn't do that, and then you contacted the sheriff's office, the police department, because you couldn't call them. I'm wondering why there wasn't another letter sent in the month of November before the lease deadline to file and correct any problems.
Mr. Chairman, Mr. Treasurer, it's generally our practice that when we receive an application, the application was received November 18th, we try to call. You have to understand that the renewal deadline to receive everything was December 1st at this time. So we were concerned that if we sent a letter, that that they would not receive it in time. So our best practice, we thought, was to try to get an email address for them, to try to get a telephone number for them, and to call them and try to resolve this over the phone, as opposed to send a letter. Also, during this time, it was the holidays, and we were concerned that it was Thanksgiving break, and so that diminished the number of days that would be available for the mail to be delivered. Am I missing anything, Holly?
The only other thing that I would add is it was received in our office on the 18th, but just to give you a little bit of an idea of how our processing works within the office. So it would have been received in the office on the 18th, and then at that time it goes over to the investment side where they process the money. They process the check and put it into our system. But the paperwork doesn't actually come over to the other side of the office for a couple of days past that. So by the time we received the paperwork, reviewed it, and realized that there was a deficiency, we were already very close to that holiday. And so my staff and I had that conversation about, should we try to mail a letter? And looking at the calendar and what the post office, is truly capable in that kind of a time frame, we didn't see any way that the letter would reach them in time. So that definitely was considered as an option. However, we felt that we were better off trying to find any way we could to contact them. As the director mentioned, we called around, within the city of Lusk, we called the police department. We even, tried to see if they had any social accounts that we could find. We really did a deep dive to try to find an alternative way that we thought we could contact them within time to give them an opportunity to cure.
Follow up, Mr. Chairman.
Please, Mr. Treasurer.
So the process that you normally use is to cash the check, and then for me, that's one part of a transaction. I mean, if I have a contract and I send money to a vendor and they cash my check, I'm assuming that I'm going to get the services that I sent the money for. That's one part of a contract. And the one part of the contract that you said that was deficient was a complete signature process by both of them not signing that. Now, but from my perspective is that you had a conditional approval when you cashed the check of that contract. And that, to me, I think that either you need to change your processes so you actually know whether or not the contracts that you have the leasees sign are proper and in order, or you don't cash their check. Because you've basically, from my perspective, if you cash the check, you processed it, then there should be some way that it can be rectified before that date. And even though you made that decision that your best practices would be for a phone call, as soon as you couldn't make that phone call, from my perspective, Mr. Chairman, then a letter should have been sent. And things probably could have been sorted out, maybe just, and I'm not sure what the process is, if they got sorted out on December 1st, whether that would throw us into a situation like we have now or not. But I do know that there is a way to contact these folks, and they have two letters. One, here's your lease. They get their check cashed. They think everything's fine. And the next letter they get is that, sorry, we think you're trying to game the system, basically, and you're out of here. And it's frustrating to me, Mr. Chairman. I think it was just both some, I guess, omissions on both parties. And I really don't hold anybody to blame here from the standpoint that there was just some mistakes from a lot of folks that resulted in an unfortunate circumstance. And from my perspective, I think the board has the opportunity to look at all of the facts and not and the time periods, and know that there was a way to contact the Cushmans, certainly before the next letter, the contacting them, is saying you're out of here. So I'm frustrated at the process. I think the legislature have done quite a little bit in this last session to make sure that there's some protections in this area. But I think it's the protections that we've had in the past is the board to take the issues that we have in front of us and find out whether or not what we should actually be doing just to set things right.
Thank you, Mr. Treasurer, and I think the points you make are good ones. But as somebody who on 3 different operations has state lands, my family ranch, my own ranch, and a partnership ranch, I will say that we take the diligence to call the office and make sure everything is in order. It's a worthwhile call. So I'm not saying anything about the Cushmans in this particular case. I'm just saying that it's a good practice for whenever you're sending forms in to make sure. And I agree with your point on cashing the check. So,
Mr. Chairman, if I might
Madam Director.
respond on the check piece. It's our process to run those checks. We have to guard against non-sufficient checks to make sure that the state is in fact going to get paid. But But also, because we're government, we can't have a bunch of checks lying around. So it's our best practice to go ahead and deposit those checks and then issue the refunds if in fact we determine that that's what needs to occur there. But we're also protecting ourselves by making sure that the check's clear. And the other thing, Mr. Chairman, I would note is that these renewal letters go out 120 days before the deadline, if you will. And it's helpful to us if people can get their information in a little sooner, because that gives us a little more options, such as another certified letter and that sort of thing. I agree with you that the legislature has done a good job to try to give that cure period in there, so hopefully this won't happen again. But if people, and I also wanted to say, Mr. Chairman, we don't choose winners and losers. We're just simply going by the statutory requirements. So we aren't sitting here going, well, it stinks to be you. We are going through a checklist by the statutory requirements, and that's what staff is doing. We looked in our file here to see if there was any way at all that we could find that perhaps we had made a mistake, that this lease had mistakenly been issued in the name of a husband and wife and not a general partnership. We wanted to figure out if there was any way to make that argument to get this renewal done. It's a lot easier for staff with staff time to renew those leases than it is to call them vacant. So I would like to just say that in my opinion, staff did everything they could. I realized that unfortunately the timing here was such that things didn't work out.
And Madam Director, just a couple of points on that. I do know that the legislature, I signed the laws that the legislature put forward to kind of prescribe a more actually rigorous process, when what's needed here is more flexibility for the board, or excuse me, the staff, to be able to make a cure process. In fact, the recommendation I had made to the legislature was that they provide a grace period after the closure. And then one of the simplest things that could have happened is, instead of being received in the office, to say postmarked by. That is, those would have been simple fixes. The legislature chose not to do that. Instead, they chose multiple deadlines, any of which could have been missed. So I really do encourage, and in fact, I've worked with both Farm Bureau and the stock growers to talk about this coming legislative session to please give a little bit of grace for the staff to be able to work to find those issues out. That would have resolved this issue. And the other question that I have, in a normal renewal process, you have the lease for a number of years. It is possible that people get divorced, or that people die in that interim. And there's usually a process by which, if there's somebody that's died, I've had that experience too. My wife passed away, and we had to go back to the state land board and present a death certificate, et cetera, to make sure that our lease was solid. My concern is if we just act without some diligence, just on the assumption that things are right, we run the risk of perhaps inappropriately conveying property without full knowledge.
Mr. Chairman, your point is well taken. And, that's why, particularly in the case of a husband and wife holding a lease, we require both signatures, because we can't bind a party to the terms of the lease if we don't have their signature. So the other piece of that is perhaps we're signing somebody up for some responsibilities that they themselves are not willing to take on. So that's a reason for the dual signature, if you will. And then your point too, I think we need to be careful about processing and making sure these things go correctly so that people's interests are not inadvertently removed or impacted.
And the other point that I'd make, I was old enough to remember the tribulations of the 80s, and I remember neighbors working on ways that they could get their swathers, balers, any of their equipment, their portable corrals, onto a different piece of property, which they divided so that the company that was mortgaging their property could not come to seek it. And I think any reasonable rancher in that kind of circumstance would probably try to do something like that. But I don't think we should be complicit. So, Madam Auditor.
Mr. Chairman, I would just, I mean, in this or any scenario, I would assert that it would make your state auditor very nervous if agencies were receiving checks and sticking them in drawers. That's poor practice for any business or government. Just for some perspective, how many leases renew at a given time? For example, how many lease renewals were you processing, for example, that, you know, the 3-month renewal period there for this year?
Madam Auditor, we have approximately 400 renewing at any given time.
Okay. And Mr. Chairman, how many staff do you have working on that?
At that time, we had 2.
Okay, thank you, Mr. Chairman.
Thanks. Secretary.
Thank you, Mr. Chairman. You know, I'm looking at this form and I'm just wondering, I mean, why isn't there a box to be able to renew in the capacity that you originally renewed on? Because if nothing's changed, I mean, you know, asking people to remember the legal intricacies of how their organization is set up, I mean, I just think there should be a box to say, look, we're renewing the same capacity we did originally. And I think that would ameliorate some of these issues. My second question is, I mean, in the future, you know, I'd appreciate, you know, if one of my questions, this is one of the only ones that you had identified at the end of December that was an issue of the 400 that we're renewing.
Mr. Chairman, Mr. Secretary, the reason we ask for sort of what the applicant is renewing under is because we have to ensure that they are a qualified lessee. So that means if they're claiming to be an LLC or some other entity that must be registered with the Secretary of State's office, we have to ensure that they are in fact, that they have complied with that in order for them to hold the lease. With respect to other leases that didn't go forward, it's not uncommon for us to have a couple that don't make it across the finish line for whatever reason. You know, we didn't receive their check or it was late or whatever. I don't know, Holly or Jason, if you guys remember the specifics at the end of this particular renewal period, but if you would like to provide some color, Mr. Chairman, I would ask that they do so.
So for this renewal period, we had over a 96% success rate of leases renewing. And I believe we only had 10 that went vacant out of the whole process. So, you know, I think pretty successful. You know, the auditor had asked how many staff we had at this time. And I guess if I can, I'd like to clarify a little bit. We did not have a grazing staffer at this time. So it came down to 2 other individuals on the trust land management side who were trying to process these. So, you know, really just trying to do the best we could with what we had staff-wise. And then, of course, this was during Thanksgiving week. So appreciate that.
Yes, and Mr. Secretary, just to your point about just signing off, when I bought my ranch, we did not have LLCs available, so we were a partnership. Since that time, there are certain advantages to becoming an LLC. In the intervening time between when we signed the lease and when we renewed the lease, we became an LLC. So lots of times things change. Now, what we have tended to do is to try to keep track of our state lease, which was particularly important during coal bed leasing, methane leasing times, just because people were asserting all kinds of things. So having a copy of the lease that you had was just good practice. So often what we'll do is we'll compare the existing lease that we have with the one we're renewing, and the form has changed. And in fact, I've asked both Farm Bureau and stock growers, and I think you've had a meeting to this effect, try to simplify the lease form and to try to figure out how to do it electronically. All of this would be helpful, and to also allow for payment by credit card. These would all be major fixes that would help this whole process.
And Mr. Chairman, you know, I'm just saying a box to certify whether anything has changed or, and if you changed to an LLC, you wouldn't check that box, you know, and then you'd move on to the next question. I mean, I think it just, it would make this a little bit easier. I mean, I've had forms I've filled out, like reports that are annually, and I asked for the previous one because I want to make sure, how did I fill out my name the previous time? Charles or Chuck? You know, I mean, things like that, and errors can happen. And, you know, I had a another question, though. What I was trying to get at is how many of these had you identified? I mean, this is pretty clearly, it's a kind of a judgment call, but this was pretty clearly just, if we are to concede it's an error, and I'm not conceding it's an error, but maybe just a small error, okay? And so how many did you have at that point in time? Because, I mean, I'd like to know if there's, it's one thing if it's 10, if people haven't renewed, but if I have to, I drive up and try to get contact with them. I mean, if we're not, I know a lot of people up there. I mean, if there's one or two that are having these issues that are, we've had 3 just before the board since the start of the year. And I think every term there seems to be these small deals that are small errors in the application, and we need to be able to get contact with the person. And, there's a lot of people up there in Lusk. This is Wyoming. I mean, I probably could have called up to 75, 100 people trying and then driven up. I mean, we got to try to make this happen. And so how many at this period were, in your judgment, were errors in the application that you had identified? I mean, is it 10 or is it just 1?
So I can't speak to a specific number, but I can provide some additional detail that may help. And I appreciate your points about being able to contact people. So, speaking a little bit to your point about, people being able to just check and say we're renewing the same entity. We have on our lease form what they hold it in currently. We have all that information on the lease, what their current mailing address is, the current name they hold the lease in, and an opportunity for them to update that. In this particular instance, the Cushmans left the updated form blank, including the ability to update their phone number. And so had that box been filled, none of us would have been sitting here today. And so that's just an unfortunate part of what led up to this whole snowball of events. And then as far as speaking to the number of leases that we identified a deficiency in, so, maybe they didn't come in with a payment, maybe they came in the wrong entity, so on and so forth. We have a whole spreadsheet that we keep of those. And the majority of the people that were on that list, we were able to contact, we were able to cure that deficiency. So the leases that we had go blank were ones that were people that we could not contact. And so any lease that went vacant this year, that is the primary reason why they went blank or went vacant, is because we didn't have the appropriate contact information. So I think it just really highlights how important it is to fill out that spot on our grazing lease form, because it is important that we're able to get a hold of people.
Thank you, Holly. Any other comments? Mr. Treasurer.
A couple of things on the process. Can you explain what would have happened that had the letter got there, at the end of November, but the Cushmans weren't able to get back to you until December? Was a timeline still basically violated, and we'd be in the same circumstance?
Mr. Treasurer, yes, and so that's the unfortunate part of not being able to mail another letter. And so, we received it on February 18th, which was a Friday, and the next week was Thanksgiving week. So, by the time we had to identify the deficiency, there were only 2, maybe 3 days left before that lease expired either way, irregardless. And so, I think that's something that this new cure bill will hopefully help with, because either way, that lease fell vacant December 1st.
And so, Mr. Treasurer, with the cure that I'm hoping we can achieve is the grace to be able to say, hey, this was incomplete. You may have been otherwise occupied, but we'd like to have a little bit of time, some reasonable period of time to be able to go back and make sure forms are complete and contact information is correct. But that is not really contemplated in the current statutes.
Yeah, and Mr. Chairman, I guess I don't want to bring in but I will bring in a separate situation where the board basically ignored the statutes and developed a grace period. So
We've done that twice.
yeah. So I guess the other thing is that and as I understand the timeline, The next time a letter was sent out was clear in February. When was the first time that anybody else in the public would have been able to, had they did the research, find out that that lease was vacated?
So when they receive the letter is when we normally send out. So we sent out all of the vacant notices that same day. And so as far as someone in the public being able to know, all of the information in our office is public when it comes to this. We have a public records room. And so had someone contacted the office, that information would have been public. However, we, to date, have not advertised that parcel as vacant, if that's what you're asking.
So it hasn't been, but the Cushmans weren't notified any time in December between the time of their, the period when they're supposed to have their lease in, and the time that the lease was, that ended the lease. They weren't notified that they were basically had lost their lease.
They were notified, again, at the same time as any others that fell vacant,
February.
after the expiration of their lease. So that's why you see that delay in time.
Yeah.
Because the deadline was December 1st, but their lease didn't actually expire until into January.
End of January, not January 1st, the end of January.
Sorry, I said into
Okay.
January 1.
January 1. And this, I guess this goes into another thing about, the way that the statutes are, is that you've got 30 days after your lease expires, but here the notification didn't come out until, I'm gonna get, what is it, 90 days to get your improvements off, or 120? But it seems like, it just seems a common courtesy that if somebody loses their lease, you tell them right away, irregardless of any other thing, because of the improvements that there may or may not have on there. Otherwise, you're really putting into jeopardy their assets. And it just has been, the notification process, and I guess that part of it, I think you said you only had 2 people. Are we understaffed at OSLI, just like we are in most agencies, or is it worse?
Thank you. I really appreciate that question. Again, at that time, we did not have a grazing staffer. So we had 2 other staffers that, in addition to all of their duties, were trying to do the best they could. And so, yes, in a normal year, that letter probably would have gone out sooner. But we were just trying to do the best we could to get all of the work done. I think something important to remember is, the 1 dashes renew December 1st, but then we also have 2 dashes and 3 dashes. So we actually have a lot of leases coming in over that set of months. So an extremely busy time for our office, and we're just trying to make sure that we get all the things covered. And so, yes, we at that time were severely understaffed. We were down 4 positions within that division alone of our office. However, we are grateful to the state legislature and the governor. We have since been able to hire some of those positions. And once the freeze is over, we actually have some new positions that we're going to be able to hire, including a secondary grazing staffer. And so we are very grateful for that, and think that, in addition to some of the legislative changes, will really help us out in our day-to-day operations.
Yeah, I guess, I don't think anybody from your office, I think, blames the Cushmans for not having the staff. I don't think there's no culpability on their part in not being able to be staffed, because I know I think you lost a lot of other people in other divisions, so I don't know how many you're down, and if you're like us, you try to cross-train everybody so everybody can kind of take over different duties for different people across divisions. But when you're down, it's like you get the things done that that you have to get done, but there are some things that need to be done and have to be done that just don't get done.
Yes, absolutely. Thank you for that observation. You know, and I myself was a brand new staffer. So, you know, in addition to trying to help out, I was also trying to learn myself the processes at the time.
Okay, thank you, Mr. Chairman.
Thank you, Mr. Treasurer. Madam Superintendent.
Thank you, Mr. Chairman. Just a comment I would make as well. I know we've talked a lot about the legislative action that will hopefully help with this process. But I think, you know, in seeing multiple instances, you know, even since I've come on the board with appeals, I think even our policy and rule regarding this appeal process for lease non-renewal is important as well, you know, to really provide an equal playing field for all lessees, not those that are just politically savvy and know to contact members of the board to become on the agenda, but also to make sure that we aren't disenfranchising our staff that really is trying to follow the letter of the law. So I think that process also needs to be updated to ensure that these issues don't happen, and so happy to be a part of that. But I think the legislative fix is helpful, but we have much work to do in that area. Thank you, Mr. Chairman.
And Madam Superintendent, I really appreciate that, because one of the areas, I mean, we really are forging new ground here. And I know that there were circumstances that were very frustrating, and I appreciate that. I think we've learned a lot in this process. I think staffing was an issue. You know, trying to catch up with a couple of other things was also an issue. But I'm, you know, being an ag myself, I'm very mindful of the special place we have in the hearts of Wyoming. But I do get very worried if we're not treating the energy industry or recreational facilities or outfitters or any of the others that might, you know, prevail or avail themselves of this board. And I don't believe we have a construct, but I think your point's well taken, in law that sort of says we can forge our own sort of appeals process. In fact, we're sort of outside the bounds of that at this point. So I do think, and I've had conversations with Mr. Magagna about, you know, how often do we go back to this well? And I'm very mindful of, you know, lease renewals that failed to occur. One was M&M Ranch Acquisitions, which was one of the big real estate companies that was looking at holding properties, and they failed to renew their state leases. And there were a number of my neighbors, including myself, who thought this was an opportunity to expand our operations. And I don't think that we would feel exactly the same way as we would about families, but yet we should take care of families at the same time. So I think your point's well taken, and I hope with the legislature's help, we can figure out a process that works and is, you know, clear and understandable. And to your point, not people who are politically savvy only can access it. So, Mr. Chairman, I got a couple more questions. Mr. Secretary.
You know, Mr. Chairman, I do think the cashing of the check is very, you know, the depositing of the check is very material, and you know, in terms of consideration and some of the legal aspects of this. So can you talk a little bit about when that happened and what date that happened on?
Mr. Chairman, Mr. Secretary, I don't know if we can pinpoint the actual day unless we had the check that showed when it cleared. But as Holly mentioned, that's the first part of the process. Is the checks are collected and they go to our financial side so that they are protected and accounted for and all of those things. And again, we're dealing with a government. It's not a private situation. We have a lot of checks. We can't just have them floating around. And to me, cashing a check, it just means for us, when we're evaluating these things, that's a box checker. We have the payment clears, where, you know, they fulfilled that piece of the requirements for the lease. So I guess I'm not sure why, if perhaps you could clarify for me why that is material,
Well,
given that we're government setting.
And Madam Director, I appreciate that, but, you know, for instance, there are checks for easements that come from pipeline companies and others, and on it clearly identifies that by cashing this check, endorsing this check, you agree to the terms of this condition. So I hope ranchers don't just inadvertently sign them. I don't believe that we have on normal checks an indication that there's a conveyed right, but I do think the auditor's point about not having checks floating around and tracking those. We already have challenges with dual controls in many places. I think practiced here would allow for renewals, but I do think the point's well taken. I just don't think that in this particular case, we are really looking at the special circumstances of this lease and whether this board is just going to renew it or not. So,
Mr. Chairman.
Mr. Treasurer, I was going to let the secretary respond,
that's
and then I also see the auditor is teed up, and then I'll have you.
Yeah, Mr. Chairman, I just think the depositing of the check is very material. I mean, while I'm not an attorney at work, and we took a lot of basic business legal classes, and the basic thing is whenever you want to cement an agreement legally, you have to have what's called consideration, and you have to have a transfer of funds, and whether it's $1, 50 cents, or whatever. And when that happens, I think I think the argument back would probably be that there wasn't a countersign, but I think that's a little ticky-tack if the office were to make that argument. And, I think the depositing of the check for me is very material here. So, thank you.
Mr. Chairman, if I might, I think it's important to understand that just because you've met all of the statutory requirements, you've deposited the check, you've filled out the application, ultimately, in order to receive the lease, the board still has to approve it and determine in that process whether that's in the best interest of the trust beneficiary. So it's a little bit different in my mind.
And if I may, I think I can certainly see some of the points you're making. However, I believe this is a standard across our state agencies. So for example, when you apply for a license with the Game and Fish Department, they take those funds, they hold them, and then they do the license draw. And then if you're unsuccessful, they return the funds. The same with the brand board. If you submit an application for a brand to the livestock board, they cash your check, they hold the monies, they process your brand, and then if you're unsuccessful, they refund it to you. Certainly just thought I would bring that to light.
No, that's a good point. Madam Auditor, and then the Treasurer.
Mr. Chairman, yeah, I think we're getting into the law of negotiable instruments, which probably none of us are experts in, and that's what I was just going to comment is I think many of us lend many hundreds of dollars to the Game and Fish for several months each year. And again, we cannot have any state agency sitting on thousands and hundreds of thousands of dollars of checks in drawers. So that is pretty standard across operations.
Thanks. Mr. Treasurer.
Had his hand up. I guess I don't know if there's public comment, or do you want us to?
Good point. Mr. President, I didn't see you in this. Please,
Thank you,
I
Mr.
recognize
Chairman.
you.
I didn't want to interrupt, and I'm actually not part of the board on liaison, but I was actually going to read the application. I've been through, it's the same as you. Our family at one point in time did not get our applications in on time, so I've sat the same way, and I've been to multiple times helping brand hearings. The importance of return addresses and whatnot can't be understated to anybody. These are major parts of ranch operations, both the brands and the other end. But I pulled the application up, and I've been through it many times, and we were talking about checking the box. And so I was going to read back real quick what it says as far as payments, because it's really clear, and I've always understood it that way. If you want to apply for your neighbor's lease, you actually have to pay for all the improvements up front on it. And they cash that check, and they hold it sometimes for up to 2 years as that conflicted application goes. It's painful. But what it really says, payment requirements. This application must be accompanied by the first year's annual rental, and this is what's important, offer, and required application fee. Applicant agrees the amount offered below should be the annual amount payable for the lease applied for, and the applicant agrees to pay the amount offered should it be rewarded. So you guys really have made it clear that this isn't a binding deal. You don't get it because you paid for it. You need to do it. We're going to cash it. And should you get it, you're going to do it. Otherwise, you're going to lose your $50 application fee anyway and do it. And I applaud you guys. To call a sheriff's office, I think is pretty far above and beyond, in my opinion. I will stand on the side of the Cushman's lot. I've been there and I can understand how important it is. But I think it's just critical that everybody understand that how important these are. The flip side of it also is the dual applications. I sit on a quasi bank board. We lost $500,000 at one point in time over a husband-wife deal because the wife had not signed the application. We went to court and found out that we borrowed money with no strings attached to the wife. So those deals, when you get to it, at some point in time, you're going to be sitting on the other side of it, that you accepted one and find out that you guys got to go to the AG to defend yourself because we didn't do our end of it. And so find myself both ends, and it's painful to look at your application and realize that it wasn't you that did it. I think it's changed at least 3 or 4 times since I've been in the Senate. We routinely, over these type situations, rather than making it easier, we add yet one more box to check or one more piece. And I would hope we could all find a way to simplify the application and still get done what we need. I agree with Mr. Chairman wholeheartedly and would be happy to try to help. But I can tell you this, it's hard to do much different when you get into it with stock growers and the other groups, because most of the boxes got put there for a reason.
Yeah.
Thank you. And if it's improper for me to do it, please tell me, because I'm happy to sit and go with public comment at the end.
No, Mr. President, I appreciate your comments. You're the liaison, and I think they're very helpful. Madam Director, members of the board, we've talked a lot around the policy. It does seem to me that we ought to offer the Cushmans a chance to address the board if they're here. If there are no objections. Mr. Cushman, welcome. If it gets red, the legislature made sure we had red lights and they have green lights. Tell me what that means, but.
Okay, thank you. Ladies and gentlemen, I apologize for my error and taking up this much of your time this morning to hear this matter. When it came to filling out the lease, on there was no place for husband and wife. As I looked through it, I figured, well, the only possible thing is partnership, being a husband and wife. And so I checked that box, unfortunately. My wife was out of town at the time. Her mother was ill, and she was spending time in Colorado, and she wasn't around at the time when I sent it. And I figured my signature on it is binding, we're husband and wife. The name at the top of the form, it had even been changed by the office, the state lands office. Why it had husband and wife in its entireties added to it, I don't know. It wasn't on the previous application. And then the box in there where you can put a change of address or something, or change of phone number. It says right on there, if a change of address, to fill out that box, that all notices and invoices will be sent to that address. When I asked the office several times, 2 different individuals, they told me, I says, why was I not notified by mail? They said, we are under no statutory obligation to even notify you. And they kept making that very plain to me. Unfortunately, I know government entities have to operate under a whole different realm than normal people. It's just the nature of the critter. I made a simple mistake. I wish I'd have had time to clarify it. If I would have received a letter, I would have got in the pickup and I would have drove down here to Cheyenne that very day and rectified the problem. I had no idea. My check had been cashed. I thought everything was fine. What do you do?
Mr. Cushman, thank you, and I absolutely sympathize. It's absolutely correct, and the forms are not easy. My wife and I take an evening, sit down, and then she, because I'm usually here, will end up calling the office and saying, now, what does this mean? And lots of us don't have that kind of time, so I really appreciate that. And I do think that one of the big things that's come out of the confusion we've seen over the last couple of years is some real opportunity to improve the process, make the form simpler, and figure out ways to improve the way this goes. And I thank you for being here today.
And when I received that letter in that the letter stating that my lease had been vacated, when I received that in the mail, I called them within the hour.
Yeah.
I called them immediately.
Yeah. Thank you, Mr. Treasurer.
I guess the question is really the details about how you apply for the lease, and I assume you don't have any problems applying husband and wife in their entirety or whatever, or however that would satisfy the understanding that the Office of State Lands had your lease originally issued in.
Yeah, that, what they'd done on the top of the form, I didn't understand why, but, because the old form just said Danny and Barbara Cushman. It didn't have anything else added to it. But, I think still the kind of the main issue for me is on their current form, at that box where there's a change of address, it says all notices and invoices will be sent to this address. And I was never notified by mail. That was, and like I say, it doesn't matter whether it's Thanksgiving week or whatever. I would have jumped in the pickup and I would have been down here at Cheyenne that same day.
You bet. Madam Auditor.
Mr. Chairman, you mentioned, and thanks for coming down, Mr. Cushman, that in the 2 form on your lease application, that said tenants by entirety?
Yes, on the very top, it says Danny and Barbara Cushman, or Danny Cushman, Barbara Cushman, husband and wife, as tenants in the entirety.
Okay.
And why that was added on there, I have no idea.
Madam Auditor.
I think maybe the director has some.
Mr. Chairman, it's my understanding that perhaps when they made one of their payments, that's the name that was on the check of the payment they made. And then there's an autofill as part of our SLAMS system that fed it in there, regardless of the fact that the lease is held in the name of Danny Cushman and Barbara Cushman. It was an autofill thing because of the nature of the check that they had paid by previously. That's my understanding.
Thank you, Madam Director.
Can I clarify on that?
Sure.
The checks I've used for 20 years, the name on the check is Royal Valley Ranch and Danny Cushman. Myself and my wife Barbara can both sign on that account. It's just, that's what's actually on the check.
Yeah.
Plot thickens.
Oh, well, but Madam Director, and then,
Mr.
if
Chair.
there's more to be illuminated here, that's fine, but I think we have a matter before us.
Correct, Mr. Chairman, that was our speculation, because we don't know. I mean, we don't know how that got in there, and it was told to me that there's an autofill portion when the lease is generated, and somehow it grabbed that out of the data that we have.
Right.
So I'm not trying to be nefarious or hold anything back. That was a speculation on our part. Mr. Cushman has said now that their checks are different, so then clearly that theory is not correct.
Okay.
Perhaps. a
Well,
quick
and
follow-up.
one quick question then. How many of the staff were here when this lease was first issued? You. Thanks, Jason. Okay. Madam Auditor.
Mr. Chairman, I think probably what I'm getting at will become evident, but if they are in fact tenants by the entirety, I mean, and I'm not saying they aren't, but that means one of them can sign the lease and bind
Yeah.
both of them.
Yeah.
Or not, and I guess that's my question, Mr. Chairman.
Mr. Chairman, when you are holding a property interest as tenants by the entirety, you're holding it as one property, and both parties have the right to do something with the property, so long as both have signed off on that. It's an indefeasible
Okay.
piece of property. So 2 signatures are required. One can't do something. It's not joint tenants where they could each take 50% and do with whatever. It's held as one, and both have to agree to what's done with the property.
And Madam Director, we could prosecute this a lot further, I think, but my view is Mr. Cushman made a good faith effort to get everything in on time. And I certainly understand the offices wanting to act as the legislature directs. I'm going to suggest, with all due respect to my good friends in the legislature, that we have the authority in the Constitution to be able to make decisions. But I do realize that these and the others that we have done are clearly outside the bounds of existing statute. So they are at legal risk. However, it does seem, if it's appropriate for a motion to be made, there is a director's recommendation. I think it's entirely in accordance with what your judgment and the way you went forward to deny the lease. However, if there is a will here to reject that, I think we can award the lease. Hold on just a second, Mr. Secretary, Mr. Treasurer.
Yeah, Mr. Chairman, I'll make a motion to approve the lease, I guess. Is that what I'm looking at this?
Well, I think you would deny the director's recommendation
Deny
and
the
approve the lease.
director's recommendation, but I want to go back to something that the director did mention, is that what we're trying to do here is manage these assets to the greatest benefit of the beneficiaries. And I think in denying the director's recommendation that we're doing exactly that, because what we're trying to do is keep the agricultural interests a viable entity within the state. And if we, I guess, make haphazard, decisions that only is on, whether a lease is 10 cents more an animal unit, or in these areas here where without denying it, that you stand the chance of I guess, basically totally upsetting a agricultural interest that's been successful for decades, and perhaps replacing that with one that the use of that land would really cause a hardship, not only to those interests, but to the communities in which they live. And when we make decisions that it affects not only the beneficiaries, the leaseholders, but in these small communities, it affects Main Street and the businesses on them. So I think all in all, we look at the general health of the state and the general health of all the taxes that are derived and support the beneficiaries, not only the narrow construct of a sectional land.
Yeah, Mr. Treasurer, I appreciate your comment. I do want to mention that for young ranchers getting started, for family operations seeking to expand their operations, it is important that they have those opportunities. And I'll give you an example with a major land trade that ended up and that'd be Bull Creek, where we were able to swap out a number of 40s and smaller sections and create a much larger section. If it had gone to the original leaseholder without a bid, the state would have been out a substantial amount of money. And, I can think of another situation, Butch White, up in our area. It was important for a neighbor to be able to expand into that operation. I do think, my point is not to disagree with you, but to say there are two sides to many of these situations.
Well, Mr. Chairman, I would move that we would deny the director's recommendation. And I think that just with the recent clouding of the actual, I guess, how the entity that actually held the lease in prior years was organized, then I think that it's the right thing to do with or without that.
And that motion has been made and seconded. Is there discussion?
Mr. Chairman.
Mr. Secretary.
Mr. Chairman, would like clarity first. I mean, I do like positive motions. I had a positive motion here. I just want to make sure in your understanding, if we vote this up, then that means the lease, we've directed the office to renew the lease, or do we then need to have another motion in your opinion? Or, so just want to take that first and then.
Madam Director, what would you like to see? Would you like to see?
Mr. Chairman, I think we need a little bit of direction here. If the
Okay.
direction is going to be to issue the lease, we need to know in what capacity,
Sure.
number one. But also, we have preliminarily approved a temporary use permit so that the Cushmans can go ahead and continue grazing the property until this was all sorted out. And there is the board's approval of that temporary use permit that's on the agenda later in the day that we will have to take out of that
Okay.
approval process. So,
Well, Mr. Chairman, I guess we'd modify it just to say that it's going to be an approved lease, and we'll use the determination that however it came to pass that the office has, which is the Cushmans in their tenancy entirety, and then provide, I think, with that application on how to, I guess, designate a different.
Mr. Treasurer, and just for the point of clarity, let's first
Deny it and then have a separate
deny,
motion.
then
Okay,
if
fine.
that makes sense, then I would like to have, because I think what the director's asked for is real direction on exactly how we renew it. So
Okay.
let's take that second. And
right.
so,
That's fine.
Mr. Secretary, you seconded it. Is that appropriate?
Yes.
Okay. So we have the motion to deny at this point. Is there any further discussion? Any further discussion? Any further discussion? All in favor signify by saying aye.
Aye.
That motion, let's see, we have everybody nays? No nays. That passes unanimously. So with that, either Mr. Treasurer or Mr. Secretary,
Mr. Chairman, I think, drafted a positive motion here that we further move that the board direct the office to process the completed renewal application related to lease 1-8817 and take all necessary conforming actions, including but not limited to waiving any late fees for the application.
Mr. Chairman,
Mr. Treasurer.
and I think we need to add to that the improvements that were in the lease would the Cushmans would retain ownership of all the improvements. So it wouldn't go through that process where they've been notified that they have to pay, buy those, you take the improvements off. So they're no longer required to remove the improvements, and the disposition of the improvements remain as they previously were. And if there's other language there.
Mr. Seconder, is that
Yeah.
meet with your, okay. Mr. Treasurer, please proceed.
Yeah, and I guess if there's other language that the board would entertain through the office, that's fine with me
And
to address those.
in particular, it seems to me there was a question about what entity or entities. Is that correct?
Mr. Chairman, yes, because of the general partnership piece. I think to maintain the integrity of our process, I think it would be cleanest to issue the lease to Danny Cushman, Barbara Cushman, husband and wife. And then if they want to assign it, they can file an assignment application with the office to assign it then to the general partnership.
Madam
Because-
Clerk, appreciate it. Go ahead.
I was going to say, because it's been our policy, and I think consistent with our rules, that we renew in the name of the entity that held it previously. Otherwise, it's not a true renewal.
Even though we don't
Mr.
know who
Chairman.
that is. So,
Mr. Treasurer, then the Secretary.
yeah, I'm fine with that. If the secretary would like to make that modification, I gladly second his amendment.
Mr. Chairman, I view that as friendly, so.
Okay.
You know, if you, there's one other piece here, Mr. Chairman, is, you know, the AG mentioned that if we were to move forward with this, maybe we should allow Mrs. Cushman to sign the renewal. And that was one other piece that I was going to put in the motion. I wanted to see where the board is at on it. And maybe the Cushmans, but.
Yeah, Mr. Chairman, I think if they do the tenant's entirety, it's required both of them sign it.
But I don't think we're doing tenants in entirety, are we?
Mr. Chairman, we consider it to be husband and wife.
Husband and wife. And Mr. Cushman, that seems to be what you indicated. And Mrs. Cushman, nice to see you as well.
Okay.
Thank you.
So, Mr. Chairman, we would need both signatures for that.
And just by chance, you have them both here.
So, Mr. Chairman, I'd like to add a third piece, which would be that we direct the office to allow Mrs. Cushman to sign the original renewal application.
Very, very good. Do we have a clear motion? Everybody understands what's in front of us. All right. Motion's been made, it's been seconded, it's been friendly amended. Is there any discussion?
Mr. Chairman,
Madam Auditor.
I think we have all, meaning both the Cushmans and the board and staff have been caught up in the specificity of the statutes, which is unfortunate. And you mentioned before that's been sort of a little bit of a struggle, that when we ask for flexibility, we get more prescription. And I think it is wonderful that the office has and will receive more staff. I think that's a critical piece. I know that we all know that we can put out all the ads for folks that we want, and folks just aren't applying right now either. So that's a challenge. So that'll take a little bit of to get up and running and to get everybody on board. The other thing, though, I think is with that additional staff, we have added in 3 to 4 to, and correct me if I'm wrong, more checkpoints and deadlines for everybody to miss.
That's correct.
So I am concerned that I know we will continue to work, and I'm so glad we have the highly competent chairman of Ag here to sort of hear these struggles. We again, I think the cure process in the statute, I hope that'll help, but I also think, again, it adds about 5 more things to get missed by a day or 2 by either the office or the applicant. And I think this becomes more complicated before it gets more simple, unfortunately. I don't think these will go away. I do want a thumbs up from Mrs. Cushman that she is here, does intend to sign the lease. Great. To avoid, President Driscoll's point was very well made. I think this all seems very clear right now because we know they're husband and wife and they're still married, but it's important to note that if we just had the office just processing things willy-nilly with one signature, you have no idea if it's an estranged spouse or a sibling in litigation or a partner that has gone rogue. I mean, that could be a whole host of issues. And so I think it's important to note that while this one feels very comfortable, I could see how it could go wrong in very, very, a lot of different ways. So, Mr. Chairman, I do intend to support the motion hesitantly, not because I don't believe that the Cushmans shouldn't have the lease. I do think they should, but it's way more complicated than the office just didn't try hard enough, or it's substantially more gray than that.
Thanks. Further discussion? Further discussion? Madam Auditor, I just appreciate your comments on this, and Cushman's, thank you very much for your work. Office, I think you've worked diligently. It is really nice, Madam Chairman, to have you here to hear this discussion. I have had a chance to talk to your co-chair and to a couple of members of and I think you're aware, I've talked to a couple of members of the Ag Committee about really providing a little more flexibility so that we can actually avoid having to come to this, avoid having folks like the Cushman have to hire counsel and all of that. To the superintendent's point, I think having a clearly outlined process that we have clearly, well, let me say, we have not done a good job of keeping the bull in the corral or in our fence. So, but we're gathering that bull up and getting it back to the pasture. And so very, very much appreciate everyone's work here. If there is no further discussion, all in favor signify by saying aye.
Aye.
Oh, wait, we have a vote, but Mr. Chairman.
Thank you.
Nichols.
Governor, what I would recommend is that you would have Jennifer and staff prepare a revised application process with the comments that have been all made today and present that to Ag at one of their next meetings, so that in listing what the issues are and the problems with the multiple deadlines and a outline of how to fix it. And then also I would suggest that you make that available to both the President of the Senate and the Speaker, because they're both Ag folks, and they will see, along with our good Ag chairman, that this thing gets fixed. Because I have the exact same problem. I think 2 years ago, after my dad passed away, we were delinquent on several of our leases, and it's just a process you got to go through. So.
Yeah. Thank you,
Chairman.
Representative.
To that end,
Mr.
I think
Treasurer.
that you'd probably, and we did this in our office as far as when we do our asset rebalancing, we changed it from quarters because we had the same problems with that you have with holidays. And so if you had your renewals like on December 15th and November 15th and September 15th, then you wouldn't have the problems with the holidays to the extent that you do.
Mr. Treasurer, I appreciate the helpful comments, and maybe we can have that as we kind of go through this. But we did have a motion, it has been voted on. To my knowledge, it was all positive. I'm going to ask for nays now. Nays? I hear none.
Mr. Chairman, one
that
more
motion-
very brief comment.
Okay, I'll just say the motion carried, and you may have a comment.
I would maybe suggest that the Cushmans also update their phone number with the Office of OSLI when they sign that lease. Please.
Thank you very much. And I know it's been a kind of a protracted process, but I think you've added to our understanding of the challenges here, and we've really appreciate it. Thanks. And really appreciate this, but I do also want to recognize that we have done this far more than I feel comfortable at this point. And I have conveyed that to both Farm Bureau and the stock growers that if this process, and no offense in this particular issue, but there is a time when we have to say this process of just coming to the board, we're really outside the limits of what the bounds are from the good legislature. And Madam Chairman, let me recognize you.
There's that wonderful red light. Thank you, Mr. Chairman. Well, I just wanted to address a couple of concerns that have been raised. So after our Zoom call the other day, when we met on this issue again, we do have 2 bill drafts coming to the Ag Committee. I don't know if they'll be taken up at this next meeting. One is to provide flexibility and a grace period that the director may extend. The other is that the application is received by the postmark date, and we're hoping that will alleviate some of the concerns that we've heard today. The cure process is a bill that I inherited, so if we need to tweak that a little bit, I'm certainly open to having that discussion. I appreciate the action that was taken by the board today. I did also want to comment a little bit on the board policy, Article 4, Section 5 on applications. I reviewed that, was not able to attend your meeting as we had a select water committee meeting as well that day. But under applications and forms, it says all applications to lease lands for grazing or agricultural purposes shall be made on forms furnished by the office. Application forms must be completed in full. Any false or incomplete statement willfully made that materially affects the application will be considered as fraud, deceit, or misrepresentation and shall be cause for rejection of the application. And so I think that the word willfully is very important in this sentence and when dealing with our leaseholders, because obviously this was an omission. We had a staff gone in both operations that take care of things. And I appreciate the decision of the board today, but I did want to just bring up that part about willfully. And so I do think there is some discretion there to be had. With that, I look forward to working with you on resolving these issues and our update that you will be providing on the process and tweaks that you might see when we come to the Torrington meeting next week, Monday and Tuesday. If anyone's in town and wants to join us, we'll be up at EWC and we'll be working on these issues again. So thank you, Mr. Chairman.
Thank you, Madam Chairman. Appreciate you being here.
I have a couple questions.
Mr. Secretary.
Thank you, Mr. Chairman. Chairman Steinmetz, any chance I could ask you a question? Yeah. Do you have a view, I've long thought, I was just reviewing our rulemaking abilities in statute, and I have a lot of respect for the legislature. I love the legislature, but, I think we should move ahead and do a cure process and rule, get something on the books here, an emergency for 8 months, with the understanding that the legislature may very well pass a statute that supersedes the rule. We can come back, reverse the rule. I just think we need to get something on the books with a little more of a procedure here. And rather than, just saying every time, well, the legislature is going to be meeting in 8 months, because one, there's the intervening period. We've had 3 situations now. And I just think mistakes happen, things happen. I just think we should do an emergency rulemaking. And I think the procedure is already there in statute for us to do this. I mean, if you don't want to comment, I understand, but do you have a view on that? I mean, do you think doing an emergency rule, setting up some kind of procedure for the next 8 months is problematic?
Mr. Chairman and Mr. Secretary, that is up to you. We've seen entirely too many vacancies, and it may be a small percentage or a small number, but these are decisions that affect people's livelihoods. And out of no disrespect to the office, if we lose a state employee or we have somebody drop the ball a little bit, the ramifications for that employee versus the ramifications for a rancher that loses his lease, it's a bit of a double standard to say that we can make a mistake, but our leaseholders can't check the wrong box. So that's going to be up to you guys how you handle that. But these situations are all too frequent. When you see it becomes such a hot topic at the legislature, it's a real problem across the state. So if you feel a need to create emergency rules until we can get back to session, I would certainly understand that, but that's your purview.
Madam Co-Chair, the good secretary makes a great point, but I have to tell you, I feel that the legislature makes the laws, and we have to act within the bounds of those laws. Now, clearly, we've exceeded that a bit here. We've asked for forgiveness rather than for permission. And I think people understand, and it's great to see how this process has sort of evolved over time. The amount of vacancies from our research did spike during COVID, but are well within the bounds they've been since the 70s. Right now, about 94, 95%, sometimes 96% of the leases go renewed normally. My concern is if the executive branch, and I know I'm the governor and I'd love to do this all the time, but my concern is if the executive branch starts acting outside the bounds of law on a routine basis, that we are in grave danger. We have a president that may be doing a lot of that right now, and I don't want to see us follow that course.
Mr. Chairman, as I said, that's up to your purview as a board. I'm not here to tell you what to do.
Thank you, Madam
But I
Chairman.
do appreciate your adherence to the law.
Thank you.
Thank you.
All right, is there any further discussion?
Mr. Chairman, I'd like to have a little more discussion on this rulemaking because my computer just locked, but I have the statutory reference, which clearly states that the Slib board has the authority in statute to do rulemaking and it's a broad rulemaking saying that, for the interests of the state lands. And I think we're at this point now. I think that there's more problematic legally with doing this case by case thing than setting up a cure process when you have that blanket rulemaking authority. For this board, we'll call it blanket, but it says for the interests of the lands themselves. And I think we're at that point that, I think we should just have a rulemaking process setting out a procedure for us to fix some of these errors.
So, Mr. Secretary, I'm going to recommend we take that up at the end of the meeting. There are a number of people here with a lot to do, and I want to be respectful of people's time. I do appreciate your comments, and we'll take it up at the end. We did take this matter out of order, so without objection, I would recess the State Board of Land Commissioners and open the State Loan and Investment Board.
Mr. Chairman, the first item on the agenda for the State Loan and Investment Board is approval of various meeting minutes. I will say those meeting minutes listed under A1, the February 27th and 28th, 2023 State Loan and Investment Board special meeting. Those are the amended board meeting minutes after the secretary expressed concern that in one area we had mistakenly put him on both sides of the ayes and the nays. So because the board adopted the changes at the last meeting, this is just showing that we've made those changes, so there will not need to be anything done with those. However, we will need approval of the meeting minutes from April 6, 2023, the April 7th State Loan and Investment Board special meeting, and the May 4th State Loan and Investment Board special meeting. I believe that was the treasurer's meeting.
All right, members of the board, you've heard. I'd like to take these one by one because I know the good treasurer wanted to take a pause, but he'll be back shortly. What's your pleasure with the meeting minutes for the April 6th board meeting?
Mr. Chairman, move to approve the April 6, 2023 board meeting minutes.
Is there a second?
Second.
It's been seconded by the superintendent. All in favor signify by saying aye.
Aye.
That motion carries. I would now,
Chairman?
yes, Madam Auditor.
I would move to approve the minutes from April 7th, 2023.
Thank you. Is there support for that motion?
Second?
That motion's been made and seconded. All in favor signify by saying aye.
Aye.
That motion carries. Madam Director, that moves us to May 4th, is that correct?
That's correct, Mr. Chairman.
Is there any discussion on this, or I would entertain a motion?
Mr. Chairman, I would move to approve the minutes for May 4th, 2023.
And is there support for that motion?
Second?
Thank you. All in favor signify by saying aye.
Aye.
Motion carries.
Mr. Chairman, we have provided the board with the usual reports behind tab B. We don't have anything to add to those reports at this point, but we have staff here and would stand for questions if there are questions about the reports enumerated under B.
Are there any questions about the reports behind tab B? We have water and sewer grants. We have program summary for countywide conservation consensus grants. Any questions on any of those? Hearing none.
Okay, Mr. Chairman, we note that we provided the materials for this meeting in advance to the board members, and we have briefed each of the board members individually prior to the meeting. At this time, I'm prepared to propose a very short consent list if the board would so desire.
That would be terrific. Thank you, Madam.
Mr. Chairman, we believe C3 and I1 appear to be amenable for treatment on a consent list.
Okay. So I'm doing my math. We can either take them one by one, or we can do a consent list.
Mr. Chairman, I would move a consent list consisting of item C3 and I1.
Second?
Been moved and seconded. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
We have a consent list of C3 and I1 that has passed. I would move for approval of the director's recommendation. I would not move, I would accept the motion.
So moved, Mr. Chairman.
Second?
It's been moved and seconded. All in favor signify by saying aye.
Aye.
Those motions carry.
Thank you, Mr. Chairman. The next item on the agenda is under policy matters, C1, to consider adoption of emergency rules for the State Loan and Investment Board, Chapter 40 Health and Human Services Capital Construction ARPA program. As you all know, the HHS Capital Construction ARPA grant program was created during the 2022 budget session of the Wyoming Legislature. The State Loan and Investment Board adopted rules to govern the program, which are found in Chapter 40. The board has fully expended the initial $85 million appropriation, which was made in 2022. During the 2023 general session, the legislature allocated additional ARPA funds for this program. An additional $25 million was provided to award funding for applications that were submitted on and before January 23rd of 2023. The board held a special meeting on April 7th to fund those applications that were received prior to that date. There was an additional appropriation of $15 million added to the program specifically for projects approved by the board in 2022, which require additional funding for inflation-related costs. However, the maximum grant cannot exceed $5 million. The board's existing Chapter 40 rules do not have rules to govern that those inflationary funds. So the office is recommending that the board adopt emergency rules. And I would yield to Ms. Blackwell to provide details about the recommended changes to Chapter 40.
Mr. Chairman, board members, the recommended changes include defining what inflationary costs are, which is the difference between the costs that were provided with their original application and the current costs that stand today. We also included in our rules that a new justification is not required for these additional funds, as a prior justification has been received and the project has been deemed eligible. We also set a maximum grant amount of $5 million in accordance with the statute, and we clarified that inflationary funds do not require additional match. However, it also doesn't decrease the match required of the entity with their original grant.
Thanks. Questions?
Mr. Chairman.
Mr. Secretary.
Mr. Chairman, I wanted to ask a question of Mr. Nicholas and the Senate President. You know, there's this whole question of Representative Chairman Nicholas and the Senate President. You know, there's this whole question of should this include increase in costs after the bid opening or not? To me, once the bid opens, that bid should include the inflationary costs, the estimates of inflation in there, and that it would be a poor precedent for us to, in this rulemaking, include increases that occurred after the bid opening. And so is there anything you want to, you know, the language is a little bit up to interpretation, I would say. And so is your thought that it would be increases in cost before the bid opening or both? Was that the intent of the legislature, in your opinion?
Mr. President.
Mr. Chairman, Mr. Secretary of State, my belief is, and this is mine, I'm not sure exact intent, you know, it's kind of hard, but is when you bid something, the bid is for the amount, and that's what it's for amounts that occur after the bid's been accepted and done should not be included. But Representative Nicholas may feel different, or Chairman Nicholas, but we run through this in water all the time. We have contingency accounts on that. So it does happen different times, but having been through a lot of bid processes, when you bid something, that's what your costs are, and that's what they should be unless there's extraordinary differences on it.
Chairman Nicholas.
So I don't have the documents that you're referring to put this in context. And so are we talking about the specific language that allows the folks to amend the contracts if there's a certain percentage over and above the bid amount of prices that we dealt with this session? So I'm not sure of the context.
Mr. Secretary.
Mr. Chairman, to put a little more meat on this, you know, I think the rulemaking is a little bit broad. And so I had a preparation, an amendment that would make it clear that it does not apply to situations after the bid is after the bid. And I've been assured it doesn't really affect anything because there's only one situation where this might happen, and it's actually a water project, not one of the HHS ones. But I think it's good to clarify that after bid opening, that inflation-related costs shall not include cost increases occurring after bid opening, cost increases from scope, materials, or design changes, or other costs not directly attributable to inflation. And I think that's a good clarification as we issue this rule on the but I wanted to, with you here as the liaisons, get your opinion on what the legislative intent was, and just wanted to button this up a little bit and prepared a little motion, but wanted to ask you before I did it on what your thoughts were.
Well, I think Mrs. Blackwell is going to help provide some of the background information that I was asking about.
Mr. Chairman, members of the board, Senator, and President, when we awarded these grants, most of what was submitted to us were engineers' estimates. And when you go out to bid, you go out based on your engineer's estimate. However, you don't know your actual costs of your project until you have awarded in a bid. That, I think, is the point where you want to stop inflation costs, because you can have the best engineer estimate. However, if you have one bidder, they can bid whatever they want, as high as they want. And so I think our grant awards are based on an engineer's estimate. Therefore, and we see this often with our SRF loans, once a project goes out to bid, that's your actual cost of the project, is what you award that bid for. And then if you approve change orders after the fact, I would agree, we don't pay for those change orders, but we've got to help them between what they estimated what their project was going to cost and what it actually was when it went out to bid, because so many factors are out of their control. Specifically, things that impact it are supply chain issues, the availability of workers, the availability of contractors and engineers. I mean, we have ARPA projects that are having to extend their end date for an extra year because they've gone out to bid and they have not received any bids, or the bids they've received are 3 or 4 times higher than the grant award they've received. So this is something we're seeing across the board with all of our programs, regardless of the type of project. So I think when it comes to inflation costs, when an entity applied and submitted their application in August, that initial application should have considered all inflation costs up to that point. That's the starting point of what we determined what we would award a grant on. Then, after being awarded funds and doing work and potentially going out for bid and finding out that, oh, we're woefully underfunded, we've got to go back to the drawing board and find additional funds. That's when you go back to your engineer, you readdress your engineer's estimate and you try again. And some entities have to go out to bid multiple times at multiple different times of the year in order to get a favorable price so that they can do a project with the money that they have. And so I think when you talk inflationary costs, you have to be careful when you talk about cost after bids are let. I think it's cost after the bid is awarded that we don't want to fund.
Mr. Chairman, I think that is an answer to the question, but I think we can, adjust the amendment a little bit. I think we can put a little more meat on the bone on what the definition is, just to make sure once the bid is awarded, that it does not qualify for these inflation-related costs. I guess, Mr. Chairman, if I could just read this right now and see, I want to get your opinion on whether this is in the right direction. So we would amend the definition to say inflation-related costs means the increase in a project's hard costs attributable to inflation for the time period beginning with the submission of the original project application and ending at the earlier of a bid being awarded or the submission of the application for inflationary funds. Inflation-related costs shall not include cost increases occurring after a bid award, cost increases from scope, materials, or design changes, or other costs not directly attributable to inflation. What do you think of that?
Mr. Chairman, Mr. Secretary, not being an attorney, I think that sounds great. I would like to turn to our legal counsel and get a nod of the head if he's comfortable with that. We got a thumbs up, so.
Thank you, Mr. Miller. No, recognize Mr. Miller in the back of the room. Okay, thanks. We'd be prepared for that when it comes up. So, Madam Auditor.
Mr. Chairman, just a quick question for the Secretary. I like the intent of that. I want to make sure I understand. Essentially, your intent would be to dissuade entities from asking for future inflation, over the next 2 years. It's sort of that back when you got your initial estimate up to when you award the contract, but anything after that, we're saying no, you're not able to ask for maybe what's going to happen in the next 18 months. That should already be captured in the bid.
Mr. Chairman, yes, is that the bid should include their estimates on inflation. And I'm very concerned that the way it's written right now, if we don't clarify this, that we're going to get a bunch of folks saying, hey, the bid's on them. And I don't think that was the intent of the legislature. I mean, they're saying things that have not yet been awarded, that were not awarded partially because the estimates were wrong because of inflation, like they were saying. So that's the intent of it. And I don't think the current definition on 40-2 quite gets there. I think you could, kind of drive a truck through it. And I did ask Mr. Miller to draft the initial rendering on this. So this wasn't just me sitting there. So it was run through some council.
Thanks. Further discussion? Further discussion? Hearing none. We can, Mr. Gray, or Mr. Secretary, if you would like to propose the motion with your amended language, that would be the motion that's on the floor and would expedite our process. So.
Yeah, thank you, Mr. Chairman. I would move passage of C-1 but replacing the definition of inflation-related costs on 40-2, which is in section 2, L, and strike the current language and replace it with inflation-related costs means the increase in a project's hard costs attributable to inflation for the time period beginning with the submission of the original project application and ending at the earlier of a bid being awarded or the submission of the application for inflationary funds. Inflation-related costs shall not include cost increases occurring after a bid award. Inflation-related costs shall not include cost increases occurring after a bid is awarded, cost increases from scope, materials, or design changes, or other costs not directly attributable to inflation.
Members of the board, you've heard the motion. Thank you, Mr. Secretary, for making it. Is there support for the Secretary's motion?
Second?
It's been seconded by the auditor. Is there any further discussion? Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Nays? That motion carries. Thanks, Madam Director.
Mr. Chairman, that brings us to C2, which is to consider adoption of emergency rules and authorization to proceed with regular rulemaking for State Loan and Investment Board Chapters 11 and 16. Chapter 11 addresses the Clean Water State Revolving Fund loans, and Chapter 16 addresses the Drinking Water State Revolving Fund loans. They must be amended to conform with changes in federal regulation and changes in the administration of the base state revolving fund program. Additionally, we need to insert some changes that will help us administer the funds, the Investment in Infrastructure and Jobs Act funding that will be coming through those two programs. And so, Mr. Chairman, I would yield the floor to Beth Blackwell to present some of the specifics about the proposed changes to the rules.
Mr. Chairman, board members, with the passage of the IIJA, they created additional funding pots or sources within the SRF programs. Within Clean Water, it added the supplemental pot as well as the emerging contaminants. Within Drinking Water, it included those two pots as well as a lead service line pot of money. In order to administer those funds, as they have different requirements than the base program, we must amend the rules. Some of the items that we have recommended for changes is including definitions within section 2 of both chapters, adding policies for the supplemental lead service line and emerging contaminants funding, changing the scoring model we have for disadvantaged communities within the drinking water program. That definition, as well as our definition for awarding principal forgiveness, has been changed. We included 2 new categories within that. The first one being the amount of property taxes and 4% sales tax an entity receives. So the smaller amount that an entity receives, the more points they get, so the more principal forgiveness they would be eligible for, helping to make that project more affordable for them. And then the second item is we're comparing each system's rate to their AMHI, their annual median household income. And we shoot for a 2%. That's kind of the standard. And if people have good rates, they're going to get an extra point, trying to reward good behavior for having good rates for our communities. So those are the changes we've made to the disadvantaged scoring model, as well as how we award principal forgiveness. We also included a section on how we would be administering planning and assessment grants, as that's a new option given to the SRF programs through the IIJA. And other than that, we did some streamlining and just formatting changes throughout.
Thank you. What's the pleasure of the board? Mr. Treasurer.
On the emerging contaminants, who develops that list?
The emerging contaminants list, meaning the list of contaminants or the list of people who are eligible for funding?
The list of the contaminants.
That's developed by EPA, sir.
Okay, so. Okay. We don't have any say one way or the other on it.
No, sir, the federal regulation lays out the requirements for level of PFAS within water. And so we are required to follow the EPA guidance.
Further questions, further discussion? What's the pleasure?
Mr. Chairman,
Madam Auditor.
I would move that the board find that emergency rules are necessary for the administration and timely award of funds under the state clean water and drinking water revolving fund programs, and adopt the proposed emergency rules, amending chapters 11 and 16 of the board's rules. And that also the board authorize the Office of State Lands and Investments to begin the regular rulemaking process with the attached draft rules for chapters 11 and 16 of the board's rules.
Thank you, Madam Auditor. Is there support for the auditor's motion?
Second.
It's been seconded by the superintendent. Further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Nays? That motion carries. Madam Director.
Mr. Chairman, that brings us to the D matters, which are the state investment matters, so I would yield to the Treasurer's Office.
Mr. Treasurer.
Chairman. I think we'll start with the introduction of some of our guests. First of all, we have from the IFC in person is Russell Reed. And glad to have you with us, Russell. I think he'll be able to bring a firsthand perspective into some of the issues that we've worked on since the last time we met. And Josh Keevan, I think most of you know, he's her manager from RVK, and of course everybody knows Patrick. And I guess I'll start with if there's any, I guess, thing that you want to say now, Russell, you know, just a brief statement or whatever, that's fine, or you can wait till the subject matter appears in front of you, and you can wait until the subject matter appears in front of you. Russell, good to see you.
Great to see you, Governor. Great to see the entire Slib. Really an honor to be here. I'm Russell Reed. My background is as an institutional investor, which I have been for over 3 decades. It includes serving as a chief investment officer for some large public investment plans. So I was the chief investment officer for the Alaska Permanent Fund in Alaska, as well as the California Public Employees Retirement System, or CalPERS. So I've also spent quite a bit of my time over the last 12 years advising the finance ministries of the GCC countries of the Arabian Peninsula. And serving as the chief investment officer and deputy CEO for the development investor for that Gulf region. Pleasure to be here and working on behalf of the IFC.
Mr. Chairman, we also have from the IFC Sam Masudi and Tom Chapman online. I don't see anybody else up there from the IFC at this time.
Welcome, Sam and Tom. Haven't seen you in a while, either one of you, so good to see you.
Okay, I guess turn it over to Patrick, and we'll go from there, Mr. Chairman.
Mr. Chairman, Mr. Treasurer, thank you. My name is Patrick Fleming. I'm CIO for the Treasurer's Office. In matter D1, we are, I'm bringing forth just an issue that has been growing over the years. And over the last couple of years, I have a growing concern on some of the risks that we have embedded in our portfolio. And so I wanted to bring this matter to the board because I think it's my fiduciary duty and kind of the first line of defense. When I see something that has potentially will have a negative impact on the portfolio, I think it's my duty to bring it to your attention. And so that is really what I'm doing today. I have spoken with numerous economists and China strategists, and across the board, many people believe that the way that Xi Jinping is managing the Chinese economy, there are certain risks that are very difficult to quantify. And so that is really the gist of what I want to bring to you, is that we're having certain issues quantifying those risks. And this is something that I've really never had in my career before, but I just think it's pertinent I bring to the board's attention. This has nothing to do with a political statement or an ESG statement or anything like that. This is purely what our number one mandate is to try and achieve the highest risk-adjusted return. And so with that, when you are not 100% confident on some of the risks, I think that's something that needs to be addressed. So with that, I firmly believe that when you bring an issue above the board, you should also have some type of solution or something that you're looking at. And so just one idea that we're looking at is saying, with our international equity exposure, we have two different structures. We have active management, which is done by two of our managers, Harding Loevner and Arrow Street. And then we have passive investments. And part of that is we invest in passively unless we can find an active manager who we really feel confident in. For instance, in the S&P 500, we don't have active management on that because it's proven that it's very difficult to do that. So that's how we kind of structured it. What we are proposing is we look at in having two definitions within the IPS of the international exposure. So right now, our index is the ACWIX, so All Country World Index ex United States. So that's the international exposure. And what I'm proposing here today is that we would look at adding a second index, which it would be the ACWI US and also ex China. And that would only be used for our passive exposure because what we've seen is our active managers have been able to produce a tremendous amount of alpha, and I'll show you specifically that in the deck. But when we have a harder time understanding the risk, we would prefer not to have passive exposure to something where we don't have certainty or a higher degree of certainty in that exposure. So with that, I'd like to present to you some of the risk-adjusted return, some of the things that we can really quantify that exposure to give you a better idea of what we're talking about. And then Russell is going to talk about the IFC's question and concern. And this was one of the most hotly debated topic amongst the IFC that we've ever had, and rightly so. There's many different views on this. And then finally, Josh will comment on some other options that you have before you to see what the pleasure of the board would be. So with that, I'd like to turn to page 2, which is just to examine basically what we're talking about here with the ACWIX. And so if you look at this, with the ACWIX, 73% on the left side on the lower level, on the lower page there, you see 70% is the developed markets and 27% is emerging markets. And then on the right-hand side, you can see the top 15 different countries that we invest in, and they're marked between developed and emerging. And the top 15 encompasses 85% of our exposure internationally. And if you see the number 3 country, which is China, China is 8.5% of that index, and that's the part that I'm addressing here. So if we could go to page 5, which is kind of the proposal that we're looking at. On the far right-hand side, all we're looking to do is reduce the China risk in our passive investment. And by doing so, one of the things that we always look at is how can we take advantage of a different investment and still get the upside. So one of the things we've already implemented in our real estate portfolio is we're saying, well, we really like Southeastern Asian exposure. But because of rule laws and so forth, there's certain things that we do not want to have China exposure, but we love the China growth story and what they're doing. So we could take advantage of some of that by investing in the peripheral countries. And that's really what this proposal is looking at. By doing so, you can see in the next item, ex-China, where it would increase exposure to certain countries that would take advantage, have a similar type of growth with China. The next thing is the returns. If we did this, how would this impact returns? So if you go to page 6, you can see on the first tab there, the ACWI ex-US index, and it shows the returns over a 1, 3, 5, 7, and 10 year. The next line down would be an ACWI ex-US, ex-China. And on that, you can see those returns, and actually this index has beaten the ACWI X over this time period on over a 1, 3, 5, 7, 10 year. So that's the returns, but what about the risk? By doing so, would we take on a significant amount of more risk? Page 7 is just a rolling sharp. All of these indices that you have are very, very similar. You can't really tell the difference. The next slides, 8, 9, and 10, show 3-year risk return, 5, and also the 10-year risk return. So I'm just focusing on the 3-year, specifically because that's where the bulk of our active managers have actually been involved. Arrow Street and Harding Loevner have only been with us for 3 to 5 years. So if you look at those dots, a triangle is the current ACWI X, and then you go up above, and that the yellow one would be the ACWI X US and China. And so you can see it's slightly higher in volatility, but you get a higher return as well. So it's not like this process, or what I'm proposing here, would be a dramatic cost to doing so. So the next page that I want to show is page 11. And this is really one of the most important things to understand. Why would we be doing this? If the indices are showing this type of return, should we just take China out completely? And what I would say is that's a resounding no. And the reason being is the amount of money that our active managers who have boots on the ground in Asia, they understand the dynamic. They have produced a significant amount of additional income to the state. And over a 3-year period, if you look at both Arrow Street and Harding Loevner, they have produced $290 million additional dollars to the state because of their expertise. If we removed China from the index, it would, one, cost the state more money in fees, but also because of the structure, they would no longer be able to invest in China and also India and Hong Kong. And that would remove a significant amount of alpha and additional money to the state. Now, what about our number one edict again, is the highest risk-adjusted return? Well, if you go back to that page 7, all of these, I'm sorry, page 8 on the 3-year rolling return, all of those dots are indices. We could have put Harding Loevner and Arrow Street on it, but they would have been off this graph. Arrow Street's return on that time was a 20% return with a volatility of 18.2. So the return risk ratio for Arrow Street is a 1.12. The return on the ACWI X is a 0.69. So again, what we're talking about is we are looking for the highest risk-adjusted return, and by keeping active management, we would clearly have a higher return here. So we're fulfilling our number one priority per IPS as mandated by the board, excuse me, to fulfill the highest risk-adjusted return. So the next question is, well, why don't we put all our money with Arrow Street? Well, one, you have a diversification principle, which you have to do. And number 2, they're closed. So ideally, we could find another Arrow Street, but there isn't another Arrow Street. And so what we're doing is looking for other active management. But in the meantime, I'm just saying my proposal would be to potentially reduce that risk and have the potential to go back and forth between those two different indices when we see fit, because we don't have the foresight, we don't have the amount of people to do what AeroStreet, the active management, does. So we're not going to be able to sit there and go, oh, we feel Xi Jinping is going to disallow profitability in the educational system. No one knows that. That's nonsensical to try and forecast that. So what we're saying is we just don't want to have blanket exposure to China when we have two managers who can actually take advantage of that. So, Mr. Chairman, with that, that's kind of the setting the stage of the issue. And I would like to pass it over to Russell Reed to comment on some of the difference of opinions amongst the IFC, unless there's questions.
Thank you, Mr. Fleming, and Russell, good to see you. Of particular interest as you go through this is the H shares in Hong Kong, and I just sort of try to walk through that.
Thank you, Governor, and members of the Slib board. We had a spirited debate among the IFC regarding China, and the key factors that we look at are the impact of unexpected returns and also the impact on risk. We have two countervailing forces that are currently at play. One relates to China being not only 8.5% of our international index, but it's the world's second largest economy and potentially growing into the largest economy in the world. In terms of opportunity set for investment, it is entirely responsible, even expected, that we have to include China as part of our opportunity set. Excluding China would do two things. If we had a blanket exclusion to China, it would materially reduce our opportunity set. We don't generally like that as investors, and it would concentrate our risks. So our starting point is we're not usually very big on restrictions. We'd like the investment team to have all of their all the tools available to them to produce the best risk-adjusted return. The second countervailing force, however, is that we are in a new geopolitical environment. China represents a giant, important trading partner to the U.S., and they're also a geopolitical rival. It is very difficult to gauge what are all of the potential risks involved related to China and their and the relationship with Taiwan. And as such, we also believe that it is entirely prudent to take a hard look at this, at the risk associated with China investment. We believe that the position suggested and recommended by the staff is entirely appropriate, namely that you take you sort of bifurcate the approach to China, which is on a passive basis, that we do not passively have an allocation to China in our international equity investment, but on an active basis for those managers who are on the ground, who see the opportunities and can diminish or exclude China or increase their investment in China subject to opportunities, that is entirely responsible. It is one in which it is fast acting. And as Patrick mentioned, the international equities is the one area where active management has really paid off. This has been true for a protracted period of time. It's very different than with U.S. stocks. With U.S. stocks, if you have a passive allocation to U.S. stocks, that can be a very, very competitive, not only benchmark, but a competitive strategy. It can be very difficult to outperform U.S. stocks. International stocks are different because there are these dislocations, and these dislocations have, there was a 10-year period, I remember, an entire 10-year period where 90% of the active managers outperformed what was the at that point the prevailing international benchmark, which was the IFA index. So 90% of the active managers outperformed the IFA index. And for that 10-year period, it was the key there was underweighting Japan. There was a underweighting Japan was your ticket to outperforming IFA on a systematic basis. So these dislocations, these inefficiencies prevail in international markets much more than they do in the US market. And so we are fans of this dual process where for risk reasons, we would exclude China from passive allocations, but for active management that we include the full MSCI ACWI index, ex-US. By the way, the MSCI ACWI index is an important index. It's the reference point for over $16 trillion of passive and active management used globally. So it is actually the most important global benchmark that we have. So this is, from our perspective, entirely appropriate. It was a spirited debate, and I invite my IFC members, fellow IFC members, Tom and Sam, to comment further. But the idea was, we want to maintain the ability to add value and recognize also in a prudent way what the risks are associated with the new geopolitical environment.
Mr. Secretary.
Thank you, Mr. Chairman. I got a couple questions here. I mean, for one, I'm just not understanding. You have $80 trillion of economic activity outside of China. How we could not maintain a diversified portfolio without having that exposure. I mean, I think it's more than possible, and so I guess, is it possible, is my question, to have a diversified portfolio with $80 trillion of other economic activity? I mean, to me, it seems basic. I mean, but maybe there's disagreement. Thank you.
I think there's a good point on diversification. You can have a diversified portfolio in general, even with fewer countries. The opportunity set is different. The opportunity set associated with a growing economy, sort of like with the emerging markets in general, and there's an important point here. The lesson in the post-World War II era from 1945 to the year 2000 was, frankly, you should omit the emerging markets. In that 55-year period, the emerging markets grew more slowly than the industrialized world, than the developed markets. So the emerging markets were both sort of slower growing, not providing a great opportunity set, and risk increasing. Since the year 2000, we've seen something very different. Now, the opportunity set from the emerging markets has been important. And so I would say that if you looked at the balance of the two, the opportunity set associated with active management allocation to China is a big deal. It's a big deal if we want to take advantage of that. The way to take advantage of that is through active management. So I sort of think your point is a very good one on do we have a diversified portfolio with or without China? I think we probably have that. Do we have in a passive way? Do we, by eliminating China from the passive benchmark, do we materially reduce a risk that we unintendedly expose ourselves to China? That's the part I think that we kind of like. That is that if we're going to make a mistake regarding China, it's done in an active way, and that our managers have proven themselves to be pretty good at assessing what the risk and return profile is of specific investments in China, like the A shares, for instance, associated with the Hong Kong market.
Mr. Secretary.
I have a follow-up there. I mean, I guess, I think we need to, certainly glad we've got a consensus on removing ourselves from passive investment. I think we need to get a T to green strategy on, completely removing, including the active investment, but from China. I guess, my question is, I mean, I think there's a pecuniary interest here, which is that in the event of some sort of conflict, whether it's an active conflict, meaning things are being fired, or an inactive conflict, meaning you have a geopolitical sort of soft conflict, there's the potential for And it's been done, as Mr. Fleming talked about, for somebody to be detained, for profits to be changed. I mean, basically, you have a totalitarian situation where there's no guarantee of what's going to happen. And my question is, how is an investment, you talk about active investment, how is an investment manager going to be able to evaluate whether Xi Jinping is going to detain somebody or require some donations from X company that's going to take away their margins, meaning we don't get the return that we invested in? I mean, how are they qualified to do that? I think that the clear pecuniary interest here is for a complete divestiture, because I don't think there's any way for anybody to evaluate that situation. That's my question. Thank you.
So an advantage we have on the active side versus the passive. The passive side, you have exposure to everything, to everything in China. And the active side, it's different still. It's stock by stock. It's situation by situation. And China it just has a big footprint. I think we're coming off of a period where the majority of profits from General Motors had come from China. It is absolutely an integrated part of the world economy. But the geopolitical realities that we face do call for a different approach. And this is where the being able to have active managers evaluate situations stock by stock is from our standpoint a very good idea. But you're right. You wouldn't want to passively fall into the situation, given the geopolitical risks that you're exposed to something that we don't take a hard look at. And the managers themselves, would have a China team. They would have a China team, and it relates to investments in Taiwan, in Hong Kong. It's a complicated, but as it turns out, kind of important part of the overall international investment picture. So it is a new environment. It's a new environment, and so I think your concerns are very good ones.
Mr. Chairman.
Mr. Fleming.
Yes, as a follow-up, Mr. Chairman, Secretary, the other thing to realize is Chinese equities, as Russell mentioned, it's not, one size fit all or whatever. There's many, many companies that do the majority of their business overseas. So historically, just what we've seen over the last couple of years, the big issues that President Xi Jinping has had is when the majority of the profit is coming from internally in China, whether it was the educational system, whether it was Tencent, Alibaba, et cetera. But so far, at least, he hasn't shown any inclination to restrict any of the profits coming from overseas. So when you look at these companies, a significant amount of the profits are born overseas. And that's really what Russell's pointing out to, is the opportunity set for some of these companies are phenomenal. And by having this active management, they're able to discern the difference. And, does anyone have a crystal ball? Absolutely not. But still, what we're looking at is by restricting that investment, I can quantifiably show that over the last 3 years, we would have lost $289 million in additional income. And so that's from, I'm not making a statement whatsoever, but I'm saying as my job is to look for the highest risk-adjusted return, and as the statement in our APS, which is promulgated by the board, that is what our job is. And so that is what I'm trying to do.
Please.
Thank you, Mr. Chairman. I do want to clarify. I think that 289 million, I mean, you don't know, because it's a hypothetical, what the opportunity cost was, where that capital would have been distributed if it were not in China. So, I mean, for all we know, it could have been a higher return in another location. I mean, you don't know, because there's a hypothetical opportunity cost there. But I understand your point that it's comparing it to itself, but you can't test the hypothetical.
Mr. Chairman, Secretary, actually you can, because I can get those numbers, but they have attribution from all of their bets. And so we can get that number for you. But according to them, it would be a significant loss, because not only do we lose China with Aerostreet, but we would also lose India and also Hong Kong, which are, India, as you know, is the largest populated economy in the world and growing rapidly. And it's extremely difficult to get in. You have to have these different structures, which I can get into in detail later if you want. But it's just not one entity. The structure that we have, we would lose that. And so it's more kind of multi-layered than just China in or out. But they do make a significant amount of money out of China.
Mr. Secretary, and I appreciate the point you're making is that we should totally divest from China. I realize this could be a very long conversation, and it sounds like the IFC had a very robust conversation about it. So
Yeah, well, I just wanted to
mindful of
ask one
time.
more. I mean, I understand it's a process, and, you know, the passive is certainly a step in the right direction. Happy there's consensus on that. I guess, how do you create, I mean, thinking about the active and how we move forward here in the next year, I mean, how do we create an environment where we can just segregate China and can be able to do some of that Indian situation, whatever, and where we don't have this argument that that's affecting other emerging markets? How do we create that market? Because I'm sure there's a way to do it.
Mr. Chairman, Secretary, 2 years ago, the IFC met to increase the China exposure. We wanted, saying this is the fastest growing economy, should we actually have China as a separate entity and increase that allocation? How can we not be involved? So this is a growing, I mean, it changes year by year. So that's the other part of it. To be excluded from that, I would say would be problematic from that sense. So there's a tremendous opportunity set, but the world changes day by day, week by week, month by month. So having a rule set in stone at any one time is very problematic. And as Russell mentioned, you know, having that flexibility is paramount. That is what we're focusing on, is that flexibility. So I would say to have a rule on that would be problematic from a risk-adjusted return and trying to maximize the returns.
Mr. Chairman?
And Mr. Treasurer.
Directly to the Secretary's, I guess, question about how does that happen? I'll kind of characterize, a couple of years ago, we sought to be a qualified U.S. investor in the stock markets. It's taken us basically 2 years to get that qualification so we can have different flexibility in different areas. And our last investment meeting, we asked the same question, and essentially it could take up to 5 years to go through, and with no guarantee that the Indian government or the regulators over there would actually approve us. But what we're doing is looking at what steps we have to do to make that happen, put it on the back burner, basically to find out all the different areas that we would have to, and all the hurdles we would have to cross. And but yeah, the first blush about how long it would take, probably around 5+ years to get that independent ability for our state to do that. There's very few people that do it. Some of them have these investment clubs. All of that in different areas is fairly expensive, but we have now a couple of active managers who have gone to all of those problems as far as putting the people in every one of these markets and getting the expertise and the qualifications that essentially, even if we could invest ourselves in India, are we going to get another 15 people to actually go out and do that, or are we going to try to find one embedded manager in India to do that? All of those things are out there, but it takes time and money, and then we look at it in the whole as far as, does this give us our highest risk-adjusted return, or do we stay with a horse that basically Arrow Street is probably won the Triple Crown in the last 6 years, back to back to back to back when it comes to investing.
Thank you, Mr. Treasurer. Is there other questions? I have a couple, if not. Do we have one online? Oh, Tom, Mr. Chapman. Tom, good to see you.
Thank you, Mr. Chair. Can everybody hear me?
Yeah, we can now.
You can, great. Okay, thank you very much. Thank you, Mr. Chair and members of the committee. Again, I'm in a really remote place, so I don't know how long my Wi-Fi is going to hold out. But I guess just really quick, what I'd like to do is sort of dovetail a bit of the comments from Russell and Patrick from the meeting, at least representing a few of us that were, I guess, maybe on the other side of this discussion. This is really an issue, frankly, about execution, not so much necessarily about a decision on investing in China. The issue that we have with doing this, of changing a benchmark, is effectively we're trading one tracking error for another tracking error. And what we're doing is by stripping out China, we are then looking different amongst our peers, amongst different indices, et cetera. And we're concerned about that execution process. We also feel that this is, if it's a decision strategically on not investing in China, which would be through you all, through the Slib board, or from a tactical side through staff, then that's a different discussion than what really I think we're talking about here. And the other thing about stripping it from a benchmark on the passive side is it is very difficult to get back in, whether you strip out a sector, you strip out a geographic area, et cetera. And when the fact that China makes up, and Patrick, what is it, 200 basis points, less than 200 basis points of our total exposure in our portfolio. It's not really that big to try to make what we think is a pretty large change in terms when we look at our benchmark. And then the last thing, I'm sure you all read that Ontario Teachers has actually stripped out their direct private investments for ESG reasons. So a bunch of the Canadian pensions are actually doing it because of ESG. And so I do get a little concerned about the political look of trying to do something like this when really, to me, this is more of a strategic or tactical decision, not necessarily so much, again, on whether or not investing in China. And I would say the group does one thing I think Russell said, which is totally true for the IFC, that everybody agrees that if you are going to try to invest in China, then you really should invest actively, as you should with most emerging markets. You want to go with active managers. So we are all in agreement with that. So I'll wrap up there, Mr. Chair. There's just some quick comments from the quote, the other view.
Thank you, Tom. Mr. Treasurer.
Yeah, follow up, Tom. I tried to find out, I guess, the other day when we met, whether you were pro China as far as being it's something we should stay in. I kind of gather from your comments that it's so small it doesn't make any difference. But I'd like to have a clarification, if you could offer it, about whether or not you think investing in China is a good risk-adjusted return, or should we avoid it like the plague? It's an uninvestable market, or is there a middle ground? Sure
thing, Mr. Chair. Thank you, Mr. Treasurer. I don't think it's necessarily appropriate to kind of get into that, particularly because I think as a group, as the IFC, we should be probably having that discussion, but I think the one thing that what we can do in terms of, I think, being a constructive sort of, moving forward, is that I think we all agree about using active managers. There's no question that active management in emerging markets makes the most sense by far. And the one thing I think in our working session a month or two ago, we did discuss with China. China has been certainly way down relative to other equity markets for a lot of the reasons that Patrick mentioned. And the sentiment about China is obviously extremely bad. And so there is a bit of a question about, if you do have existing investments, is it the right time necessarily to be exiting from it with existing ones? And so I just would say, Mr. Treasurer, that this is something that I think the IFC, if the board and the staff, want the IFC's input, then this is something that clearly I think the IFC should meet and have a really good, thorough discussion on.
Thank you, Mr. Chapman. Mr. Treasurer, any follow-up on that?
No, I was hoping that we had that thorough discussion here a month or two ago, but as both I think Tom and Russell said, is that we had a lot of discussion and much like today with lots of different viewpoints.
And it strikes me, I guess this goes to my question, and Russell, when I talked about the Hong Kong shares, it also feels to me that being ex-China completely is an incredibly difficult task, considering they own so many ports worldwide, including Long Beach, considering the fact that they have so much of a reach into so many developing economies, et cetera, et cetera. I think and Mr. Treasurer, much like you, I think at that working session, I asked if the IFC could really robustly discuss this, and it sounds like you did, and didn't come to I guess, a clear, sort of sense. And I would put forward that the recommendation that's been made, I think, makes a lot of sense because you are divesting in the passive sector, to the good secretary's point, but you're allowing active participation in the second largest economy. And it was interesting to me, I was recently with a number of CEOs, and Nike was talking about the complexity of dealing in China, both from a business perspective and from just an operational perspective. And it's an experience. Before I went to work for Apache Corporation, Apache also had operations in China, and I think for some time, operationally in China, it has been problematic, to say the least. So I think having an astute, active manager allows us to be able to get it may be marginal by overall standards, but it's still $270 million, real dollars, for Wyoming, and really important dollars that can fund specific programs, keep taxes low, et cetera. So I would say, Mr. Treasurer, I think your IFC actually came up with a pretty good recommendation.
Yeah, Mr. Chairman, I think one thing, as Tom and Russell and I think all the IFC members would say, is that, yeah, if you're going to be in China, active is really the way to do it, and emerging markets in general. So that's what the recommendation embraces.
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Chairman. Well, I would just like to applaud the efforts of looking at this. I spent several years living in China over a decade ago and lived through firsthand some of the atrocities that we see there, and worked for an international trade company as well. And it's a very different world from then. And so I applaud this effort in looking at, how we make sure that we have that risk-adjusted return. I think we're really talking about, two different things here, and I don't think we're going to be able to tackle them both today. And so I think, focusing on the progress that we've made through this plan is appropriate. And really, moving completely into active investment in China is appropriate. I am absolutely willing to have that discussion of how we completely eliminate China. I think today we don't have the information to quantify that and to know what that does to change our investment policy, as well as the impact to our taxpayers. And so I think this is an excellent start, and I think really the focus of today. And I just appreciate all the work that you've done.
Thank you, Madam Superintendent. Sam, I see you have your hand up. CIO Masudi.
Thank you, Governor, Mr. Chairman. So a couple of comments. So as was noted, the China exposure is about 1.6% of the portfolio. And so
you're fading a little bit. Can you get closer?
Yeah, so I've got some background noise. Can you hear me okay?
Yeah.
Okay,
if you speak up a little bit, it would be helpful.
Okay, sure. So this would be cutting the China exposure by 0.8%, so relatively small move. And Mr. Governor, as you were mentioning we're always going to have China exposure throughout the portfolio just because they're global companies. So for instance, if the portfolio was just invested in US stocks, if you look at the revenue of the S&P 500, about 7.2% is from China. And if you look at European stocks, it's pretty similar. It's about 7.8% from China. So we'll never be able to remove all of the China exposure from the portfolio. And I think that this issue, there are two issues here. One is how much to invest in China, and the second is what to do with the benchmark. And I think I'm not going to disagree with underweighting China. I think that's a tactical decision. But I think if the board wanted to make the decision to underweight China, I think it would make a lot of sense to change the benchmark to reflect that. If it's a staff-driven decision, my recommendation would be not to change the benchmark. And it's partially because to the extent that the investment office, the Treasury is correct about that, if the benchmark isn't changed, they'll benefit. And that'll be reflected in their performance relative to benchmark.
Thank you, Sam. Madam Auditor, I see you have a question.
Mr. Chairman, I think, again, I appreciate the IFC's work and sort of the complexity of the conversation and recognizing that there's a wide variety of opinions on the IFC. But I didn't get the impression that there was anybody on the IFC who was in the camp of divest everything immediately today. Is that the spectrum was, yes, get rid of all your passive, potentially underweight active, which is what folks are already doing, up to don't do anything. Is my understanding of the spectrum amongst the IFC, knowing there wasn't a consensus, is that fairly accurate?
That is exactly correct,
Okay.
Madam Auditor. And also involving the benchmarks. Should there be a benchmark change for at least part of the international equities index to include, perhaps a shift toward maybe half, which includes China, reflecting the active management, and half that doesn't include China.
And Mr. Chairman, a follow-up, please?
Please, Madam Auditor.
I think my other question is, I know Patrick and team went to a lot of trouble and pain to get into these active managers, and I think that those predate some of the new members on the board. And recognizing the good job that they do and knowing that they are all underweighting in China right now, I don't know if it would be appropriate in the future for us to, we see them when we first interview them and grill them and they come here in person. I don't know if that could offer us some additional comfort or situational awareness to have an update from them once in a while, and maybe that's not appropriate, but I wonder if it wouldn't be helpful to talk to Arrow Street and sort of if we could get some comfort on the level. I certainly don't understand the level of involvement. I believe they have people on the ground in China they're spending millions of dollars figuring this out, which we can't do. So just a thought maybe for the future.
Thank you, Madam Auditor. Mr. Secretary.
Thank you, Mr. Chairman. I think it is good that we have what appears to be somewhat of a consensus on the pecuniary interests of us removing ourselves passively. On the active side, though, I want to emphasize that I think this whole thing about how we have to interact with China to do anything in India or go down the list, I think that is increases our risk. When we don't have the direct access to those markets. So I think it is very important, getting the Treasurer's comments earlier, that we unwind that aspect of the active investing in terms of the interaction that we have to have with China to do anything in India, to do anything in any other market, go down the list in that area. I think that increases our risk and is problematic. So thank you.
Thank you, Mr. Secretary.
Mr. Chairman, I do have one practical. In the IPS, Mr. Fleming I'm a little bit unclear. Do we need to, on page 26, in the third column, that's where we remove ourselves formally from passive investment, correct? So that amended language, do we need to move that amended language, or is that the proposal you're bringing us?
And this is a little bit out of order, but
Okay.
we'll come to that next.
All right, thanks.
So. Yeah.
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Chairman. One follow-up question. So the actively managed exposure, just so I understand correctly, they have been underweighting China historically. Is that correct?
From the most recent data that I have is that they've traditionally been underweight China, and that has been part of their attribution and being able to produce that alpha is having that underweight and the stock picking. Whether it's the entire time, I don't have that data. I can get that for you.
I would sort of clarify that China has been a significant factor for producing alpha. The alpha generation has been generally for underweighting over the last few years, but overweighting in the years before that. So China was a big growth engine. So it hasn't been that systematically underweighting China has been the path to success. There was a long protracted period of time where taking China seriously and leaning into it was indeed value added. That has changed tactically over the last few years for those managers.
And Russell, it's interesting. I've been, unfortunately, in this board for a long, long time. And I can remember back under Obama when we were trying to close coal plants. And ESG was just sort of on the horizon. And you mentioned you were at CalPERS, and I remember CalPERS was a big proponent of all that stuff. And, the World Bank, for example, was going to stop investing in anything to do with fossil fuels. And at the time, Xi Jinping was singing a very different tune. He's gotten much more bellicose of late. But at the time, there was the if I remember correct, Asian Infrastructure Investment Bank, which was sort of purporting to be an alternative to the World Bank. I can remember talking about, would that have been an opportunity for Wyoming coal plants to be able to get the funding that they were being denied elsewhere? So China has changed dramatically. And we know that China is doing a lot of investing in new coal plants and a lot of fossil fuels. What was interesting to me in talking with some of these CEOs was that there is a changing attitude amongst companies. And to the good secretary's point about unwinding, it appears to me that a number of multinational companies are beginning to say we need to firewall ourselves against China. So there's a process here. And I think my point comes to what we're doing here perhaps helps encourage that. And I just wanted your opinion on that.
I think it's an excellent point. The way we view it, I believe, is that the sensitivity to China is going to be sector by sector. China it will remain likely a very important trading partner to the U.S. So the sector by sector view is going to be the right one. And if you look at fossil fuels, we're going to have one set of policies. And even there, it's multifaceted. In Alaska, for instance, which shares a number of commonalities regarding natural resources policy with Wyoming. If we produced significant natural gas from the North Slope of Alaska, likely recipient of that buyer or that over the next 100 years would be China, also Japan, Korea. So we look at China sector by sector. It is both a trading partner. We act cooperatively and we act competitively with it.
Thanks. Further discussion?
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Chairman. Well, I think that there's been great discussion today, overall on both of these topics and really appreciate that. I look forward and hopefully, you are all willing to have those discussions offline of how we do, what the implications are to the taxpayers of Wyoming if we fully decoupled versus not and moving forward. I only got my business degree from the University of Wyoming, so I'm not an expert in this. And so really appreciate those conversations and hope that we can continue to have them. Thank you, Mr. Chairman.
Thank you, Madam Superintendent. Further discussion?
Mr. Chair, can I make one final comment?
Yes, Tom, please go ahead.
Yeah, thank you very much. And Madam Superintendent, I actually look forward to having those China discussions with you. I've spent lots of time over there, so I'll definitely give you a call. But I guess one thing, Mr. Chair, I just wanted to make sure that was clear. At least, the majority of the IFC, again, is in favor of the active management component into China and think that's very appropriate. We're not very happy with the necessarily of changing the benchmark, but I think adding to Sam's point on if it is going to be a strategic change from the Slib board about China, then it could be, then it would make sense to do it. But if it's more of an investment decision, sort of driven from staff, then I think that the majority of the IFC, doesn't like the changing of the benchmark. So again, the thesis we all agree with. It's just the question of, how do we do it?
Thanks.
Sure, thank you.
So, Mr. Fleming, that was mostly an informational message, I think. Is that correct?
Mr. Chairman, that is correct.
Mr. Treasurer.
Yeah, Josh now that can go over the IPS.
Okay. Mr. Keevan.
Or was it performance or IPS first? You got to look at mine.
Thank you, Mr. Chairman, members of the board. Josh Keevan, Principal and Senior Consultant with RVK. As it relates to the IPS and the China issue in particular, you may have noticed we left some question marks in the policy because we knew this conversation would be in front of it. We did lay out on page 12 of the presentation you've been reviewing what we see as a range of policy options you could consider. We do think it makes sense to separate policy from implementation. It gets easy to start mixing the two in the discussion, but really the policy decision should be most appropriately kind of the first level of discussion, and then implementation follows whatever you determine is in your investment policy. The options we laid out here, one would reflect no changes. No changes to your policy would mean the benchmark stays the same, which would mean that if your staff did decide to underweight China, that decision would just show up as a difference in the performance relative to the benchmark. They don't actually have the tools to do that today because this board approves the investment managers, and you don't have investment managers that are just China that would allow you to reduce that. It doesn't mean that couldn't be built somehow in the future. The second is the recommendation from the Treasurer's Office to change the asset class level benchmark. And as a board, that's really kind of one of the most clear ways you have to express this view in policy is the asset class level benchmark. And what I mean by that, it's the benchmark for the asset class that in your policy is called non-US equities. Basically, stocks that are outside of the US. Currently, it's the all-country world, ex-US, which, as we just discussed, includes China. The proposal is to move to a 50-50 blend of that benchmark and a version of that benchmark that also excludes China. That effectively moves your policy target into China from about 8% down to about 4% for that portion of your policy. Or you could choose a different blend of the two. There's probably nothing magic about 50-50, but it does line up with about your active passive split today. The third would be more of a restrictive statement in the policy, and 2 and 3 really actually could be thought of together if you wanted to actually state in policy a restriction that you don't want to have passive exposure to Chinese equities. And this would, I think this has been well spoken to, but to the point of the A shares and why this is becoming a bigger deal than it has been in the past. You've got the A shares are the locally traded shares, whereas the H shares are the Hong Kong traded shares. And those A shares historically have been restricted and not available to foreign investors outside of China. The major index companies, MSCI included, have been going through a process as those markets have been opening up to include those in the index. Currently, 20% of the A shares are included in the index. If nothing else is changed, and as that gets stepped up to 100%, China would actually increase in the emerging markets index from roughly 30-ish% to about 42%. So it's going to be a growing part of the benchmark, most likely, which is relevant to this discussion. So we just wanted to sort of highlight for you our perspective and really sort of a range of options that you could consider. But I believe the proposal that's in front of you would be number 2, which is the changing the asset class level benchmark to 50/50.
Mr. Chairman. Yes, the treasurer in conversations is saying instead of having a split 50/50, I believe his proposal, which he will comment on, is just saying that active would be in the ACWX and passive would be the ACWXX instead of, delineating a percentage. So just a clarification.
Yeah, Mr. Chairman, that's what we basically do. We just add in the ACWI ex-US, ex-China. And so that allows us to do the passive in that particular index, and funds would flow out of the ACWI ex-US. And to the extent that we still have Arrow Street and Harding Loebner that invest actively within that ACWI ex-US construct, that we would allow them to continue to do what they're doing, and then allow our regular index to continue the way that there's I can't remember, Patrick, which manager that's going to run. I think that's Harding Loebner. They're going to run the XX. Is that right?
Mr. Chairman, Mr. Treasurer, our passive manager is Northern Trust.
Northern Trust. Okay.
Yes.
All right. Yeah.
And by moving that index, it would be a 1 basis point increase in fee is all.
Yeah. So we've looked at where we're at, try to keep it as simple in-house as far as making sure that we can facilitate pulling out of China to that extent with the managers that we have. And I think to the point that several people have made is that we don't necessarily have the managers to do a lot of these things at a snap of the fingers, and that we have to develop that capacity. And so we're going to be looking for another international manager, and we'll see what comes out there. And to the extent that the secretary was talking about giving the flexibility in these other areas, the thing is that we have to find out whether or not there's managers that can actually move the needle out there in India and other areas. And those things will be things that we're going to endeavor to discover over the course of the next year or so, to see what flexibilities that we have. And then, we'll probably set up a lot of that capacity, but necessarily not offer a suggestion to the board that things change until we can actually see that we're going to get a gain in our risk-adjusted return. So we're not going to do it just for the sake of doing it, but we're going to make sure that we have the capacity to do those other things in the future, but make sure that it's, everything we do, again, it comes right back to the highest risk adjusted return.
Thank you, Mr. Treasurer. Very good. So that would then constitute, please go ahead, Josh.
Mr. Chairman, did you, maybe just a point of clarification, as a board, did you want to come to a conclusion on the China issue first, or do you want to contemplate that as part of the broader review of the investment policy edits?
If we've spent a lot of time on China, so how would the board like to proceed? Mr. Treasurer, it really is your
Yeah,
matter.
I'll make a motion, Mr. Chairman, that I move for the broad international equity benchmark, the addition of a passive management benchmark index, which is the MSCI ACWI ex-US ex-China index.
Okay, is there support for the treasurer's motion? Been seconded either by the secretary or by the superintendent? Mr. Secretary, I'll give it to you. Discussion item, I forgot to ask this, is there going to be impact to any of the incentive comp related to this?
Mr. Chairman, not to my knowledge how that would impact, because it's all active or passive investment.
Yeah.
So
okay.
the passive, they're just replicating the benchmark. Josh, if you had any, I couldn't see how that would have any impact. It's just a passive index.
Okay. Very good. All in favor of the motion of the treasurer, seconded by the secretary, signify by saying aye.
Aye.
Are there nays? That motion carries. Thank you.
And Mr. Chairman, I guess the only thing that's, just for informational is that the active investment broad international equity will remain benchmark against the MSCI ex-US. And that's the same managers that we have now.
Right.
Okay.
Okay. Josh.
Thank you, Mr. Chairman. I'll move on to what I believe is item D2 in your board packets, which is the red line edits to the investment policy. And as we always do, we summarize in the memo that precedes the actual policy edits the essential nature and rationale behind each of the edits. And I would group the proposed edits into three primary categories that are driving the edits to the policy. The first is some language around clarifying ESG and its role in your investment decision-making process, and some language related to that, as well as proxy voting that's been proposed by the treasurer. We have some recommended guideline changes for the state agency pool that I believe we've had a chance to discuss with the board. And we've also got the edits to the policy that would effectively accommodate and memorialize the asset allocation adjustments to the targets for the funds, as well as the consolidation of the permanent funds, both the total return and the income-focused funds, into a single endowment asset allocation strategy. So those are the three main categories of change. The first being in section 3.5, the additional ESG language that's been proposed by the treasurer. Section 11.2, you've got the state agency pool guidelines. The state agency pool is effectively the very short-term reserves utilized by a lot of the agencies within the state. And because we understand that some of those agencies legally are not allowed to experience a realized loss, this portfolio has been managed for several years in a very ultra-conservative U.S. Treasury only laddered portfolio strategy. The proposal is actually to keep it still very conservative, but to allow a little bit of additional flexibility so that your staff can start to manage for some incremental returns against a market benchmark. And the specific proposal is that that benchmark is 25% 0 to 1 year treasuries and 75% Bloomberg US government 1 to 3 year government index, which will include both treasuries and agencies. And that there's additionally some allowance that's detailed at the top of page 2 of our memo to invest up to 20% in corporate exposures, but still with a requirement to be 80% in treasuries specifically. And the limits per issuer, which are mostly relevant to the corporate investments, are anything AAA rated can be up to 3% per issuer and can be up to a maturity of 3 years or less. Once you go below that, even into AA, which is still very high quality, and single A, those are restricted to 1% per issuer and maturity of 1 year or less. We have a recommended change to the bank loan index. Currently, you use the S&P bank loan index. S&P has sold that to Morningstar. Morningstar is now trying to monetize that, so there is some incremental cost for that index. There is another index that's actually used by more investors than the S&P and is very similar, in fact, almost identical in terms of composition and performance. That's the Credit Suisse Leveraged Loan Index. And so when we see two things that are essentially the same and one costs more, our preference obviously would be to use the one with the lower cost. So that's just a change to that benchmark. Section 14 has some voting of proxies language that is a companion to the ESG language that's been proposed by the Treasurer's Office. The nominal benchmark returns, Section 20, this is where you would actually capture the benchmark changes for the state agency pool, bank loans, and then also the proposal that you just passed on the non-US equity index, the passive portion of that excluding China. As we move into the sub-policies for funds, this is where you get into the actual asset allocation policies for each of the different funds that this board oversees. And under the long-term permanent funds, this is where we are consolidating those funds and reflecting the policy targets that were discussed in great detail in the joint session with the IFC and the Slib at your May 4th meeting. As well as adjustments to policy targets that were discussed at that meeting for workers' compensation, Pool A, and the state agency pool. So that's the high-level summary of changes. I believe you've all had a chance to review the actual red line edit, so let me stop there and happy to take questions that the board has.
Members of the board, I did want to look at Section 3.5. I think that the Treasurer's work there is remarkable. I have some slight recommendations. I have here recommendations, and I worked on it this morning, Mr. Treasurer, so apologies. Essentially what I'm asking is we modify language in the second paragraph, which I think comports with statute, which would be upon recommendation of the State Treasurer's Office, comma, the board may respond to an investment partner when it is acting in a non-pecuniary manner and the State Treasurer's Office identifies a potential detrimental outcome to the highest risk-adjusted return or loss of the state's revenue in general by communicating these limited to request to change policy, concerns to management, its board, and other responsible individuals. Then insert instead of this, these board actions may include, but are not limited to requests to change policies, voting proxies, to force change and divestment and/or replacement with competitive alternatives. Ultimately, all partners must adhere to the standard of care of being a fiduciary. And I do want to recognize the treasurer's really good work on this. The piece of the legislation is that I think this board has the authority to fire. The treasurer's office has the ability to redeem. So I think this just comports with statutory requirements.
So, yeah, Mr. Chairman, so what was that last statement, that the board has the authority to fire?
The board currently under statute can fire managers. The treasurer's office can redeem. So essentially you can defund, but the firing is the board's responsibility by statute.
At this point in time. So
Yeah.
we're going to hire a manager. So this just keeps it in line with the current statutes as far as hiring a manager. But it also goes on and I think gives the board other powers as far as when to act upon.
I think you would still retain the ability to act. I think essentially if you redeem, you've done everything except fire. And I don't think it is an incursion on your authority to make sure they manage. I mean, your language above talks about the investment policy guidelines. And so if they're acting outside of the bounds of the investment policy, you have every prerogative to do everything.
So are we only talking about the board being able to replacement of competitive alternatives? Is that where you're looking at, or are you going in and saying that it's the board may request change to policies and voting of proxies to force the change, or divestment? Divestment is where we're redeeming.
Yep.
So, but it looks like where you put this in there, that the board is doing all of those plus the replacement with a competitive alternative.
Well, functionally at this point, that has to come to the board anyway, the competitive alternatives.
Right, right. So I agree with that as far as the statutory construct, but I'm not sure if the board wants to get into the oversight of 30 to 35,000 votes annually.
And I think that was the reason for this, was to say that the treasurer's office makes those recommendations. So the treasurer's office can go ahead and do whatever it needs to at this point.
The treasurer's office is going to have to ask for a mother may I on a request to change a policy, the voting of proxies of force change, and divestment.
I think and we can change the divestment, because we could just take that out, because you can redeem at this point anyway. You just defund.
Well, I don't have a problem with changing the mother may I on the replacement of competitive alternatives, because that's the way managers are currently. I think you're getting in the day-to-day management decisions of the treasurer's office when we're trying to request changes or in the voting of the proxies, because it's going to be almost impossible for the board to act in a timely manner when the companies across what we have in our portfolio don't basically vote proxies at the same time the board meets.
And that's true, Mr. Treasurer, but I don't know how many opportunities you have to vote proxies currently. In fact, I think there's policy in here about hiring a manager to do that, and presumably that would be consistent with the IPS that is passed here.
I think the way I envision it is that the proxy manager will, alert the treasurer's office to, some concerns that they have and ask for guidance. And those proxies will come out, I think, probably, I think they have about a 3-month notification, more or less. So, we'll be alerted to that. On some of them, we could ask, the board, but some of them, it would probably be restricted to the point where I'd have to be calling special sessions of the board or asking for special sessions to actually do the day-to-day facilitation of the policy change or voting the proxies. So that seems a little too much into the weeds for the, what the board does. It's kind of like asking us to get into the state Office of State Lands and doing some of their day-to-day activities when once those are done, then they bring them to the board.
Fair enough.
Mr. Chairman,
Madam Auditor.
perhaps a solution in that second sentence, it could just be tweaked to say, board and state treasurer actions may include, but are not limited to XYZ, which would maybe give the leeway to the STO to do everything up to the firing that they do on a day-to-day basis, which is how I would envision this shaking out. But then, of course, allow the board to have a stick as well, I guess.
Yeah.
Which we already do, but that would maybe.
Yeah, and I
encompass
think
both of that.
I think that's reasonable because of the construct of the current statute is to make sure that the manager hiring. So how about something like this that says that, and we go down to there, may respond to that, and then we strike out the and/or replacement of competitive alternatives and add to the end of it after fiduciary, the hiring and firing of proxy managers shall be in the same manner as, and then do the statutory citation.
You could do that. I don't know if it's necessary, Mr. Treasurer. I think if the auditor's language seems to make sense to you, because we are going to talk about hiring and a proxy manager.
Right.
And that proxy manager presumably is going to adhere to the policies in the IPS and the state
Yeah, they
treasurer's
have to.
office.
Yeah, I think that's all right there.
My intent here was just to make really modest changes and not make it complicated.
Yeah,
So-
well, it seemed like you took a lot of the power from the state treasurers and gave it to the board, which, in the manner of hiring and firing.
And I think the auditor's point is really good. If you say the state treasurer's office, did you have to say and/or the board? Or
So the second sentence where it starts, where your recommendation would be these board actions, just tweak that to say board and state treasurer actions may include, but are not limited to. And we don't need, I think we all know sort of where the treasurer would act to try to manage this situation prior to bringing it to the board. I don't think we need to necessarily say, well, the treasurer would request change. It's just saying these two entities, the STO and the board, may take any or all of these actions. You're on notice. That makes sense?
Yeah, because I think if the board comes to the process and says, hey, we don't like what this guy's doing, and so we need to do something, I think that it's perfectly reasonable for you to have that authority to say, yeah, we want to jump on this. The reason I did it more constrictively to just the treasurer's office, so there wasn't as much political input into issues, but basically having the reports so you guys had the knowledge of what was actually going on. Yeah, I think we can live with that language that the auditor brought forward, but I think it'll be a work in progress. But I think ultimately you want to try to have, the authority not split and shared. So you don't have some company going to the board, kind of like we do grazing leases.
Right,
You know?
right. No, I, absolutely.
Yeah.
Absolutely. So,
All right.
Mr. Chair.
Mr. Chairman, Nicholas.
Thank you. I just want to articulate some of the concerns that we talked about in our working group with this particular language. And if you go up back to the first paragraph, you go down to where it defines pecuniary factors, or what pecuniary factors are. And I find the language both confusing and probably contrary to statute, the way that it's currently written. Because, and it does two things. It inserts a political description or of a definition of what pecuniary is. And then it says that defined pecuniary factors are by definition will result in lower returns, increased risk, and less funding available to the state. And I would submit that that is just simply an inaccurate statement. So if you go back to it says pecuniary factors do not include the furtherance of social, political, and ideological interests. Well, there are lots of things that are furtherance of social, political, and ideological purposes, which are not basically pecuniary or non-pecuniary. For example, if you're the manufacturer and you're manufacturing the windmills, that is a social interest because you're advocating for wind power. If you're doing the same for solar panels, then that's a ideological and social interest, in addition to a business that have a higher return than other types of industrial type of manufacturing entities. And yet they're, under this definition, they're non-pecuniary because you can't consider what those purposes are. So to me, that language does not really say what it's meant to say. And then saying that all of that lowers our risk of return, I think that's a political statement. It's not a factual statement. Why would you have a statement like that in your policies? It doesn't make sense to me. And then once again, then you go down and then you apply the ability of the state treasurer's office to take action for those non-pecuniary social or political factors, which may actually be bringing more income into us as opposed to less. And so I understand the purpose of the language, but to me, it doesn't really do what it is crafted to do. My suggestion is that this is premature. It's not, as you would say in the legislature, it's not prime time language. If you just cut it off and took out the definition of pecuniary, then it says you have to comply with statutory and regulatory guidance. Our statutes right now say you have to follow the prudent investor rule, and you have to manage it for the greatest risk-related return, period. And so this doesn't really change that, other than I think it confuses it. It's just bad language. And I know that this was adopted out of the part of the Florida statutes, but it does not fit into ours. And so we're trying to put a round peg in a square hole. So, and I in my discussions with the treasurer, I'd be happy to sit down and work on this language and clear it up. I just don't think it's ready. I think it's more confusing than it is directive, basically. So
Yeah, and Mr. Chairman, and I'll recognize the treasurer here in a second. I know you want to be responsive, but if memory serves, we used to have definitions in the IPS. Those were moved out, and I think they are on the website somewhere. And pecuniary does not really have a definition, so one would recommend a dictionary, just saying it's monetary. And I think the particular issue that Florida was wrestling with is that when you talk about fiduciary, then suddenly you have people saying, well, if we have a warming climate, if we don't do something about that, we're not being proper fiduciaries. But that can come at a huge cost to the returns and consequently the people of Wyoming and the industries that are viable here. So I think this was an effort to sort of compartmentalize that fiduciary note to really mean monetary consequences of a decision. And I understand people can warp that too, but I think that was the reason that pecuniary sort of entered into the discussion. But it is a new term, and it doesn't necessarily mean positive. It can also mean negative, so.
Yeah, Mr. Chairman, I think for the representative to represent that we can't invest in wind towers or can't invest in solar or can't invest in anything that develops energy is probably a misstatement as far as the aspect of if it's the highest risk adjusted return, it's something that we're going to look at, you know. But I think what we're trying to do from this standpoint, and to say without the qualifier of saying that it will result in, I said, most likely result. And so we qualify it. So because there is no absolute in investment, you know, and there's no absolute in your determination on things. But what we can see, I think, just in recent events, that people who have, you know, put other issues in front of the aspects of their core business have resulted into some missteps that caused a great deal of headline risk and a tremendous lot of loss to the shareholders. And so I think that's what we're trying to do, is get ahead of it, because we're looking at, we identify potential detrimental outcomes. And then at that point in time, then we have a conversation and try to relay our concerns about the actions that these folks are actually doing. Now, I know, Representative, that you have this on your I guess, interim topic study, and you want to continue to study it. And I think that's well and appropriate. But I think that that this gets us close enough to where we have a working model that other states have used, that we can go on this. And then during the legislative process, if you want to make the tweaks to put the polish on the apple, so to speak, that's fine. But whatever is implemented, if it's not this, or if it's something that goes through a legislative process, the reason we, for myself, prefer this process is that if we do make a misstep and we see that that it needs to be changed, we can do that on the next meeting of this board. And I don't think, I just don't believe that the legislative process is going to get it 100% right the first time. And will I represent to you that this is 100% right this time? Absolutely not. But I do know that other states have moved down this path, very close to this. And I think that we have taken a lot of the problems that some states are having right now, like Texas and other states, where they were essentially, they'd be taking our salary away from us, and all of my investment salaries and all of my management salaries times 2 or 3, you know, and those things that were just made absolutely no sense at all, and they're having problems. I think this tries to thread the needle, and I think it does a pretty good job of threading the needle. Now, there might be some areas that necessarily that you think are political here. What we're trying to do, as to the governor's point, is that we're trying to put a definition in there that it does some explanation, but it isn't 100% black and white, because we're saying that it's less likely, and we're not saying it's going to occur and we're going to jump through any hoops we can to go nuclear on people. That's not what we're doing. The whole thing revolves around the statute as it is right now, which is the highest risk-adjusted returns. And if it looks like it's going to be detrimental to the highest risk-adjusted returns, we want to have a process that we can respond. And not only for the treasurer's office, but as modified, to have that input from the board where it's necessary.
Thank you, Mr. Treasurer. I do see Representative Stith is on. You came up on my screen. Are you wanting to address the board?
Mr. Chairman, thank you very much. I think this ESG topic is very interesting. It's crucial. I'm struggling with the proposed language myself. I did have a question, actually, perhaps the state treasurer. I see the language was changed to say all individuals, I believe, and I wasn't quite sure if all individuals applied to every outside third-party investment manager, or if that was applied just to the state treasurer and government employees. That's
From the relay that I've got, this was made by my staff attorney, and we had a list there. He was concerned that the list wasn't comprehensive enough. And the question of all individuals basically are all individuals that are represented within the IPS. I think that's the universe that we're talking about. So those would be indeed, all the managers that we deal with, and in any manner.
That's an interesting turn of phrase.
Yeah, I thought it was a little bit too broad, but when you look at it in the perspective, we were trying to capture everybody in the IPS, because our understanding is that all of our managers and everybody that we do business with in investments, they have to adhere to the IPS. And essentially, this is part of the IPS. So we're just I guess restating that. I'm sure it's probably someplace else, but we wanted to make sure that it was clear in this section so people understood and didn't have to read another section. But I'm sure there's one section in here that says that this applies to everybody we do business with, in the more or less in that phraseology.
And Mr. Chairman, if I might, just as a follow-up question to the state treasurer, if this policy is adopted, what's your expectation of how it will change how you interact with your investment managers and investment advisors? What's the real world impact of this from your point of view?
Well, from my point of view, I think that it's going to be, we're going to have more communications in different areas. That it's not going to be combative like it would have been in some of these other reiterations of ESG statements. And I think that what has occurred over the last couple of years has been a kind of a remarkable change in the attitude of a lot of our investment partners, like BlackRock and State Street and other areas, where they have, I guess the ESG effort has kind of given them a, I don't know how exactly I want to say this, but basically evening of the leveling of the playing field, so to speak, more or less, in ESG, anti-ESG, or at least letting people know that they have a reason to make another decision, or to not go full board into some of the ESG protocols that have been widely adapted in the last several years, but to actually take pause and look at the other side and how other people are effective, and such as Wyoming with their energy industry in different areas. But so, and there are legal things that are out there now, antitrust suit on all of the major banks in the country, as far as how they jumped onto the do not fund aspect of a lot of industries, and basically acted in a combined manner. So there's a lot of things that have happened, in this area. I think what we're going to do it to make money for the beneficiaries. that's how we're going to do it, and that's how we're going to approach all of our managers and everybody we deal with. And so we're not going to approach it as a political situation, but, you know, if it's a situation that we deem it's going to be, you know, something that's going to, you know, that we think that might be a problem, we want to talk to them and find out, you know, why they did it, and kind of express our concerns and kind of, you know, take that action from there.
Mr. Treasurer and Representative, I'm aware that individuals is defined in section 3.2A, which kind of holds staff and managers to, it's under the ethics and professionalism section.
I knew it was somewhere. Thanks for finding it, Mark.
Yeah. Well, don't thank me. Thanks, Betsy.
Okay. Thanks, Betsy.
Mr. Chairman.
Madam Auditor, and then Secretary of State.
In response to Representative Stiff's question, which I think is a good one, and I'm always happy to be corrected, but I'll give my opinion. As far as how this will change the way we do business, my knee-jerk reaction is to say very little. This is a permissive section, and recognizing that the language, we could tweak the language for months. It's permissive, but we aren't giving ourselves any authority or creating any process that isn't already available to the treasurer and the board. And I think for the last, I'm going to say 2 to 3 years, through several iterations of this board, these are the things we have been saying in every single one of these meetings already. When every single one of these managers come before us, they're getting, well, are you, what's your thought on extractive industries? We've been hammering this home in every single one of these live meetings where we interview an investment manager for several years. So I don't want to say that this isn't, I'm not trying to say we shouldn't say this or this isn't necessary, but on the day-to-day operation, we are already grilling managers about this. We already have and I'm fully confident that we would divest of a manager if it was operating in a way that we found egregious to the state's best interest. So I'm not sure. I'm sort of the opinion that this is more putting our feelings down in writing and sort of putting folks on notice. But I think in terms of the way this board operates and the treasurer's office operates, I see little to no change.
Thank you, Madam Auditor. Mr. Secretary.
Well, Mr. Chairman, just wanted to respond to, the chairman earlier. I mean, happy to listen to any of his comments on it. I guess my immediate question is, what is the solution that he proposes? I think this is a big problem. I do think we need to address it. And the one thing I think missing here, and I've got an amendment that I'm going to be bringing and proposing in a minute. I think the way the governor did it is actually take his method here where we're going to have it tracked in, but I think there needs to be some reference to environmental, social, or governance investment strategies at least, and maybe even a reference to scores, because it says the furtherance of social, political, or ideological interests. That is a little broader. I mean, we really are addressing the ESG issue. That's the title, environmental, social, and governance. And nowhere is that in the statement. So that's one thing that I do think we need to do. But it's really important. I think this is putting down on paper what the direction we need to be going. And we certainly need to keep getting better on this and addressing it. Thank you.
Thank you, Mr. Secretary. Mr. Treasurer, noting your thoughts, and I think they were absolutely appropriate. And I also think you have done a great job here, both with the language. But, and I'm coming back, and I don't want to belabor this, and I know we're taking a lot of time on this issue, but I think it's appropriate. On that second sentence, which I think the auditor provided great amended language, and thinking about possibility, elections you really never know exactly how elections are going to turn out, although with the secretary's efforts, probably they'll be more accurate, but still, nonetheless, it's a bit of a crapshoot. And I guess my concern is in that language, and I wonder if this makes any sense, is that after care of being a fiduciary, you then add, and in accordance with the policies outlined in this IPS. And my concern there is not for you, but if there is another treasurer that comes along at some point who decides to be rogue and decides to go off in different approaches, the sideboards of the IPS would be valuable. I don't think that precludes you from operating as you would, but if somebody were to come and say, I want to do something with regard to investments, on any particular issue, and that was a particular issue that the treasurer liked, I think this language as it's been amended would allow the treasurer or the office to go off in directions that are not, and I tried to find if it's constrained within that top paragraph, and I think these talk about the actions. Does that make sense to you?
Okay, I think we were trying to cover that well, I think, when we said, well, adhering to the applicable rules of law. And I guess if you wanted to, and law includes regulation, I guess the question would be, does IPS, is that construed as a regulation?
Yeah, and it's our investment policy statement.
Right, and if you wanted to be direct on that, and I guess after rules of law, you would cert including the investment policy statement. So there's no, I guess, to me, there isn't any, I don't see the non-inclusion, but if you wanted to be specific and include it directly, I think that's the place to do it, is that you would say after the rules of law, including the Wyoming State Investment Policy Statement.
My comment goes directly, though, to the actions that the treasurer could take.
Oh, you want to put it down in number 3?
I was putting it down in the bottom on the second paragraph, right? The state treasurer's office, upon recommendation.
Paragraph.
And I was just saying, ultimately, all partners must adhere to the standard of care of being a fiduciary and in accordance with the policies outlined in this IPS.
Yeah, I think that's appropriate. That's a fine place to put that too.
Okay.
'Cause I think it's included in the rule of law, but I think that's specific and it makes it more readable to somebody that doesn't know how to follow back and forth on things.
Yep.
Yeah. that's
Okay.
fine. Okay, did you get that, Matt? Are you getting those?
Does that make sense to you, Matt?
All right. Did you get the auditors also and the other ones? Okay, so get with Matt, he's putting those in there.
Should I email it?
Okay.
All right.
Further discussion? Okay,
Propose. Guess we're going to take them all at one time.
okay.
So as Mr. Chairman, thank you. Want to make clear that this would interact with, I guess, what's becoming the governor's adjusted amendment. So it doesn't change that amendment in terms of who's initiating the action, but there's 3 key pieces of this amendment. The first is in the first paragraph, and ignore the stricken language in the first paragraph above the tracked in language, because that's just what is already happening there. So the first change which has the little vertical line to the left, is the addition of or the furtherance of environmental, social, or governance investment strategies in the first paragraph. Let me give one to the legislative liaison.
Is Russell still here by any chance? He'll be back shortly. Okay.
So I think it's important that we add that definition in, or that kicker in the follow through there, because I think the first clause is kind of vague, and I debated whether to just delete the first part, the furtherance of social, political, or ideological interests, but the point here is about ESG, okay? And this is a strategy about trying to increase these ESG scores, and if you don't include that language, I think it is pretty vague. And so that's the first addition. The second one is in the second paragraph there, changing the may to shall. Obviously, the governor's amendment will potentially adjust who's the subject of that sentence, but it would change it to a shall. And then the third would further conform that second paragraph with the intent of that second amendment. So it would take out this may include but is not limited to and replace it with and taking one or more of the following actions necessary to ensure that all fiduciary decisions made by investment partners are based on pecuniary factors, requesting, changes it from request to requesting, use the gerund form so it works grammatically. Those are the three changes in my amendment, and I think there's nothing there that would be in conflict with what the governor's trying to do. It would interact with that.
Thank you, Mr. Secretary. Just as a point, ESG as a constellation really does stand for a lot of stuff that is counterproductive, and I think you've made that point very well. Environmental investing can be construed to be kind of problematic too. Social investing to ensure social outcomes, be whatever they are, also kind of misguided. The governance one is one that is a little bit of interest to me, in that there are a number of boards of major corporations which are moribund, poor performing, obnoxious, and in fact that is kind of a really fertile area for active managers and activist managers to go in to shore up. In fact, that's private equity. It's to go in and get rid of poor performing boards and bring a fiduciary. And Russell, thank you. What I was trying to do is kind of walk through ESG and really talking about governance as, if those are bad corporate policies, and we're not talking about stuff that has to do with diversity or anything else. We're just talking about poor performing boards that are moribund, boards that are stuck in their ways, that have bylaws that, I can think of one corporation that was proud of the fact that it resisted an activist by saying that, activists had not reached an 80%, which was in the bylaws, to change the management. So they won by 79%. Clearly, there are places here, and to differentiate E&S from the G, or to allow for the G, because that is exactly the place where private equity likes to go. Get into an airline, figure out how to get rid of a bunch of extra weight and so on. I didn't know if you had a particular thought on that, since CalPERS was sort of where all this started. And I know you've been on the other side too at Alaska.
Absolutely. What I like about the discussion and the language, each part of it is it's very consistent with the prudent investor rule, and I have to say, at its best, and where the Council of Institutional Investors and and the International Corporate Governance Network was trying to get to, is that poor governance, governance especially, poor governance is problematic. And it's true among US companies, and it's true internationally. You know, one of the biggest problems we see in Africa is that the governance issues loom very large and makes investing in Africa challenging because of those governance issues. So I think, but very consistently, the language that ESG, to the extent that there are ESG objectives that are different than producing risk-adjusted returns, that's a different matter entirely. So I think with respect to the positive impact of, looking at ESG opportunities as value-added ones, that's entirely fair game. And that's, again, I think consistent with the discussion that I'm hearing among the Slib. So I don't feel like there's an inherent conflict between that objective and the key in the wording, I think, is that the ESG factors need to be that those ESG factors which could compromise the risk-adjusted return character of the portfolio, those should be avoided.
And I guess the only concern, Mr. Secretary, that I have, and I appreciate what your concern here, and it's one that I've fought for a number of years, is that really what we're interested in is the best returns, not a political statement. And I'm not suggesting that that's you're not being political about this, but I am, I guess, wanting to be thoughtful, because ESG can be construed to mean I'm going to put a couple of women and somebody of color on a board, and I've met the ESG requirement. You have added no value, and now you've got people that are investing in you because you've made all these big changes. That's clearly just improper. If, on the other hand, there happens to be somebody who is fantastic and adds to the board, I don't want to be precluded from investing in a company that's just going to be a better company because they've improved the membership of their board. And Mr. Secretary, that's the only concern I have here. Are we going to limit our choices? And as I mentioned before, the other concern I have with some of this, our responsibility is to the taxpayers of Wyoming. And I think we try to invest to the furtherance of the industries that mean something for our state. And that's, what this board has, to the auditor's point, continually tried to emphasize with any investment manager decision. If we get dragged into national political challenges that don't really benefit our state except tangentially, I guess I would much prefer to go to the treasurer's point, is we're just going to invest for the best outcomes. And I do think that's a precarious place to be and takes a certain amount of courage politically, but on the other hand, I think it is the appropriate thing to do.
Thank you, Mr. Chairman. A couple responses to this. I mean, I think the G in ESG, and if you look at some of the proxy statements they put out there, the motions that they brought to the shareholders, it's along the lines of what you said later on in your comments. It's not about like removing some corrupt board member that, is trying to take advantage of a nation in Africa. It's trying to, usually these take the form of trying to put people on the boards that are of some woke category that the groups think they view as important. And that's usually what the motions are. And that's been the form of what they've tried to do in these votes before shareholders. And that's what I think this is referring to. And I think ultimately, this gets to the comment earlier about putting something down on paper. I mean, the discretion is still there. And even if changing the may to a shall, it can even be just asking them to change their policies. I mean, that discretion is still there. But if you don't have any reference to ESG other than in the title, in the body of it, I got to ask here, is this just window dressing? Or are we trying to actually take on ESG? And I think you got to have a reference in it somewhere in the statement. I really do, to either scores or strategies. I think strategies is a little bit, an ESG score driven by that. I went with strategies over scores, but that's my opinion on this. And I understand what you're saying, and getting this right in terms of the language is always a process. But I would say that the G in governance has not been about, the way it's played out is not trying to, remove corruption. It's about this sort of woke social goals that we see around our country, unfortunately. And that's what they've been bringing. So that's what I'm trying to get to at this amendment.
And I would agree with you, so.
Mr. Chairman?
Mr. Treasurer.
And I guess I'll kind of comment about why it's only 3 words. And basically because I did go down the same road, I think that the secretary is going down now with some different descriptors in there about, some of the, I think I even put in woke in my descriptors, but I basically looked at it and I said, and the discussion was around, okay, do we put in a list, or do we look at areas that aren't particular descriptive but are broad enough categories that you can, that they give you the flexibility to walk through doors necessarily, but you walk through the doors, but it's always tied back to the highest risk adjusted return. So if I look at the aspect here of governance, you can say those governance things are, if they're a woke ideology, by trying to check all of the boxes in the spectrum of our society, has to be on your board, no matter whether they add any value or not to the board in its ability to perform their product or service. Then I think you could say that could fall in any of those social, political, or ideological aspect of governance. And so that's kind of where we were looking at there in that regard. But it all goes back to whether or not this for their product was something that actually added value or added the ability for decision making at the board level. And I guess going to Representatives Nicholas's concerns, that it all ties back, all these things tie back to whether or not the state can make money on it. It's not necessarily whether you have a huge, solar or windmill project in the lower part of the state, and it displaces something else in our economy. You're still making money for the state in that regard. So it's like but it all comes back to, what that stock is doing at the end of the day. So we tried to make it less, not more, because making it more might actually mean we're making it less. I know we don't have to have social in your deal there because it's above, so you don't have to put that one in there. Environmentally, I think there's a lot of these people are almost, it's almost another religion to them when you look at environmental aspects of what's going on.
Yeah. Well, Mr. Fleming, and we've been hard at it for a few hours and
Great conversation, Pat. Bring her down.
And unfortunately, we still have a big agenda, so.
Yeah.
Mr. Chairman, just one quick comment. If you do adopt Secretary Gray's comments on the scores, I'd just be careful on who's the arbiter of those scores, because I've seen instances where a certain entity has received a low score just because of a failure. They were redeeming one manager, and so they excluded it, and they said, well, you didn't answer all the questions, so we're giving you a failing grade. So there's so many different firms out there. I just make sure that there would be some type of criteria on who we're looking at in a score. I just want to make that
Yeah,
comment.
and,
Thank you.
and it's also encouraging to me that you see companies like Vanguard that are basically abandoning this ESG standard, and the funds have not done particularly well, so it may resolve in and of itself. But
Thank you, Mr. Chairman. Just wanted to clarify, in the amendment, I know I didn't have a copy for you. We went with strategies, not scores. But my concern is, if we don't put that qualifier on there, then, what we're trying to get at, right, is the attack on let's get down to brass tacks. We're trying to get on the attack on our extractive industries, the wokeism. Those are the two big things that is not driven by a pecuniary interest. But on the other hand, we're not saying we can't invest in a coal mine, we can't invest in oil and gas. That's not what we're saying there. And ESG is in the first box, certainly not in the second. I'm afraid if you don't have that qualifier there, it's too vague. I mean, that's my concern there. And that ESG, that's what we're trying to get at here.
Okay. I have a request from a couple of members to take a pause. So hopefully that pause doesn't allow them to refresh with lots more conversation on this. We need to get to a resolution and move on to the other pieces. Thank you. We'll take a 10-minute pause. Thanks. Chair, or Madam Director, sorry, recognizing the lateness of the day, and I see the auditors here, I'm going to call us back. We have before us the matter of ESG. I think we have taken about an hour and a half to discuss this one provision of the IPS. So my recommendation is if we cannot come to a fairly efficient set of language here, noting that we have changed the IPS periodically, not on a regular basis, and there's nothing that doesn't allow us to do this, that if we aren't able to come to a coherent statement that we believe does the best thing for the state of Wyoming, that we pause and allow for drafts to be circulated beforehand. But I know we've done a significant amount of work here. I just don't want to get into drafting from up here because I think that's problematic. That was one reason, Mr. Treasurer, why I thought your language was so good and strong. And I know mine was sort of coming out of the blue, but I really did try to just modify it. The Secretary's language adds to that, and that may be valuable, but I guess my point is I don't want to belabor this if that's okay with you, and I don't think it's going to change, and I'm not saying we don't continue, but my point is I don't think effectively this provision going in or not being completely drafted at this point is going to affect the way your office invests per se. This is much more of a statement for the world about the way we feel in Wyoming investments ought to be handled. Is that?
I guess the only thing I'd request is that we do approve the proxy part of this, because that takes time to go ahead and do an RFP and get the managers up. And that'll probably take about the time between now and our next meeting that we can work on the language. And I guess I would say to the legislators in the room and Bob, whoever else, that as we're working on this, if you have a polishing statement to want to polish the apple or make it more precise or more, please, during that process, come forward. But as long as we have the proxy thing in there and we can get a B11 for your office to pay for it through the rest of the funds that we have, which I think we figured it would be not over 150,000 and probably somewhere between 50 and 100, get that rolling, get that ball rolling.
Sure.
And we can catch up on the ESG part of it.
And Mr. Treasurer, I think that makes a lot of sense. I think devote just a little bit more time to this. If we can't resolve it, let's move on, get the proxy piece done. Whatever other IPS pieces we have to do here, these are always works in progress. Just one caveat, and that is, I know you and I both have been in that office and are jealous of making sure that we don't see encroachment from the separations of state. And I just want to make sure that, with all due respect to my good friends in the legislature,
Yes.
there is a separation of powers issue here, so.
Yeah, and I'm saying that they make recommendations, I didn't say amend it. Okay.
So, thanks. Well, so we have, we left off at the break with some language suggested by the good Secretary of State.
I think he has a modification there, Mr. Chairman, if you'd want to listen to it.
Okay.
Mr. Chairman, I was going to move these separately because I think there's two concepts in this amendment. Just for ease, I put them on one piece of paper, but do you want me to move the amendment at this time?
Well, I think we're still sort of working language, so I think.
Well, I think where we're at is that the first paragraph change would read, Pecuniary factors do not include the furtherance of environmental, social, governance, political, or ideological interests or strategies, period. So we're basically still keeping it as one long list, but we're adding in environmental and we're adding in governance as the third item, environmental as the first. So we get that ESG in there in order, which I think is a good clarity point. And then we're adding in interests or strategies. I mean, or strategies after interests. I mean, I don't mind decoupling them if people, but the treasurer kind of wanted to combine the two, and I'm not opposed to that, but I want to make sure we get the strategies in there and the environmental and governance as well. So that's the proposal.
I guess, Mr. Chairman, what that does, I think it doesn't do any harm because we got environmental and governance in the title. And I think that we are saying that fiduciary decisions don't, where are we at there? I can get into the right sentence. Yeah, that they do not include those interests or strategies. And I understand your thing about the governance strategies where you have bad governance structures there, but I think what we're looking at is the governance structures as it applies to some of the different agendas that people are getting on boards with, adding absolutely no value to them.
What, I think the point I think the secretary is trying to make is that ESG investing per se sucks. I mean, just let's put it in plain language. It's misguided and it sucks.
Yeah.
So what if we said ESG in quotation marks investing sucks? And then we go on. I'm serious. I really am.
Oh, man, you were in legalese, but then
I think you would one up the governor of Florida in a heartbeat, Mr. No, but I mean, that's that I think is what Mr. Secretary, you're kind of trying to get at here. And what my concern is that by being overly prescriptive in this, we limit our opportunities to invest to the best interests of the people of Wyoming. And those two don't necessarily diverge 100%, but there are places where they overlap. I can tell you EOG has an ESG policy. I can tell you Exxon has an ESG. I can tell you Arch Minerals, Peabody, they all do. I am now currently trying to get a meeting with our good custodian because they just invested $60 million in carbon capture. They should have done it in Wyoming, and hopefully they can see their way clear to do that again. But that's my point, is I don't want to cut off our left hand just because, so, I'm not being disingenuous. I really am just flat out say it's wrong-headed and incorrect. I like the word sucks, but
Mr. Chairman.
Madam Superintendent.
Well, Mr. Chairman, on that point we're discussing, I mean, I also believe that, ESG is what it's trademarked or called at the moment. I think as soon as you just define that, these ideologues will find a way around and call it something else. And so being prescriptive enough, but also broad enough that we make sure that, once it is identified as something else, that we're still prohibitive of that.
Yeah. Okay.
Mr. Chairman?
Madam Auditor.
I think I do like the tweak made by the secretary, but I like your point because I think your earlier concern was if someone, instead of seeing ESG as one thing, which we all sort of know what it is, but it's hard to define in writing, your concern, I believe, was if somebody just pulls out governance or just pulls out one of those things, then that sort of becomes potentially problematic. So maybe this could be solved for example, by up in the title, environmental social governance, in parens, quote, ESG, and then down below that sentence can list, social, political, ideological, or ESG strategies, something along those lines. So where we actually don't change it to 3 words, we say ideological, political, or ESG as one thing, so that somebody can't grab that governance. And again, I think that maybe helps us too, because one of my, which I think I brought up at the last meeting, I want to make sure, we may make a decision about China that isn't solely based on monetary factors. And I want to make sure we don't inadvertently violate our own.
Yeah, that's a
policy.
slippery slope. Yeah. Mr. Chairman, how about we do this? So let's take these suggestions that we've got, and as the auditor just suggested, your suggestions there as were amended, put them in a draft and move them forward to the next meeting.
That sounds good to me.
Okay.
Does that meet with?
Yeah.
And Mr. Chairman, we want to get it done, but yeah, I mean, if there's a majority, that's fine.
Mr. Secretary, I think as long as we have the proxy part of it implemented today, then we don't lose any time in the actual implementation of the whole process. So, so we can get everything done at the same time schedule, but we'll be able to look at this a little bit more. And I think with these amendments, we've added some perspectives in there, and we'll take a look at those perspectives over the next 3 months.
That sounds terrific. If you can either take that as a motion or.
I can take that as a motion, Mr. Chairman.
Sure,
I'll
why
make
don't you?
that motion.
You move that portion?
The proxy
Yeah.
portion. Mr. Chairman, I'll second.
No, the proxy port, we got a different motion for the whole thing. What we're doing is making a motion to take 3.5 out of the IPS, but include the amendments as a draft for the next meeting that we have to be included in the IPS, and or as further amended during the process with the consent of
And at the risk of just muddying the process, let me just say that's what let's have this as a motion on the IPS.
Yeah.
And we'll just note that 3.5 could be moved to the next session. Does that make sense to you?
That's fine, Mr.
Yeah.
Chairman.
Okay.
So I'll make the motion to move the approval of the IPS as amended with the exclusion of section 3.5, which will be carried forward to the next Slib meeting.
Is there support for it's been seconded by Superintendent? Is there any discussion?
Mr. Chairman, I just want to be sure on page 26, have we conformed our motion earlier with MSCI, ACWI, ex-US, ex-China in the statement? So we're out of China passively, basically.
That I
bottom line.
believe is what is, if that was the notion of the treasurer's motion when he said as amended.
Okay.
Right.
Thank you, Mr. Secretary.
Okay, good.
Further discussion? Further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Nays? That motion carries. And we are at 12:27. No, actually, good work, and I really very much appreciate the discussion. Thank you. With that, Josh, I think, or Mr. Treasurer, is Josh the next one up?
Yeah.
Great. Thank you, Mr. Chairman. The last thing I have is the preliminary March performance report. I'm going to be super high level and brief given the hour and the fact that I believe you've all had a chance to review this. Page 2 of that report You'll notice the table on the left-hand side, which lines up calendar years and sort of just rank orders the different asset classes by top best performance to worst performance at the bottom. As you know, coming off 2022, which was a very challenging year for pretty much all financial assets, only MLPs and real estate providing material positive returns. And you can see in the calendar year to date, 2023, to the right of that, that's the first quarter of this calendar year, most assets are positive. So you're seeing some nice rebound in most assets. The worst performer's been commercial real estate. A lot of that is coming from write-downs in the office sector. To some degree, it's also very similar to what we saw in 08 and 09, where private real estate didn't fall at the same speed as public real estate. It just took longer for those valuations to catch up. The negative returns for private real estate came in 2009, not in 2008. The S&P is up 7.5. That's the best performer on the page here. I would note, however, that if you take out the 5 largest companies in the index and their returns this year, the S is barely positive. So we are seeing a little bit of a return to the market dynamic that you saw in, especially in mid-2021, where those largest companies, primarily tech or tech-oriented, are sort of dominating market performance again. Whether or not that can continue is debatable. It doesn't seem that we are completely out of the woods on the inflation question. Core inflation has remained stubbornly high, and whether the Fed pauses or skips or however they define this next move, they do need to keep their eye on inflation. The performance of your funds has been good in this environment. I'm just going to go to page 6 and highlight the Permanent Mineral Trust Fund. Fiscal year to date, that now brings you to 5.6%. So you're seeing some nice alpha there, 60 basis points ahead of the total fund index. 70/30 is now up 7% over that time period, primarily due to this sort of rebound in the cap-weighted equity indices. But over the past year, which includes most of last year's turmoil, 70/30 is down 6.4. Permanent mineral is only down 1.5%. The Common School Fund performance isn't quite as strong, and I would just note that 4.5% fiscal year to date. So it's not keeping up quite as much in this sort of growthier rebound phase. But as you just approved in policy, we'll actually be consolidating those into one single asset allocation strategy. And the last thing I would point you to is on page 10, and this just looks at permanent mineral in green and common school in blue versus that 70/30 stock and bond index in purple. And this is the rolling 3-year Sharpe ratio. So looking at risk-adjusted returns over lots of different 3-year periods across time. And on the far right-hand side of the page, that's the most recent 3-year period. From my perspective, it is worth noting how good your risk-adjusted returns have been. So your team, including the decisions you've made as a board, the IFC guidance, and the execution of that by the Treasurer's Office and the team there, you're well above 1 Sharpe ratios over the last 3 years. And that is, anything above 1 is phenomenal for Sharpe ratios. And 70/30 is well below 1. So I just wanted to make sure we took note of that today. In the interest of time, Mr. Chairman, I'll pause there. Obviously, we could talk about anything that you have questions about, but those are the main points I wanted to highlight today.
Thank you very much, Mr. Keevan. Any questions, Mr. Treasurer, any color you want to put?
Well, I think as we roll into these things, when we go to the a total return from income. We're gonna have to, I think, kind of pace ourselves into it, because as we don't want to do a wholesale sale of our bond portfolios, because there's a lot of embedded losses in those. So, but I think those things will roll off, and we'll get to those as soon as we can. But I don't want to realize a whole bunch of losses if we can defer those a few, sometime.
Perfect. Thank you. Any questions? Hearing none. Thank you, Josh.
Thank you.
We saved the best for last. Mr. Treasurer, is there anything more?
No, I think we're going to slide on to the K1s. Are you guys done? Yeah. Anything, Patrick? Good.
Do you,
Mr. Chairman, we have an emergency MRG, and we also have a request from Town of Lusk for redoing some of their the scope of their ARPA.
right.
Right.
So, Mr. Chairman, the next item on the agenda is H1, which is to consider one application for a Chapter 3 Emergency Mineral Royalty Grant for the Kemmer-Diamondville Water and Wastewater Joint Powers Board. This is a request for $404,890 in emergency MRG money to address a failed water main. The failure of the water main required them to shut off water to approximately 45 residences. Water had to be hauled to homes. People had to use the Kemmer Recreation Center for showers until emergency repairs could be completed. Water was also shut off to the mine, power plant, and industry park, and fire suppression was unavailable. With that, Mr. Chairman, I would yield to Ms. Blackwell. She can give you more of the details with respect to the request and what the funds will be used for.
Ms. Blackwell.
Mr. Chairman, board members, as the director stated, Kemmer-Diamondville Wastewater Joint Powers Board has requested funding to replace a 16-inch transmission main that's integral to their water system. This main ensures water is transferred between the two communities. It also ensures that the residents south of the district receive their funding. The funding being requested is 50% of the total project costs. This request does not include any of the emergency repair costs. The town or the district or Joint Powers Board, has paid for those emergency fixes themselves. While we shared this request with our partnering agencies, DEQ and Water Development, they reviewed it and believe that this situation does meet the definition of an emergency. Therefore, it is recommended that the board approve this request in the amount of $404,980.
Thank you, Ms. Blackwell. Are there questions from Ms. Blackwell? Thank you. I don't believe there are. Do you know if there's anyone online, Mr. Bump? I don't see anybody. If there is, please raise your hand. If not, I would entertain whatever the pleasure of the board would be.
Mr. Chairman,
Madam Auditor.
I would move that the board approve the Kemmer-Diamondville Water and Wastewater Joint Powers Board application in the amount of $404,890 in emergency MRG funding to repair their failed 16-inch transmission water main line.
Second.
I had a second with the treasurer, so
okay.
thanks. Thanks very much. So moved and seconded. Any discussion? Hearing none. All in favor signify by saying aye. Nays? That motion carries. Thanks.
Thank you, Mr. Chairman. The next matter is J2, which is to consider one change in scope for the town of Lusk for an awarded project from the Chapter 42 Local Government Project ARPA grants. You may recall that at the special State Loan and Investment Board meeting on February 28th of 2023, the town of Lusk was awarded $5 million for its water and sewer system infrastructure project under ARPA application 1030. This is a request to utilize part of that funding for essentially an emergency repair. So with that, I would yield to Ms. Blackwell to again provide the details of the request.
Mr. Chairman, board members, the town 2 weeks ago experienced a couple breaks in their line on Elm Street between 8th and 9th Street. These 3 breaks are outside the original project scope of the approved ARPA project, the application 1030. Therefore, the town has asked to use some of their ARPA funds and request a change in scope. The information was received after the due date for emergency MRG apps to be considered at this meeting. Therefore, staff felt it was economic and efficient to present to the board a request to amend the scope and allow the town $120,000 to make these fixes while they already have construction crews out and mobilized.
Thank you, Ms. Blackwell. Sir.
My name's Todd Skukud. I'm the Public Works Director with the town of Lusk, and I'm just here to entertain any questions. I would like to note that the 120 we did apply for was an engineer's estimate, and then we do have a amount from the actual contractor, and due to subgrade issues that they came in at like 170. So I'm not sure if we can amend that from 120 to 170, if there's any way to do that.
Thank you very much, sir. Questions from the board? Madam Superintendent.
Thank you, Mr. Chairman. With this change in scope, are you worried about the viability of the entire project, or is it going to be able to be changed and adapted and maybe scaled down?
So I think what we're dealing with is we're tying on a new 8-inch main to an old 100-year-old 4-inch main, and that it's got a history. And when we turned it on, it just ruptured the line, and it did that 3 times. So we actually left the 8-inch valve off and backfed it through a 4, and now it's holding. But my fear is if we loop it and get that 8-inch open, we're going to have issues there. But I think once we get out of that hot spot, I think we should be good to go. So.
Further questions? Okay, thank you, sir. It's the pleasure of the board.
Mr. Chairman,
Madam Auditor.
I move that we approve Town of Lusk's request to use a portion of the funding previously awarded to the town under the ARPA 1030 grant for water and sewer infrastructure project for the necessary emergency repairs described today related to the water main between 8th and 9th Street on Elm in an amount of up to $170,000.
Yes, ma'am.
The remaining 4.83 million in funds awarded to the town under ARPA Grant 1030 will continue to be used for the water and sewer infrastructure project as previously authorized by the board.
You've heard the auditor's motion. Is there support for the motion? It's been seconded by the superintendent. Any discussion? All in favor signify by saying aye.
Aye.
Nays? Congratulations, and I hope good luck too.
Thank you. Thank you, everyone.
Thanks.
Mr. Chairman, we are now to the K matters, which are Board of Deposits, so I would yield to the Treasurer's Office.
Mr. Treasurer.
We have the standard thing that we do every time this year, and that is to set the rates for the next 3 months or the next quarter for the TDOA program. And as you can see in your packet, that those are averaging 4.76% now in the 1-year Treasury. So I would recommend, Mr. Chairman, that the board accept the recommendation of the TDOA rate to be established using the 1-year Treasury bill average yield for the full calendar quarter preceding this meeting
January 3rd, 2020 through March 31st, 2023. The rate of 4.76 will be for the first quarter of the TDOA contract year of 2023-2024 to be effective July 1, 2023 through September 30th, 2023.
Thank you, Mr. Treasurer. Is there a second?
Second.
It's been seconded by the auditor. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
That message carries.
Okay, Mr. Chairman, the second part of that, I think you saw that, that was just the summary here. Oh, this is a summary of the different banks and their deposits and their over or shortage. You can see that there is no shortages within these banks. I do want to draw your attention to a request that we've had from a couple of banks. You see that there's a lot of these banks don't avail themselves to the amount of money that they could possibly take out as a participation in the TDOA program. Some of the banks would like to have a further, I guess, shot at that money that's left over. We're working on a potential proposed change in the application that would allow them to check the box up to a certain percentage and request that if it was available. We're trying to make sure that we don't have any more than 2 times that we go through the process. And we're thinking that might allow us to be able to get a little bit more money out into the banking industry. I guess during this time where there might be some additional stress to some of the institutions. So we're going to work on that, and we would hope that we were going to be able to do it for this particular tranche, but it's going to have to be for the next one at the first of the year if we get that form changed. But we want to get the form, I guess, developed, get it in front of the board, have their input on it, and in a discussion about whether or not, because we will be, possibility that we might have a little bit loss in opportunity income, but at 4.76, that's still a fairly good rate, and I think may help out the industry overall and be augmented by, increased economic activity because of the loans.
Thank you, Mr. Treasurer.
Yeah, going on to the K3 here, this is a list of the banks that have been, I guess, come under other ownership that have requested to be a approved depository. And so we've got 2 mergers here. One with the First State Bank of Newcastle was acquired by the First Northern Bank of Wyoming. And also the Lust State Bank was acquired by Banner Capital Bank. It looks like it was all in order. And so the recommendation would be that that the board accept the treasurer's recommendation of the list of eligible depositories to receive public funds on deposit.
Thank you, Mr. Treasurer. Any discussion? Hearing none. Mr. Treasurer, do you make the motion?
Yes, Mr. Chairman. The motion is that we recommend the board accept the treasurer's recommendation of the list of depositories to receive public funds, and that's on the subsequent 2 pages.
And is there a second? It's been seconded by the superintendent. Any discussion? All in favor signify by saying aye.
Aye.
That message carries. Mr. Treasurer, one thought on banks, and I'm wondering if we want to talk about it at some point. My concern has been how many of these mergers are going to out-of-state banking companies, and the fact that state chartered banks are getting fewer and fewer. And that may, I hate to see that, number one, but it may require some constitutional discussion, because if I remember correctly, the constitutional amendments is either national banks or state chartered banks, or banks chartered in the state of Wyoming.
So to you just be practical about this, I don't know if we need to really think about how we would approach that.
Yeah, and I think that, I'm not sure what the rules say, but, we want to make sure that we're not putting Wyoming's money to work in another state if we can help it. Yeah.
Precisely. That was always my concern, is that we put deposits here, and particularly TDOA deposits,
Right.
and they're used in Colorado or Nebraska or Montana or wherever.
Right.
Yeah. All right. Thanks. Madam.
Mr. Chairman,
Director.
that concludes the agenda for the State Loan and Investment Board, and we can transition into the State Board of Land Commissioners.
Okay, without objection, please go ahead.
Mr. Chairman, I do want to note one thing, and I know the superintendent's been working on this a lot. I talked to the staff yesterday. I mean, we have this matter, a couple things on the charter schools. One is that, that bill goes into effect July 1, and it mandates us to transfer those charters to that new board, that new authorizer, and we've received legal counsel that that would happen after that's created on July 1, so that is something that I'm hoping is going to be on the agenda here soon, just to keep us on the up and up statutorily. And then the other thing is, there have been some concerning developments on one of the charter schools, and it looks like they, unfortunately, and it's not on them, they've had some difficult negotiations. And it does look like there may need to be a slight adjustment to the contract, so that they could open the following year. And I just want to make sure that we are clear that we are the intent is to take action at our next meeting on those two matters, because we want to make sure, one, that that transfer does occur in accordance with state statute, but two, that Laramie County Charter School, which is very, very important and a really, really important thing, is not in violation of the contract. And I think it's preferable we do that before that transfer happens. So anyway, I just wanted to make sure we note that at the end.
Thanks.
Mr. Chairman, if I could just comment, the Secretary is right that we do not have that on the agenda today because the statute governing the assignment of the contracts to the education entity is not effective until July 1. So we have nobody to assign those agreements to until that body is formed. With respect to a request to alter the charter agreements, that request needs to come from the applicant themselves, not from Department of Education. And that, as I understand it, has been made clear to the applicants. I'm looking at our counsel back here. I believe Mr. McKenzie has spoken to the applicant or to Department of Education. I know our staff has spoken to Department of Education and let them know that the applicant needs to make that request, and we will get the board matter in front of the board as soon as we have that.
Thanks. Okay.
Yeah, Mr. Chairman, I would just note our staff is working with that particular school, and so the hope, I think, is for the August meeting to have both of those that we can vote on.
Fantastic. Thank you, Madam Superintendent. Madam Director, without objection, then I will close the State Board of Loans and Investments and move to the Board of Land Commissioners.
Okay, Mr. Chairman, the first item on the agenda are approval of meeting minutes. We have the minutes from the April 6th regular State Board of Land Commissioners meeting and the April 25th State Board of Land Commissioners special meeting, which was the virtual one related to the shed antlers.
And thank you. And for the record, I'll say we still have a full complement of our quorum. So what's the pleasure of the board?
Mr. Chairman, I would move to approve the minutes of the State Board of Land Commissioners from April 6th and April 25th, 2023.
Thank you. It's been moved and seconded by the superintendent. All in favor signify by saying aye.
Aye.
That motion carries.
Thank you, Mr. Chairman. Once again, we have provided the board with those enumerated reports under tab B. We don't have anything to add to those reports at this time, but we do have staff here should there be any questions from the board.
Any questions from the board? Hearing none.
Mr. Chairman, I note that we have provided the materials for this meeting in advance to each of the board members. We have also briefed each of the board members individually. Prior to this meeting, at this time, I'm prepared to propose a consent list if the board would so desire. And it just occurred to me that I didn't pass out my list, but I think we can do it if I go slowly here.
Sure.
Okay, Mr. Chairman, the following matters appear to be amenable to treatment on a consent list. D1 through D11, E1 through E11, F1 through F5, and G1.
Members of the board, you've heard the recommended consent list. What is your pleasure?
Mr. Chairman,
Madam Superintendent.
I would move to adopt the consent list as proposed by the director.
So those would be, thank you, items D1 through D11, E1 through E11, F1 through F5, and G1. Is there support for the superintendent's motion? It's been seconded by the auditor. Is there any discussion? Any discussion? Any discussion? Okay, hear none. All in favor signify by saying aye.
Aye.
Mr. Secretary, nays for the consent list? Mr. Secretary, I didn't hear your vote.
What's that?
I didn't hear if you were.
Aye.
That's an aye, I'm sorry. Okay.
I do have some questions on all these extensions on the oil and gas leases. And I just want to just voice a concern that somebody brought forth to me was that that the extensions, as they go on and on and on, it's a way to tie up a lot of land for hardly any money and have just a continuation of non-development. And I don't know whether, how much truth is in that concern, but I just wanted to bring it up and ask the land office if they can, give us a inventory about how long some of these extensions have been gone on, and see if it actually is a problem, just to determine whether or not we needed to change courses in some manner, way, shape, or form.
Madam Director.
Mr. Chairman, Mr. Treasurer, the requests for extension that are on the agenda for today's meeting, they all meet the criteria, the requirements. The bulk of these are waiting on like APDs from the Wyoming Oil and Gas Commission, or there's some litigation that's preventing them from moving forward with this. They're waiting on those sorts of outcomes. So these are beyond their control. Now, you raise a fair point. When we do get multiple extensions, these are 1 year at a time extensions. So we look at them again every year. And if they are not able to drill, then we have the liquidated damages provision. We collect the liquidated damages that they have posted with the agency. But when we see them for multiple years, we, again, look at the situation and try to make sure that there isn't any funny business going on. But I believe most of these have to deal with waiting on other regulatory agencies. Jason, do you have some additional color?
Yeah, Mr. Chairman and Mr. Treasurer, if I understand your question, the typical scenario for an extension is laid out partly in statute and then in the board's rules. So the legislature has given each oil and gas lease a 10-year primary term. And that's as long as a lease can be held without it being in production. The board has reduced that to a 5-year primary term. And then after the 5 years, it approves 1-year extensions at a time, like the director mentioned, only 5 times. So you cannot get extended past that 5th time, regardless of the issue or the reason. And each time, as the director mentioned, that liquidated damages bond is assessed. It's $10,000 per lease. It's roughly $15 an acre or so. And if they don't drill within that specific extended period, each 1-year period, then that $10,000 is forfeited to the state.
I think the concern, Mr. Chairman, was from the private landowners where these directional wells might be going on, the private landowners. And there's companies that would like to lease their land and drill, but the drilling permit is held up and held. And so they just continue to do that, and that the free market basic system is just, no longer in existence. And so I can understand waiting for permits and other things, but I mean, we need to maybe re-look at this and see just, how many of these wells, maybe have a bifurcated system that if that well is going to be drilled on private property, that, when do you get competition back into things, and when do you just have people for $10,000 hold up a multi-million-dollar enterprise?
Mr. Chairman.
Yeah.
Madam Superintendent.
Thank you, Mr. Chairman. I would just comment on that too. I think that, the commission has made changes that will help in the APD process, but I mean, some of this litigation held up dozens of leases, and so no, activity can occur. And I think what ends up happening is I can see where, private landowners are frustrated with the process, but when you're putting together a DSU, I mean, the drilling spacing unit, I mean, it expands beyond just that private. And so you're waiting on then the federal permits, the state permits. And so some of this too, it's frustrating, I think, for the companies as well. And it's just one of those things. And then you've got these STIPs as well, these stipulations, whether it's the Game and Fish Department, whether, right, that these periods of time that they can't do anything to even move forward. And so it's just, I mean, it just shows you the regulatory, snowball that's been created. It's unfortunate. Thank you,
Yeah,
Mr. Chairman.
There's friction in the system. It's not working really well, and a lot of it is probably just exactly as you explained, Madam Superintendent. But yeah, it's just I'm just bringing up the concern about the friction that's out there, and that we need to figure out, I guess, how big the problem is, and see what we have to do. If we have to pressure our federal counterparts, then we do it to much as we can, if they can do it.
Yeah, Mr. Treasurer, this is a topic that we've brought up often at the Oil and Gas Conservation Commission. I do recognize the problem you point out, and it's one that has been brought to my attention. And, Director, maybe is an opportunity here for us at some point to sit down and kind of look at that again, because I think that was part of the reason why we didn't extend a full 10-year lease, is because we did see a lot of holding, and we were trying to make sure that people got moving along. So, very good. Thanks. I did want to, is it E11 that is the lease sale results? No, probably not. One of the ones on the, anyway, I just wanted to know if you could, I think it's on the consent list. It is E11. Could you just characterize how that lease sale went, either director or deputy director?
Mr. Chairman, I think the lease sale was successful. We've been seeing a trend of an upward trajectory from where we were back in 21 and first part of 22. Each one of these sales are exceeding $1 million and $2 million, and I apologize, I forget the total amount for this sale. But the sale always is the initiation to royalty development. And if you don't have a sale, and if you don't have a good sale that generates a lot of money, we don't see a lot of positive outcome in royalty development in the near term. And so I think what we're seeing is higher lease rates. I don't know that this lease sale topped a 50% lease rate, but we're surely higher than the 20 and 30% lease rates that we were seeing a couple of years ago. So it's always on a positive trajectory. This sale probably saw a lot more speculation than actual developers bidding on the parcels, which is also a normal occurrence. A lot of new names inside the sale that we weren't accustomed to seeing. However, that's how the industry works. You have speculators, and as the superintendent has mentioned in the past, a lot of people try to package a lot of land together and then flip it to somebody who might actually develop it in the future. And we're seeing a lot of that here lately.
Okay, thank you. All right, we have a consent list consisting of D1 through 11, E1 through 11, F1 through 5, and G1. What's the pleasure of the board?
Mr. Chairman, would move the
That-
consent list.
Yep, the consent list has been moved by the superintendent. Is there a second?
Moving directors rec on the
Moving
consent
director's
list?
rec
Yes.
is the way I
Second.
understood. And that has been seconded. Is there any discussion? Hearing none, all in favor signify by saying aye.
Aye.
That motion carries. Madam Superintendent, I assume I did not hear it. Okay, thank you.
Okay, Mr. Chairman, that brings us to the C matters, which are a series of rulemaking requests. Most of them go together like 1 and 2 and 3 and 4 and 5 and 6. So I will yield to Deputy Director Crowder to take you through the rulemaking requests.
Thank you, Mr. Chairman. The first set we'll work on is C1 and 2. This is related to Chapter 4 of the board's rules, the grazing and agricultural leasing. The legislature in its 2023 general session passed 4 bills that have an impact on this program, specifically House Enrolled Act number 35, which was state lands use of land qualification requirements, House Enrolled Act number 59, state land leasing improvements, House Enrolled Act number 82, state lands grazing of non-owned livestock, and House Enrolled Act number 83, state land lease deficiencies cure process. Each one of these bills has an impact to how the program is currently managed and needs to come with it changes to conform the board's rules to the statutes. The statutes are fairly prescriptive, so when the office was drafting these rules for your consideration, we didn't take a lot of liberty in adding any new language than what the legislature had provided. So specifically, there are 4 changes that we're asking to be included into the rules. The first is with the first House Enrolled Act, and that's a requirement, a core qualification for all applicants desiring to lease for grazing and agricultural purposes, that they have actual and necessary use of the land for production of agriculture commodities. The second is to amend the minimum improvement amount needing approval by the director from $2,000 to $4,000, and then changing the valuation method of those improvements from the contributory value to the current market value. The legislature also provided a definite definition for current market value within House Enrolled Act number 59. We're also adding that to the rules. The third is to address the issue of grazing of non-owned livestock. The legislature provided a criteria by which if a lessee meets this criteria, they don't need to get approval of a sublease, as would be the normal custom by the director. And that criteria is that the ratio of non-owned livestock to owned livestock can't exceed a 1-to-1 ratio in any 2 years out of the 10 years of the lease. Anything outside of that would follow the normal sublease approval requirements. And then the fourth and final is to adjust, and what we called this was the cure period during the session, but adjust the due dates for renewal applications, adjust the notification process that the office will go through. And we talked a lot about that this morning already, but how does the office notice people who have missing or delinquent or deficient, applications and the response time to that. That inserts a lot of new deadlines and a lot of notification from the office in a certified mail manner. The legislature did provide us the ability to make those phone calls as we've attempted to in the past. However, if those aren't fruitful, it does require us to send out a certified notice for those missing or deficient applications. In a conflicting application sense, we are to notify the existing lessee that a conflicting application has been received. That's not a new step. The new step is if the existing lessee doesn't respond with a complete application or it's deficient in some manner, we have a process that we are required to notify that existing lessee of the deficient application and give them enough time to clear up that deficiency. The last change inside of that House Enrolled Act was the change moving the notice for annual rental 30 days ahead. So right now we notice each lessee of their annual rental 30 days before it's due. This bill changes that to 60 days before it's due. We did hold a working session on this chapter of rules and invited everybody who may have an interest in how the leasing is done and the administration of those leases. We did that back on May 10th. We had the Wyoming Stock Growers Association, Jim McGagna appeared, and from the Wyoming Farm Bureau Association, both Brett Moline and Ken Hamilton came, as well as Representative Bob Davis. We had a great conversation during that. They've offered some additions to what we've offered you in these rules. However, after review, we feel a lot of those may need a lot more thought than the couple weeks we had to complete it in, or additional statutory changes in order to present it to you today. So we haven't taken a lot of the comments that came out of that, but have assured that group as well as the Joint Ag Committee, and we talked a little bit about that again this morning, that those changes, this office will work with the legislature to try to get in this session or try to clean it up in future sessions as we move forward to get to a spot where this process gets a little easier, perhaps introduces a lot more discretion to the office and the board, and does meet the times that we're currently in as far as electronic submission of payments and of applications, and ensuring that process has credibility and is trustworthy as we go forward. As the director mentioned, these rules are in packages for you. The legislature enacted these statutes to be effective July 1st. So in order for us to move forward with the administration of grazing and agricultural leases, we're asking that the board authorize emergency rules to insert the legislative changes into our current processes, and then also allow the office to move forward with the regular rulemaking process. With that, Mr. Chairman, I'm happy to answer any questions.
Thanks. And Jason, just for point of information, the comments that were made and the recommendations that were also made by the various groups and interested parties, those are a part of the record and can be helpful as we go forward.
Mr. Chairman, they're correct. You're correct. The working session wasn't a formal public meeting. It was an informal get-together, so we don't have an exact set of minutes for that, but we do have all the notes that we took from that meeting, and they will be informative as we
Okay.
move forward.
And as to electronic processing and form submission and so on, and I'm sure this would come about, but just if there's a budgetary issue associated with that, I want to, as we go through preparing the budget, know what that could mean. So, thanks. Mr. Secretary.
Thank you, Mr. Chairman. We got this email from Mr. Magagna about that this would be a great opportunity to add electronic submission of applications, electronic payment methods, clean this process up. And I was going to make this motion at the end. We could just roll it into this. I'm a little bit at a loss. While the statute may not address these things explicitly, 362107 says that the board shall have the power and authority to promulgate and adopt rules and regulations not inconsistent with the laws of the state, as it may from time to time deem necessary in the direction, control, disposition, and care of all state lands, and to preserve the value of the land and to recognize the fiduciary duties of the state land office. And happy to get 10 copies here. I think that the value of the lands is we're not reaching the full potential when we don't have these renewal methods there. I think we're in the clear bounds of 36-2-107. And so I'm trying to understand, do you want us to have a motion to do a separate process? Do you mind if we roll it into here with an amendment, or is your position that you're opposed to any board action to have electronic submission of applications, electronic transfer of funds, and a appeal process before the board? Those were 3 of the 4 things in this email. The other one is a little bit of a different issue, but I just want to understand, of those 3 options, what's your position? Because I think we need to get this done. I think this is actually an okay vehicle to do it in. If you want to do it separately, I'm okay with that. But if the position is that anything isn't good, then I want to understand that.
If that question is directed to me, or is it directed to the director?
Anybody's views.
Yeah, I would just note that electronic payment requires a certain amount of effort to sort of figure out who the processor is going to be and how that's done. The existing software that you use to record the leases and so on
would probably need to be modified. There's a procurement process that's associated with both of those that would take a certain amount of time. I don't think there's any reason to delay any of the suggestions moving forward, but procedurally, I think it's going to take a certain amount of time to get it done. And so that would be my reflection. And that also is a budgetary issue, and they already work with a fairly tight budget. But
And Mr.
Madam
Chairman,
Director.
if I could add on to that a little bit, we are concerned about statutory authority in some of these, and I think we have made some, through the governor's office, some suggestions for statutory changes that would in fact allow some of this. Like if you look at the payment structure of the statute, it enumerates those specific things that we can take as payment, which must accompany the application itself. So, and that's like in the form of a check or money order. I don't know, but it's weird because it enumerates all of that, but it doesn't say anything about electronic payment. We're not set up to take an application and an electronic payment at the same time. The way that the statute reads, it says filed in the Office of State Lands and Investments. We've always taken that to mean physically. We're not set up yet to take it electronically. Doesn't mean that we don't want to. We just want to make sure that we're not overreading the statutes when they're pretty prescriptive at this point. So we want to work with the legislature while we're trying to get our house in order, if you will, to accept these things. And so it's not that we disagree with it. It just takes a little bit of time, and we want to make sure we're on solid ground with the statutory readings. And Jim, you can come up, our trustee counsel.
Madam Superintendent, and I did have a question for Jim, but
Thank you, Mr. Chairman. I just want to make sure that I'm understanding correctly. I mean, we're talking about emergency rules right now that are basically to the letter of the statute, but you will almost immediately begin in that formal rulemaking process and consider these recommendations that have been discussed with Stockgrowers Association and other stakeholders. Is that correct?
And Mr. Chairman, Madam Superintendent, that's correct. And part of our process when we bring you the final rule packet is have a response to each one of those points. If we feel it needs more legislative action, then we'll state that in there and be very clear on what the path forward for each one of those changes needs to be in order for us to consider it.
hold on just a sec.
And Mr. Chairman, I was going to say that the cure process that the legislature has provided to us, it's pretty specific with respect to what we need to do. So that's why we put in the cure process that came out of the statutes. There may be some additions as we move along here and figure it out. But I think at this point, we're trying to get what's in the statute into the rules and make sure that we're abiding by that. And Mr. Chairman, Mr. Peters may have some additional discussion here about potential statutory changes.
And before we get to that, Madam Director, Mr. Secretary, you were wanting to say something.
Mr. Chairman, I do want to get to each kind of individually and be specific here because, and I had a different understanding, I think, from the superintendent, which is I think they're saying on payment, there's three issues here in Mr. McGagden's letter. So payment, submission of the application. Oh, and he's here now. And then the third is the appeal process before the board. And then there's that fourth, but a little bit of a different issue. So I think you're saying on payment that you think you need statutory changes to make that happen. How about on submission of the application and then appeal before the board? I think you were talking about that in the cure process. You also want.
So I do think this is probably appropriate for Mr. Peters to respond to that. And Mr. Peters, just before we get there, I think there was provocative testimony by the co-chair of the Ag Committee that this board could pretty much act on its own as it wished. I may be paraphrasing that a little generously, but I was hoping that you could kind of tell us how far outside the prescription of the statutes we can venture.
Mr. Chairman, I'll try to take these in order first and starting with payment. 36.5.103 is the applicable statute that lists the types of payment that are acceptable. And just to read from the statute, it says any person desiring to lease state lands for grazing and agricultural purposes shall file with the director an application on the form approved by the board, which must be accompanied by the regular filing fee and a certified check, bank draft, cashier's check, post office or express money order, cash or personal check acceptable to the director for the full amount of the first year's rental offered, and then it proceeds on. So there's a very specific list of types of payment or forms of payment that are acceptable that are designated in this statute. The board's broad rulemaking authority in 36.2.107 requires that any rules can't be inconsistent with the statute. I think that the legislature has prescribed here specifically the types of payments that are acceptable. And I think that if the board were to just promulgate a rule that accepts another payment method, if we're strictly looking at, I think that may be inconsistent with the specific list that's identified in the statute. There isn't a catch-all that says, or other forms of payment acceptable determined as determined by the board or by the office. And so I would hesitate a little bit there to say that it would be consistent with the statute to allow for other forms of payment, even though I'm not sure that there would be much objection to be able to expand the payment. So if we're just strictly looking at the forms of payment that are acceptable under 36.5.103, I'm not sure that it would be entirely consistent with the rules if we were, or with this statute, if our rules allowed for additional methods of payment that aren't prescribed by the statute. Second, for the submission of application, it does say file, and there's no definition of file. I know there are other agencies that interpret file to either mean electronically, fax filing, hard copy. I think the difficulty here and the basis for the director's statement of how the office has historically handled this is the second piece that says the application must be accompanied by the fee. And I think that's the procedural difficulty in allowing electronic filing of an application currently, while not allowing electronic funds to be received. I don't think there's a prohibition on it if the board wanted to interpret this to allow electronic filing. I think that's certainly within the statute. I think there would be some practical difficulties in matching that up with how the payment is received at that time, plus just procedural difficulties if there isn't an appropriate process for it right now. So I think that is something that the board could interpret or allow, but I think there are some procedural difficulties with that as it exists right now, and the lack of a process to be able to accept those electronically. For an appeal process, fortunately I don't have the request right now is to know exactly what is contemplated in terms of an appeal process. Or Mr. Secretary, would you mind elaborating on that? I'm sorry, I don't have that.
Thank you, Mr.
correspondence.
Chairman. And he's here now, so I'll just read off. I mean, it's pretty basic language. It's a lessee whose lease is canceled by the director under the section shall, upon request, be provided an opportunity for a review of the cancellation by the Board of Land Commissioners at the next regularly scheduled meeting of the board. And he puts it in two different places in section 7 and then under conflicting applications in section 5 as well. So.
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Chairman. So I think something that we might need to discern here is what in the emergency rule versus for final rulemaking. Because of course, with our formal rulemaking process, we get public input, which is extremely important to everything we do, versus the emergency rules. And so that might perhaps be a question for Mr. McGagnon too, of if everyone's on the same page of moving these forwards. I mean, we want to get it done as soon as possible to eliminate issues as we discussed this morning, but also want to make sure that we have that appropriate public comment period. Thank you.
I think that's an invitation, Jim. And while Jim's coming up, I do want to be mindful that we don't just lease to ag operations. We lease to oil and gas, we lease to wind, we lease to hard rock minerals, we lease to a number of other entities. And I do think that we carve out some special exceptions for ag, but if a permit is denied for being incomplete, I don't know if we want to say that only applies, that the appeal process only applies to one economic activity on state lands. So, Mr. McGagnon, very
Thank you,
good to
Mr.
see you.
Chairman, members of the board, and I want to be clear, certainly, that we totally agree with the emergency rule as it's being put forward. That's what's required to be in compliance with the legislation, and that's not the place to go with additional items. Our intent, and perhaps a little misunderstanding on our part, the meeting that we were very appreciative that the deputy director held with some of us, the informal meeting, we took that to be an opportunity to provide some additional thought, not just to hear about what they were doing, but to provide our input. Don't have a problem that the decision was not to put that into the rule at this point in time. Looking ahead, the thing I would like to guard against, if there are things in what we have advocated or anyone else that don't believe can be done through rulemaking and must be done legislatively, then we would like to know that now in a timely fashion so we can go before the legislature in this session, preferably through the Joint Ag Committee that has jurisdiction, and bring the necessary changes to enable this to happen. It's my personal view that those current statutory language allows for those changes in process, and even listening to the legal counsel for the department now, it sounded like has some maybe discomfort with it, but I did not hear any way that it would be a direct violation necessarily of any of the statutes to move forward with some of this. So if we need to do it through the legislative process, we're certainly happy to do so. Our approach to all of these issues for the past couple of years has been, before we go running to the legislature and asking for what we want, and sometimes getting maybe more than we want or more than you want, that it's preferable to try and work these things out through the rulemaking process with the office and with the board. But certainly, we're not hesitant about going to the legislature where we feel that's necessary. So that would be our approach here. If we see that this can be built into the regular rulemaking process as it moves forward, but not have to wait 120 days to find out whether it's there or not, that's perfectly satisfactory to us. We do think that while it represents some change, we have to keep in mind that most of these statutes dealing with state trust lands were written in a different era, not the era of any of us that are here today. And some of the tools that we have available today and the conveniences, both conveniences for the Office of State Lands and conveniences for lessees, whether it be grazing or otherwise, didn't exist back then. So I think that at least our view is that the board has some jurisdiction within statutory parameters to modernize these processes to a reasonable extent. And the other one I would add, just because it was also brought up, the issue of and I'm not talking about a formal appeal to the board, but an ability to appear in front of the board. I think back to the days when I was sitting in the director's position, and we had at least a half-hour period at the end of every board meeting where anyone could come forward and raise an issue with the board. The board may choose to respond to it, they may not, but that opportunity existed. Given the busy schedules and everything today, I see that that's no longer provided, and some opportunity to say, if I feel I've been wronged, that I don't have to go on my hands and knees and beg for the opportunity to address the board or go around about and reach out to each of you individually because I don't have any opportunity to reach out or stand before you as a board. That's the type of things we're trying to accomplish here. So happy to work with the board and with the department, the agency, to make that happen. But I don't want to find us next January finding out that these things couldn't be done when the final rule is proposed, and then, as we did a year ago, come back and ask you to reject the final rule and make some changes again. That's not the ideal process for any of us. With that, Mr. Chairman, I'd be happy to take any questions.
Questions from Mr. McGagnon? Mr. Treasurer.
Okay. It was brought up today that one of the problems that we have is that basically the holidays got in the way of some of the processing because of the dates. And I know on the end of the year, and you probably remember this from your time when you were the director, is that your employees wait till the end of the year to take their vacation, and it's a skeleton crew the last 2 weeks of December. Yet you have a due date, basically on the 1st of January. Would it help at all if we change the due dates on these things to the 15th of December and the 15th of November? So you get rid of the holidays in front of those due dates, so you know that you're pretty much fully staffed, during that time period.
Mr. Chairman and Treasurer Meyer, I'm trying to think of this from the perspective of the average rancher out there.
Right.
And part of the problem is that, the 15th sounds good. It avoids some holidays, but it may also create some new confusion with people. One of the issues is that we're used to having our annual renewals either January 1st, February 1st, or March 1st.
Yeah.
Under the laws that stands, and even with the legislative changes that were made, while there's much more notice required, suddenly the due date that it has to be filed is 30 days prior to that. And I think what the habit of so many busy ranchers, particularly in a year like this, is I always do my state land stuff by March 1st. So here's an envelope from state lands that'll go in the pile for March. Not stopping to realize, well, this particular one, because renewal is due 30 or 60 days prior to that. So I'm not sure that any choice of dates is perfect. Part of it is we've got to work more once we get this sorted out to educate ranchers about these differences that exist and how to respond to them. So I'm not saying that that would be bad. It would certainly help maybe in the office and might help some ranchers who typically pay their bills by the 10th of the month, and they would see that then. But because of all the advance notice that's required, particularly with the recent legislative changes, I'm not sure that that additional change would have much of an impact.
So Mr. Chairman, I guess, so rather than when we look at moving some of these dates, rather than moving them up earlier, it might be better to move them later because they're going to be on time because they figured they were going to do it 30 days earlier than what the dates were.
Well, Mr. Chairman and Treasurer Meyer, one of our initial recommendations to the Ag Committee last year was to say that a lease renewal application is due on the date that your current lease expires, because that's when you're used to dealing with it, and then to provide a 30-day grace period after the expiration date if you hadn't gotten it in, which we did provide in terms of annual payments. But we would have, as a way to simplify this, would have been to say, yes, everything I have to do with this lease is always going to be on March 1st of every year, and I don't need to be looking at different dates depending on a different time frame.
It
But
just complicates it too.
it does complicate it for people. There's no question about that.
And Mr. Treasurer, from my standpoint, having to do these things usually, fall, winter, that's a time I'm working on tractors. I'm trying to get other stuff done. It is a time when you try to get your paperwork. And for a lot of us, that's when we get our big checks. So it's a nice time to be able to kind of resolve a number of those issues.
Yeah, but we're asked to change the dates in one of these sets of rules here, so I'm not sure what dates we came up with, but as we get in that discussion, we want to make sure that you have your input. Thank you.
Appreciate that. And I don't believe that the new legislative changes change any dates by when things are due. They certainly change the dates in terms of notice that you receive in order to move forward with these things. The one exception is on the annual rental payments that we were successful in getting in a 30-day grace period with a penalty.
Adjusting the date renewal applications are due. So.
I
believe it actually makes it earlier than it was before.
It does.
Yes.
To 60 days.
Mm-hmm.
Yeah, it did very little, if I remember the statute correctly, it did very little to solve the process after the termination. It did a lot of stuff to have notification prior to. So there's new timelines for the office to notify for renewals. And to Mr. McGagne's point, I think, the two things that we've really looked at, and the co-chair of the Ag Committee brought them up today, were one, post date as opposed to filed in, so that an application postmarked by a certain date would be considered.
What we proposed and what we've offered there too is that the post date would be the controlling date. I mean, if you read the statute totally literally, which I've tried to do, it says it must be in the office, which almost could be interpreted from the old days. That means you had to physically show up in the office and knock on the door and say, here's my lease renewal. And obviously that's not the world we live in today.
And then I think the second piece that the co-chair brought up that they're working on is a contemplation of a grace period and a cure. You know, that was really what we were looking at last year. And I think the third one that Mr. Peters illuminated here is that, you know, maybe having some ability to have a catchphrase on form of payment, although, you know, we are getting into things like crypto at this point, and I'm not sure we're prepared to take that. So maybe you just add.
Maybe stable token.
Yeah. Maybe what you do is you add credit card or electronic payment or wires or something like that, so.
If I may, Mr. Chairman, just one other item that's not involved in here, but I think needs some attention, and this one I believe will have to be done legislatively, and I'll be suggesting that. And it would fill someone in the context of the issue we were dealing with earlier this morning. It says that if you lose your lease, that you negotiate the value of the improvements with the new lessee, or you have 120 days to remove those that can be removed without damaging the property. Well, to use an example like this morning's, I don't know with that in that 120 days, even if the lease is declared vacant and put up, I may be the successful bidder. So I'm having to remove my improvements, and 3 months from now, I may be putting them all back again because I won the lease back in a bidding process or no one bid against me.
Yeah.
Or the same thing is if I want to be paid by them, it says I negotiate with the new lessee, but there is no lessee at that time. So that's another place where we need some time frame changes that until we know what the status of that land is with a new lessee, that I'm not obligated to remove or declare the value of my improvements.
Well, and it does sound, Mr. McGagna, like we have the Ag Committee working really diligently on this. And I also want to say thanks to the Farm Bureau for being there. And it sounds like we've got a process. But just to be clear, the rule set before us, you don't believe there's any reason for the emergency rules that we need to change those when we're going to regular rulemaking? And then one quick question, and I'll let you answer that, but then Jason, I'm going to come back and say, when are these renewals mostly coming in? Because to me, most of these are going to be coming in this fall. But anyway, go ahead.
Well, no, that's all I had, unless you had a question for me.
Okay.
Okay. Thank you. Appreciate the
Thank you.
opportunity.
Mr. Chairman, to answer your question, roughly the board has 4,000 grazing leases in total. 10% of those renew each year. We have split them up into different sections of the state in 3 different parts of the state, though. What was mentioned before, the 1 dashes, the 2 dashes, the 3 dashes. This is just a little bit of foundational information, but 1 dashes are mostly the southeast corner of the state. The 2 dashes are the northeast corner of the state, and the 3 dashes are all of the west side of the state. And we have a lot more state land, obviously, on the east side of the state than we do on the west with the federal ownership over there. Those have been given specific renewal dates. The 1 dashes, the southeast corner of the state, renew on January 1st. The renewals are due in the office on December 1st. The 2 dashes renew on February 1st. The renewal applications are due into the office on January 1st. The 3 dashes, the west side of the state, expire on March 1st. They are roughly due into the office on February 1st. February being a short month, it goes into January, probably 28th or so. So those are the time periods when everything is due into the office. The current legislation, as well as the bills we're talking about today, require the process to start 120 days prior to the expiration of those leases. So you can think September 1st, October 1st, November 1st.
Okay, further questions? Mr. Peters, if you could, and Mr. Miller, if you could look for any colorable argument about accepting electronic payment, to the Secretary's point, maybe you could report that to us.
Mr. Chairman, happy to look into it further. As I mentioned on initial read, there's a very specific list enumerated in the statute, and to add to that list would be inconsistent with that statute. But we're certainly happy to look into it and see if there's any other way that we can.
Thanks. Further comments? Questions? Testimony?
Mr. Chairman, I've been trying to look at dictionary definitions of, bank draft, whether it's more broad than what I consider a bank draft, but yeah, I understand what he's saying. I'm not conceding, but it's a difficult one.
Thanks. Very good. All right, with that, members of the board, what is your pleasure?
Mr. Chairman,
Madam Auditor.
I move that we find that emergency rules are necessary to comply with the acts and for continued administration of the grazing and agricultural lease program as the board undergoes regular rulemaking process, and that we adopt the draft emergency. I guess we're just adopting the draft emergency rules. Do we not need to also direct you to start the regular rulemaking process?
Mr. Chairman, Madam Auditor, for whatever reason, we were inconsistent with our process on this side versus the Slib side. So on this side, we've separated them out. Emergency rules, C1, C2 is regular rulemaking process, whereas we combined them on B. So we apologize for that. We will be more unified next time with our rulemaking.
Mr. Chairman, barring objection, I would make the motions together that we both adopt the emergency rules as enumerated and direct the board to go forth with the regular making process as discussed.
Is there support for the auditor's motion, dual motion?
Second.
It's been seconded. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Nays? Motion carries. Thank you. Thank you for the discussion. And thank you, Mr. McGagnon, for your participation. So,
Mr. Chairman, that brings us to the next set of rules, emergency and regular for Chapter 5. Oh, yeah, they directed us to move forward with the regular rules. So Deputy Crowder, we take it from here.
Mr. Chairman, the next set of rules are of the same nature. The 2023 legislature passed House Enrolled Act number 86, or House Bill 171. Inside of that bill, it requires that the office provide notice to existing state lessees and owners of adjoining lands of the office's intent to issue an RFP, or a request for proposal. And it's specific to the state lessees and adjoining landowners of the parcels which the RFP would reference. It is also expected that the office would advertise on its website of its intention in a newspaper of general circulation in the county or counties where the project will take place. Mr. Chairman, we have inserted that process within the rules that we're asking for approval of today. It's important to note that we don't do a lot of RFPs, but when we do them, we do want everybody to know that we are doing them to solicit as much response as possible to get the most positive outcome. So this is a good change to the rules. It does impact two sections or two chapters of the board's rules, Chapter 5, special use leasing, and Chapter 6, wind energy leasing. And those are board matters C3 through 6. The legislature did affect these, or enacted these statutes to become effective on July 1st. While we don't have any RFPs known right now, or have any desire, or no process, no plans, yes, thank you, to issue an RFP, we want to be responsive to any opportunities that come up. So we are asking for emergency authorization if those opportunities do come, that we can comply with the statute when we're moving through that process. Happy to answer any questions.
thanks. Any questions for staff? Any questions? Any questions? What's the pleasure of the board?
Mr. Chairman?
Madam Auditor.
And I would note to Jason's point, I think that in my 4.5 years, they've issued one, and we all had loads and loads of notice. So I think this is unlikely that it'll happen before July, but I would move that we find that emergency rules are necessary to comply with the act and to allow OSLI to be responsive to any emergency opportunities for the benefit of the state's trust beneficiaries as the board undergoes the regular rulemaking process, and that we adopt the emergency draft rules for Chapter 5. And I
further move that we direct OSLI to begin the regular rulemaking process on the aforementioned chapter.
Second.
Been moved by the auditor, seconded by the treasurer. Any discussion? Mr. Secretary.
Thank you, Mr. Chairman. Just want to understand for clarity, are you moving all C3 through C6, or are you just moving C3?
Well, Mr. Chairman, Mr. Secretary, that's why I was making funny faces, because I wasn't sure if I could move all four together. I have no strong feelings. I think at the moment I just moved 3 and 4.
Okay.
Okay,
Correct.
3 and 4. Everybody understand that? Mr. Second has had, okayed that? Any further discussion? Hearing none, all in favor signify by saying aye.
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 Yeah, all ayes. Thank you, Madam Director.
Mr. Chairman,
Madam Auditor.
since we already covered 5 and 6, I would intend to go ahead and make a motion on those as well.
Is there support for the auditor's motion?
I can say it out if you.
5 and 6, yeah.
I would move the director's recommendation on 5 and 6, being that we adopt the rules related to Chapter 6, and that we also direct the office to begin the regular rulemaking process.
Been moved by the auditor, seconded by the treasurer. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Nays? Motion carries.
Mr. Chairman, that brings us to D12, which is to consider an application for special use lease. This is related to the Tallgrass High Plains Carbon Storage Project here in Laramie County. This will be the second carbon storage lease that the board has considered. You may recall the Frontier lease from a couple of months ago. And with that, I would yield to Deputy Crowder to explain the Tallgrass lease.
Thank you, Mr. Chairman. This is the second carbon sequestration lease that the board has seen. The board approved the first one back on February 27th. This lease template largely follows what the board approved back on February 27th, with only a couple changes, which would be trying to create some consistency with the DEQ and their rules and regulations related to Class 6 injection wells and some of the timeframes that go along with that. One of the other changes, and it's specific to the applicant and this lease, would be the compensation structure. We have an initial bonus payment of $15 per acre, and then a second bonus payment that has an equation that is tied to it. The equation for the second bonus payment is to identify the number of acres owned by each affected landowner within the unit area, multiply that total unit area by that landowner's per acre rental rate, add the rental totals from that total, and divide the sum of the rentals by the total number of acres within the unit area. So effectively, we are getting the average of every person within the unit. It's important to note that a lot of the negotiation that we had with this lease was trying to make sure we were comparing ourselves to similarly situated landowners. Similarly situated landowners needs a little bit of discussion, meaning that we are a relatively small part of the whole project, and we are relatively dispersed across the project. We don't have consolidated ownerships that would make our land easily or ideally developed. We also retained some rights that others let go in their lease negotiation. One would be the development of minerals. We retain the ability to develop the state's minerals on these parcels. The right to drill through the pore space, we retain that right. And the ability to forego any surface development. Other landowners are actually having this Class 6 well on their land, as well as any monitoring wells. We're not contemplating any surface activity as contemplated here. The last part, and sorry, let me finish my thought on that, meaning that when we talk about similarly situated, we need to define that we are only comparing ourselves to others that may have reserved those rights to themselves. The size is also important. There are a lot of landowners in this part of the state. This lease is in Laramie County that may only own 40 acres or 100 acres. And in order for the project to move forward with them involved, the applicant may have had to negotiate higher per acre rates than what they have negotiated with us. This second bonus payment takes advantage of that. It doesn't bring into the equation similarly situated, as I just discussed. It brings everybody into one pot. The second bonus payment takes the average of everybody within the project. It also has a timing component to it. We are owed the initial bonus payment 5 days after execution of this lease. The second bonus payment is due 5 days after the injection initiation date, meaning that they have drilled their well, all infrastructure's in place to start sequestering that carbon into the ground. And that can be years down the road. And so what we have is that average multiplied by the number of years between the initial bonus payment and when that second bonus payment is done. So really it trues up the state's compensation to any annual payments that may have been made in other private agreements and keeps us on level footing. Additionally, we have a storage fee, which was similar to the original lease. It's a $1 per metric ton of CO2 sequestered. It's a proportional dollar, so the amount of state land that is involved in the project or the unit as defined by the OGCC. Tallgrass expects, and I apologize, I should have mentioned that earlier, Tallgrass is the applicant for this lease. They expect to inject close to 3 million tons into the project. We've also added a CPI increase or a rate escalator to keep pace with inflation. And we're going to ask the board to consider new language in the lease here after discussion with the state treasurer and what may be more appropriate in this provision. But essentially, what we have placed in here is that any payments, including bonus fees and storage fees, bonus payments and storage fees be adjusted by a consumer price index adjustment to keep pace with inflation. And that will be based on a preceding 5-year period from the Bureau of Labor Statistics unit from the United States Department of Labor. The change that we're going to ask is that original CPI was to commence upon the operations term. We've spoken with Tallgrass and they are agreeable to change that language to read, and I'll just read it for you, upon DEQ's approval of a Class 5 permit associated with the project. So we're beginning relatively soon, probably 2 or 3 years prior to when it would actually have been, the operations term would commence. So that's a good change, and again, Tallgrass is agreeable to that. So when we ask for approval of this lease, we'll ask for that adjustment to the lease form as well. We've also inserted a favored nations clause. It certifies, the lessee certifies in that clause that any financial commitments provided to the lessor are as favorable or more favorable than that provided to similarly situated landowners. And that's why the definition of similarly situated is important. The lease has some performance measures and some termination points that the board may terminate this for lack of performance or production. The first is if the lessee fails to apply for a Class 6 well within 4 years. And we believe that they've already applied for that well, so that may have already been completed. The second is if the lessee fails to completely construct all infrastructure necessary to inject within 11 years, the board may terminate the lease at that point. The third is if they don't actually start active injections within that 11 years, the board may terminate the lease. And then the fourth would be if CO2 injection stops after the operational period begins for a continuous 24 months, and there are some extension provisions built into the lease for that, but if it stops injecting for a continuous 24 months, then the lease automatically kicks into the closure and monitoring phase. The financial assurances associated with the lease and the requirements for financial assurances are that they place a bond to cover any environmental and reclamation compliance and operation requirements. That bond will be held by the DEQ. And OSLI is also requiring a bond to cover any financial obligations of the lessee may incur, and that would be equal to 1 year of expected storage fees. That bond is due once they begin the operational phase, and it's increased by 15% every 10 years. Mr. Chairman, we also required the applicant to reach out to every surface lessee, and they have done that and have received consent for the project from all surface lessees involved in the project. And with that, we do have representation from Tallgrass to answer any questions for you and to maybe give you a little bit more color on their project specifically. In the audience is Cody Wagner. He's the senior land agent for land and right-of-way, and Kyle Quackenbush, he's the segment president of liquids for Tallgrass.
Mr. Treasurer.
Just a couple of things there. How long does DEQ retain the bond? Is that 50 years after the length of the project? Is it forever? Is it relinquished at the end of the project's completion? Because I think there's going to be maybe something may or may not happen after the project completion. I'm just curious as what that is.
Mr. Chairman, Mr. Treasurer, it's a good question, and the fun part about carbon sequestration is that the legislature is looking at the state retaining or taking on liability and responsibility for the CO2 sequestered after a certain period of time. Possibly Mr. Quackenbush can answer that question a little bit more.
That sounds like a great idea.
It's a fantastic idea, but the intention is that DEQ's bond will be held until that point of transfer.
Okay, definition of similarly situated, we've got thousands of acres, and you talked about the 40-acre parcel is not similarly situated to us. So is there a per acre? Are we similarly situated at 160 acres of the landowners, at a section of the landowners? What's the definition of the similarly situated?
Mr. Chairman, Mr. Treasurer, we don't have an exact definition for that because there's a lot of pieces that go into understanding what it is. Not only the size, but all of the other terms or rights that may have been retained by the landowner. So when we need to get in and make an assessment if we are being treated fairly with other similarly situated, we would need to go in and do an audit of all of those terms to ensure that we're with those similarly situated individuals, and they're all over the board.
To avoid confusion, both on our part and for the company, it would be nice to have some understanding going into it, so we're not both paying lawyers. That's just a practical aspect, I think, of something that we should endeavor to do. The other thing is that I think, this horse is pretty much out of the barn, but in the future, I'd really like to have an analysis of the tons per acre that's in the formation of carbon dioxide that can be stored, and be able to compare the Trona play at $75 an acre for a bonus to this particular play at $15 an acre for a bonus, plus the enhanced compensation calculation here, because I think that this particular formation, from what I can recall, is thinner and it's not as deep as the Trona area, but I don't know for sure, but if you have a common denominator of tons of carbon dioxide per acre stored, then it gives us a better idea about how to price the bonus structure on it. And so one company doesn't think that they're getting a bad deal and the other company is thinking they're getting a great deal, that it's all based on a common denominator. So that's something that I hope that we can do in the future, is get that common denominator, so we understand that everybody's getting a fair shake. Something I don't think that we can do, that I'd like to do, is try to get some incentive for sequestering in-state carbon dioxide from our coal facilities or any place else. This is going to be sequestering, from what I understand, Iowa ethanol plant carbon dioxide. And so that's, to me, I think that we need to move forward on this, because more likely than not, the legislative process in Iowa will wake up someday and say, oh, do we have any of these particular, areas that we can use? Thank you, Mr.
And Mr. Treasurer, thank you. We're competing with North Dakota for Iowa ethanol, but I think there's Nebraska ethanol that's also, that's also valuable here. But Mr. Quackenbush, it's good to have you here, so. If it's red, it's on.
Okay, that's counterintuitive, but helpful. Thank you
Yeah.
very much, Mr. Chairman and the board. Thank you guys for the time to be here. My name is Kyle Quackenbush. I am the segment president of Liquids here at Tallgrass, so I actually oversee our legacy crude oil assets as well as all of our CO2 efforts. I know we've had a chance to speak with many of you, but for those who don't know briefly, Tallgrass is a midstream energy company. We have over 900 employees. We operate across 14 states. Here in Wyoming specifically, which is very much home for us, we have 168 employees and over 2,700 miles of pipeline. So a very active operator here in the state. What we're talking about here, this project, is really as an extension of our business in the state, frankly supporting our additional customers, both in the oil and gas space, power generation folks, and then you're right, to some extent, the ethanol plants that we have in Nebraska as well. This particular lease is in support of our Trailblazer pipeline project. So it's an interstate CO2 pipeline. It's actually the conversion of an existing natural gas system from natural gas to CO2. So repurposing infrastructure, which, as you guys are well aware, minimizes land impact, which is important to these communities. It will be serving emission sources in Wyoming, Colorado, and Nebraska. We are starting our sequestration efforts here in the state of Wyoming, but CO2 really is a commodity and something that also lends itself towards new industry that's developing along the pipeline route. So we're excited for both the opportunity here regionally, what it means for these communities in Laramie County, for those landowners and individuals, as we do compensate them for the pore space, but also what it means for Wyoming as we are able to deal with CO2 emissions that helps some of these industries, either where they are today, advance, or new industries that want to be located along infrastructure that can handle CO2, as well as bring the commodity to the state for industries that want to use CO2. And now that we'll be here in mass, have the ability to think about how that affects their business. So we're excited about that. Just a few statistics about the project, because I want to make sure I speak to some of your concerns specifically. The state lands represents about 4% of the area that we're interested in. So it really is the vast minority of the land. This is an area, unlike the project on the western side of the state, is actually a vast majority is private landowners. And so we have negotiated with more than 200 individual landowners in order to be able to get to this point with the project, to have a critical mass of pore space secured. So that has provided a lot of data points for us as we think about the market. It provides a lot of information actually that's informed our negotiation with the state lands on how to improve these leases or provide to the benefit of the state the benefit of negotiating with lots of private landowners. We also incorporate into our lease discussions members from the University of Wyoming, as well as several landowner lawyers, so that we can get this industry started off the right way in our minds with a form that feels fair and will work for private landowners, that the benefits of many of those negotiations reflected themselves in the state form as well. I wanted to speak to the fact that for this particular agreement, as you talked about, what is the total capacity of storage available? That is something that continues to develop over time. You have a chicken and egg dynamic where you know you have an area that you like for CO2 storage, then you want to make sure you have the right to store, because then the next level of diligence is very expensive as you continue to drill characterization wells and develop out your development plan. So we have that benefit for the state specifically in that form of the true-up payment, so that as we advance our knowledge in the area, if we're negotiating with private landowners, the state is getting the benefit of that over time. But it really will be a market rate, just like right-of-way negotiations across the state. Each region will have different pricing for CO2 storage. As is the case out here, as you mentioned, a very different formation than on the western side of the state, the CO2 storage capacity being less, and then actually a larger footprint, a subsurface footprint that's impacted. And so we end up having to negotiate with more landowners to store the same amount of CO2 than we would maybe in other parts of the country. So all those considerations are factors into what we would be willing to pay for the private landowners for the storage. We do have the same injection fee, though, so that is one of the great equalizers. As you're injecting over an area, if the formation is more prolific, you're making more money over the course of the injection horizon than you are just during those front-end payments. And so that's an area where if the formation is more prolific, that should catch up relative to some of those other areas. Last thing to mention, though, what's also unique about this project is we plan to be in service in early 2025. So actually starting the injection fees, as Jason mentioned, all the different milestones that are out there. We do have our Class 6 permit already filed. There'll be several more to follow here as we work through that process with the DEQ. But you will start to see injection fees with the project in a much earlier time horizon than some of the projects that might have 5 or 6 years of time before when you first leased and where you start the injection fees, which is where the primary compensation comes in. I want to thank you all very much for your time. We're thrilled to be here and excited about this project.
And Mr. Quackenbush, just the other thing that the treasurer brought up is the length of time you end up holding the bond before the state assumes the liability.
Correct.
And, go ahead.
Yeah, so thank you, Mr. Chairman. So it is our understanding as we work through this with the state, right? These would be the first projects that would actually have the state SIP in. So Jason is right that we would keep the bond in place up until the point that the state chose to potentially accept the long-term liability. So we will be paying into a pool over time that compensates the state for taking over that liability, more than 20 years after we cease injection, though it still is, our understanding is that's at the option of the state. So there could be circumstances where that wouldn't be the case and our bonding would need to remain in place.
Thank you. And I've got the secretary, and then I'll come back to you. Mr. Secretary.
I think Superintendent wanted to weigh in too.
Superintendent, I'm sorry, I didn't see.
Mr. Chairman, I've got a couple things here. I guess, I'm a little concerned by the difference in the payment structure with the one that was approved from Sweetwater versus this one. Anecdotally, I've heard that we haven't gotten a great rate here. I mean, and I think you were alluding to it, but I just lost track. I mean, how much lower? What is the contract structure that is justified a lower rate here, and how much of a lower rate have we gotten? And I also want to say on the record before you answer that I am concerned about the liability being assumed by the state. I think the legislature made an error on that bill, and I voted no. But anyway, I mean, we got to be careful with that. So thank you.
Thank you, Mr. Secretary. I'll take the first question, if that's okay with you then. So for us, the payment actually that we have here is reflective of what we're paying for the private landowners that are, as we talk about the idea of similarly situated landowners. So for this particular project, as an example, oh my goodness, I'm ringing. That might be my mom saying she saw me on TV. So it is reflective of the market in that particular area. And so on the western side of the state, again, not participating in that particular project, but they're looking at land in closer proximity to an emission source. There's very limited land or pore space where they can sequester. So that would command a different price. The amount of tons they can store per square mile is going to be unique to that specific area. So as a developer, we look at where else can we lease the pore space and what can we pay for that. That's a market indicator, as well as how much pore space will we need to procure that we can afford to pay. In our particular instance, oh my goodness, in this particular instance, it's more than 200,000 acres that we're actually having to procure for our CO2 storage. And so we negotiate those terms with the private landowners. The state is seeing the benefit of what we negotiated privately out there, what the market was. I mean, in this particular instance, as an example, Trailblazer is the connection that has CO2 be able to economically get to this area. It's not sitting right next to the emission source, as was the case in the other circumstance. So we also, just for a data point, Tallgrass is pursuing multiple projects across the country. Every market is it's a different market for every region based on if there's other people that are actually looking to secure the pore space, as an example. If no one else is looking to buy it, the market is different in that case. The state will get the benefit between the true-up payment and then the most favored nations clause. The state will get the best rate for that region. And so that will just be the regional price.
Mr. Chairman, that was my question. I mean, I know I mentioned the Sweetwater, but that was just comparing them initially. But how does ours compare with other Laramie County landowners in this project?
Yeah, so the payment itself we've been leasing in a range of, we use annual payments for the folks. We've been leasing at rates that are at these same prices for similarly situated landowners. Other landowners had actually foregone more rights than the state was willing to do. And so they had received a premium in exchange for foregoing some of those development rights for the minerals or things along those lines. That wasn't the case with the state. So this is the same price that we've been paying for landowners that didn't give up that right effectively. So that was the basis of the discussion. It It was what we'd already signed up. We have the benefit of, again, more than 200 negotiations so far. But when we go through the process for the unit, as Jason mentioned, like that'll be, you'll have a true up at that particular time. The way that we've negotiated our pore space leases out here, because it's closer to injection, is we make annual payments and then we start making injection payments. Some other projects that have a longer time horizon have made a larger upfront payment for maybe a multiple year option. So they're also just kind of different projects. Mr. Secretary.
Thank you, Mr. Chairman. My first question was the same as the Secretary's, and then second was just regarding the status of your Class 6 application. And so you had mentioned that it's filed, but no other further progress on that?
Yes, I apologize. I'm trying to read your title and I'm feeling my age.
You're fine.
So thank you, madam. We filed our Class 6 permit in March. So we've been in communication with the DEQ. We should be going through the comment, or we should be receiving their comments here in the next several weeks. So it's an active Class 6 permit. Based on our conversation with the DEQ, we think that's about a 12-month process to be able to get our permit to construct. We're using that first form, and then we will be filing subsequent permits in the area as a result of successful pore space negotiations, but also making sure that the DEQ is comfortable with our application to be able to progress that. So, thank you. Good question.
I'll have the treasurer and then I'll come back.
Yeah, Mr. Chairman, just the possibility exists that maybe that we could use CO2 to like pressurize a lithium deposit on the other side of the state that's in solution. But the lithium is such a small percentage, that you can't pump it up by itself. But if we could get CO2 down there to pressurize it, then it might actually make that an economically viable purpose. And so that's something that if you guys had some time can take a look at that prospect, because I think your line goes clear over to Utah, I recall.
Mr. Treasurer, for this particular project, this one actually stops. We do have pipeline that goes all the way over in that side of the state. This particular pipeline actually ends just south of the Wyoming border, but travels through Laramie County, so the far southeast side of the state. That being said, though, again, CO2 is a commodity. And when you have it available and you're just trying to prevent it from going to atmosphere, and there's a myriad of other opportunities for you to be able to utilize that commodity. And so as you mentioned, now we can unlock other value streams for the state by having it here in Wyoming in large quantities, pure CO2, and ratably, which is important.
Okay, thank you.
Thank you. Mr. Secretary.
Mr. Chairman, I was wondering if you could sort of estimate the size of the premium that we didn't receive because of some of the restrictions we had in the contract. And is it 15%? Is it 20? Is it 10? Is it 5? And I understand you had a lot of negotiations, but I mean, about what was it?
So this was the agreement that we reached. So just one thing I want to be clear on, this initial bonus payment, sorry, Mr. Secretary, I need to make sure I use my introductions correctly. So one thing to be clear on, as Jason mentioned, and maybe this isn't clear, so the bonus payment itself is reflective of a similarly situated landowner. Like that's what we've paid to procure the rights if we didn't impact the minerals at all, period. Okay. Then when we calculate the true-up payment, we are actually going to give you the benefit of that in the weighted average rate that we paid across a unit. So as an example, we will have a unit is located around an injection well. So it might be that maybe the average annual payment that was received was, maybe it was $25 because a lot of the people in that area were willing to agree to forego some of the mineral development and give us some additional rights. That will be reflected in the state's payment, okay? So you're getting the benefit of the group negotiation, even though you might have more limited, they had more limited, we have more limited rights for this particular pore space. So you're getting the benefit of that in the true-up payment. It's just the bonus, the initial bonus payment is just the kind of day one payment that we make. So it's very similar, but we've had a range of rates out there. Again, some small landowners, for it to be worth their time, if they have 2 or 3 or 4 acres, you might need to pay them $50 an acre for it to be worth it for them to sign a lease. So.
Thank you for the questions. Thank you very much, Mr. Quackenbush. I'd note a couple of things just for information. North Dakota and Wyoming are the only 2 that have Class 6 primacy at this point. Louisiana and Texas are both working very hard to get that done. It'll take a little while to get that accomplished. Problematic in this whole equation is nobody seems to have come up with a price for carbon dioxide, which is ironic considering all the ESG pieces that are there. But to your point and to the treasurers, the ability to do a lot of things with that CO2, whether it be imported, as North Dakota gets from Wyoming, or export, or just use in-state, is something that the state ought to spend some time and policy looking at. I really appreciate Tallgrass bringing this forward. This is all new. EPA doesn't like the idea, and it, I think, is going to be valuable if we get this accomplished properly.
Thank you, Mr. Chairman. We appreciate it. It's a great opportunity for the state.
Yep. What's the pleasure of the board? Oh, one more question, Mr. Secretary.
Mr. Chairman, Mr. Crowder, where is this true-up payment in the contract? Can you explain this? And where is it?
Mr. Chairman, Mr. Secretary, it starts on page 7 of the contract, in section 5.2. The second bonus payment, and goes on to page 8 for how the second bonus payment will be calculated.
And at the bottom of the page is the treasurer's changed language as well.
And Mr. Secretary, if I may, while you're taking a look at that, just to put, the calculation itself is obviously taking you through the process to be able to calculate it quickly or accurately. What it is doing is taking a unit, for those that don't know, when we permit a well, you will have a unit around that well, okay? It'll be the impacted, it'll either be where you expect the CO2 footprint to reach, or in some cases, like a buffer beyond it. But those are the landowners that will make up a unit, okay? That calculation is doing is saying, the way our contracts work, we have annual payments, and then you flip over to an injection fee. It will take the weighted average annual payment in that entire unit for all the private pore space, and it will give you a per acre rate. And then the state will receive that same per acre rate per year, so it'll calculate over time at that second bonus payment. So even as the market continues to develop, it might be that for some leases we sign that some of them are more expensive, closer to injection, because they didn't receive as many annual payments. The state will receive the benefit of that in that calculation. In addition, we also agreed to the most favored nations clause. So we feel that's where we think we feel very comfortable that, like, if we just focus on the bonus payment themselves, these are two elements that don't exist in our other contracts. So if you were just to focus on the bonus payment, you'd only be focusing on one element of compensation. You take all of it together to make sure that again, as negotiated, that the state is receiving a very market rate and the most attractive rate in that particular unit.
Okay, thank you.
Thank you.
Pleasure of the board. Madam
Mr.
Auditor.
Chairman, I'm ready to move the director's recommendation, but I'm need to, I guess, have the specifics on the terminology on how to update, how to make the aforementioned amendment to the lease.
So just as a matter of efficiency, this probably isn't exactly correct by form, but we'll be voting on the right thing. Jason, do you want to tell us exactly, I think it's on page 8, exactly what the language change is?
Absolutely, Mr. Chairman. It is page 8. It's section 5.3 of the storage fee subsection B, the compensation rate escalator. We will strike in that section, in the first sentence, the commencement of the operations term, and insert DEQ's approval of a Class 6 permit associated with the project.
Thank you. Jason, Madam Auditor, does that help?
Yes. as enumerated by Mr. Crowder. That would be my motion with that one change to
Okay.
the lease.
It's been moved by the auditor, seconded by the superintendent. Is there any discussion? Hearing none, all in favor? Signify by saying aye.
Aye.
Mr. Secretary? Aye. It's an aye. Motion carries.
Thank you, Mr. Chairman. The next item on the agenda is D13, which is to consider a settlement agreement related to lease number 2-3651, related to Eaton Brothers and Ladkey and Coxbill in Campbell County. I believe you've talked with your conflict counsel, Mr. Brown, on this matter. I think he is here. So because OSLI is a part of the settlement agreement, Chris, do you want to come up and introduce the matter, or would you prefer that I just lay out the facts? It's a little bit awkward because we haven't done this before.
And Madam Director, just before we get to that point, Eatons are friends, but I have no business dealings with them. Ladkeys are friends, and I have no business dealings with them, but I just want to be clear. I don't think it compromises me in any way.
Okay. Mr. Chairman, I will just briefly go through the facts here. The Eaton Brothers, Inc. held state grazing and agricultural lease number 2-3651, consisting of about 1,920 acres in Campbell County. The lease expired February 1st, 2022. The lease was then considered vacant pursuant to Chapter 4 of the board's rules. On June 7th of 2022, OSLI advertised the vacant land that was subject to the lease, and we accepted applications by sealed bid until July 1st of 2022. The Eaton Brothers and Ladkey and Coxbill timely submitted applications. We determined both applicants were qualified for the preference pursuant to Wyoming Statute 36-5-105B, and based on the Chapter 4, Section 6C, Romanet 3 rules of the board. The director, I requested a final bid from each conflicting applicant via sealed bid. Eaton Brothers submitted a final bid in the amount of $4,944 per year, and Ladkey and Coxbill together submitted a final bid in the amount of $10,251 per year. On November 21st of 2022, I issued the director's decision conditionally awarding the lease for the lands to Ladkey and Coxbill, as they were the high bidders. The Eaton Brothers appealed the director's decision on December 21st of 2022. As per our normal process, we transmitted the appeal to the Office of Administrative Hearings pursuant to our rules and pursuant to the Wyoming Administrative Procedures Act. This was a contested case before the Office of Administrative Hearings. Since the transmittal of that appeal, the parties engaged in settlement discussions and have come to an agreement. All the parties have agreed to the executed settlement agreement. That's been made part of your materials, and it's now ready for the board's consideration. I would note that conflicting lease appeals are governed by Chapter 1 of the board's rules and the Wyoming Administrative Procedure Act. The board's rules provide that any contested case may be finally disposed of by stipulation, consent order, or default of a party when approved by the board. Any such disposition shall be made by order of the board, and that's Chapter 1, Section 9B. The Wyoming Administrative Procedure Act also allows for contested cases to be resolved by stipulation, agreed settlement, consent order, or default. That's pursuant to Wyoming Statute 16-3-107N. As I mentioned, the parties have agreed that the settlement agreement will fully resolve this matter. And OSLI believes the agreement to be in the best interests of the trust beneficiaries. So we are recommending approval of the settlement agreement and issuance of the attached board order accepting said settlement agreement.
Thank you. Any questions? Any questions? What's the pleasure of the board? Madam Auditor.
Mr. Chairman, I would just note that I'm not sure that there's such a thing as a happy ending to a contested case hearing, but I sure appreciate the parties working together, and I do think this is a good solution. And I would move the director's recommendation that we approve the terms of the settlement agreement and execute the board order attached as Exhibit A to the settlement agreement.
It's been moved by the auditor, seconded by the treasurer. Is there any discussion? Hearing none, all in favor signify by saying aye.
Aye.
That motion carries.
Thank you, Mr. Chairman. The next item is G2, and this normally would be put on the consent agenda. However, in light of the Cushman matter earlier this morning, we do have a temporary use permit that's listed on board matter G2. It's TUP 03459, Danny or Barbara Cushman. It's for the temporary agriculture and grazing use. So we need to remove that from the temporary use permit list, as that will not be needed any longer with them obtaining the lease. And in addition to that, I had preliminarily approved the TUP, so you will also need to deny that preliminary approval in addition to removing it from the list.
Mr. Treasurer.
I would move that we deny the temporary use permit. And I guess I'll just make that straight motion and we'll clean up the other later.
Thank you. Is there a second?
Second?
It's seconded by the auditor. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Motion is approved.
Mr.
To
Chairman?
deny. Okay.
I would move that I would move the director's recommendation on all remaining TUPs listed in board matter G2.
Second?
That's been moved and seconded. Madam Director, I just want to make sure that should be pretty clear, but I don't know if we need to remove this from the list or not. I think it's denied, so I think it should be clear.
Mr. Chairman, I think we get the board's intent here.
Okay.
And just so that the intent of the treasurer was also to deny my preliminary approval as part of the denial of the permit, I think we're good.
Yep.
Yeah.
Okay. All right. That's been moved by the auditor, seconded by the superintendent. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
Thank you.
I think I was denying your temporary approval is what I was doing to start with. And then
And the temporary use. Okay, great. Thank you. Mr. Chairman, the next item on the agenda, we have Kelly Norris, the interim state forester. I believe she's here for the forestry and fire report.
And I know that she took her time to get here. I don't know if she was expecting things to take a while, but you know, you're probably more nimble than Bill Crapser was, so. We'll tell him that too.
she was here.
Thank you.
I think I need to apologize. I'm going to remember Amy Arbor Day celebrations here on the state, so I apologize.
We took notes.
Well, thank you. And thank you, Mr. Chairman and members of the board. It actually worked out that I was so late. We've been waiting for the June fire potential. And it wasn't there at 8. It wasn't there at 10. And I just got it emailed to me. And I want to thank the governor's office for printing this off for us. And so here we go. I'll start off my briefing with the fire potential outlook. The National Wildfire Potential Outlook shows pretty near normal wildfire potential in Wyoming. We had pretty sustained precipitation and pretty below normal temperatures across Wyoming in May. Our snowpack has been holding off in the higher elevations. It's been pretty slow due to the abnormally low temperatures. Our drought conditions across Wyoming have improved. Although the eastern portion of Wyoming did see some deficits in precip over the last month, and it's still holding out with some abnormally dry conditions. It's still persisting. With our snowpack being slow to move off, that's kind of giving us a bit of a buffer, if you were to say, as we're going to expect to see some warmer temperatures rising in the coming months. So across the state, we're in green up. We have been having a few starts. Just today, I've been getting some dings in Campbell County area. but nothing too major. That is the area of the state that is probably the driest in that northeastern portion. If we were going to say that we're expecting an average fire season in Wyoming, which we are currently, for Wyoming, that's approximately 900 fires in a year. So just to kind of give you a heads up with that. So as for state forestry and the preparations for this year's fire season, the HeliTAC program is heading into its 20th season. So with that, we have a permanent position that we staff fully year-round, who just was hired on, I think it was February, Chris Norquist, and then our 4 seasonals came on May 1st. We also help staffing the HeliTAC program with our federal partners. So the Medicine Bow route provides a position during our contract period. And between the Black Hills, the Bighorns, and the Med Bow, they provide typically 2 detailers who rotate in every 2 weeks to help keep the HeliTAC program going. The helicopter contract is for 120 days this year, and it will start June 5th. So that's Monday. And we will then be going into our single engine air tanker program, which will begin its 4th season this year. And we call that SEATS, but single engine air tanker. We like our acronyms. So the 2 seats are going under a 90-day contract. They're going to start on June 15th. We house those 2 seats at the Casper Airport in conjunction with the BLM. And we typically staff this with cooperators across the country that come in that are seat-based managers. Our forestry conservation program currently has 26 fully trained inmates and 7 crew bosses ready to be flood support or wildland fire support, whichever we get called upon. I want to just take note on that. This is the largest inmate crew we've had in years. And I just want to acknowledge and thank the leadership team of Wyoming Department of Corrections for all their hard work in helping us get to this point. The inmate crews are a huge asset for us and a big benefit when it comes to wildfire suppression response. And we couldn't do it without that strong support from Wyoming DOC. State, county, and federal firefighters have been really busy finishing up training, doing our PEC tests, fire refreshers. State Forestry recently conducted an agency representation training for all of our staff that participate in wildland fire. We have quite a few new employees, and learning our processes and procedures as we go into wildfire season. We're expecting that we're really going to focus on cross-training during this fire season and bringing many of those new employees along with us and getting them up to speed on how we do fire and cost shares. Our shop has been very busy preparing and fixing federal excess property, which we call FEPP. We were able to acquire a very large mobile home from the Air Force, and we are creating that and turning that into a command center that can be used for our type 3 state and private fires. We have a finance trailer, we have a planning trailer, now we're going to have a command trailer to help support those type 3 fires on state and private lands. So I'm going to move into the forestry update. I have good news on the Good Neighbor Authority front in hiring. So our GNA seasonal for the Bighorns started last Monday and is already out and about in the Bighorns starting on project work. We have hired our Black Hills GNA forester. That position will start mid-June. And once that position starts, we will be fully staffed with all of our GNA foresters. So that means the Black Hills, the Bighorns. We have 1 in the Bridger Teton. We do have 2 in the Medicine Bow route. One of those is actually a shared position between Med Bow route, High Desert District BLM, and State Forestry. We will be having our partnership coordinator position open, I'm hoping by tomorrow, for application. That position will help manage and grow our GNA program while also working on shared stewardship. So I'm hoping to be able to hire that position hopefully by sometime in July. So currently we have 1 active GNA timber sale going on in the Black Hills. We expect numerous others to begin as the snow melts off. This includes BLM GNA timber sales. We have one that will be going on in the Southern Bighorns, as well as a few in the Shirleys. And then the Black Hills, we just had a brand new agreement signed, and that agreement is what we've been waiting for so that we can put out a salvage timber sale in conjunction to the Fish Creek fire from last year. So that will be going out sooner than later as well. I wanted to give the board a quick update on forest plan revisions. So the Black Hills final assessments will be coming out soon. The LiDAR contract was recently updated to an even higher quality flight. It basically doubled. It went from 8 to 16 pulses per minute. The flight is still planned to occur this summer. The Bridger Teton had a cooperating agency kickoff meeting, and their draft assessments are expected to come out this fall. The Medicine Bow route is still planning on kicking off their plan revisions this fall with an October timeframe. So while our wildland fire staff have been really busy this spring, we also have been very busy on the program manager and state and private side. Wyoming was recently awarded 5 out of the 6 fuels mitigation projects that we applied for in Region 2. These projects are funded under a program called Community Assistant Funds Adjacent to National Forests and Grasslands. That is a mouthful, so we call it CAFA grants. These are really competitive grants, which means most of our staff's time, they coordinate with our county cooperators, and we spend quite a bit of time developing and writing these grant proposals. And this year it really paid off for us as we brought in over $1 million into the state for those fuels projects. So 2 of the projects are located in the Laramies. One is in Esterbrook. It'll be sub-recipiented over to Converse County to implement. The other one is in the North Laramie Peak area that State Forestry will implement. 2 projects are in the Bighorns. One is in the Little Bighorn Canyon, which will be sub-recipiented in Sheridan County. The other one is the Washakie Gold Mine Road area, and that will be sub-recipient in Washakie County. We also have one project in the Black Hills. It's going to be called the Mosky Fuels Break Expansion, and that one State Forestry will be implementing. So all of these projects are being done on private forested lands, and they really help expand that landscape level cross-boundary work that is occurring on the U.S. Forest Service land side. And so these projects just will border those projects. Wyoming also received IIJA funding through the Community Wildfire Defense Grant, so CWDG, for the Crooked Creek Community Fuels Mitigation Project, which is located near Du Bois in Fremont County. We will also be sub-recipienting that project to Fremont County to implement. And again, this is a competitive grant program. So Wyoming had 1 out of our 8 projects funded in the first round. The second round of applications opens up this July, and we are working with numerous counties on their applications and multiple applications for the County Wildfire Protection Plan updates, or what we call CWPPs, as well as a few additional fuels mitigation projects. So we're expecting about probably 8 different applications going into that. Lastly, Wyoming State Forestry was recently awarded $500,000 through the Urban and Community Forestry IRA program for a proposal to do hazardous tree removal, planting, and establishing new arboretums and community orchards in our underserved communities across the state. So the majority of these funds are again going to be passed through directly to go to the communities that will apply into this program. We believe this funding should be making a pretty positive difference to our underserved communities, and we'll be working with each of them to improve their forests moving forward. And so with that, I'll leave it open for questions.
Thank you, Kelly. Great report.
Yeah, Mr.
Let me have the auditor first, then the treasurer, and move on there.
Just very quickly, thanks for being here, Forrester. I really enjoy well, hopefully not daily, but periodic fire updates. So I guess I would request that we would continue to be on that email list. I think we asked a couple of years ago, and I don't think that would change, but I look forward to them with bated breath each morning. So
Mr. Chair, Ms. Auditor, yes, we haven't had anything to notify you on.
Great.
Yes, which has been great. But yes, both my fire management officer and our retired state forester have gone through that list. I've worked on that and we've looked at it closely. But yes, we will include you as activity starts up. We haven't had the activity as we've had in previous years. So thank you.
Thanks.
Yeah.
Yeah, Mr. Treasurer.
I guess congratulations on the 4 out of 5 grants, but you had 1 out of 8 on the community development grants. Just kind of wondering why, what was going on there. And the other thing is that I heard when we had all of this smoke in the air from Canada that those were actually prescribed burns. Is that right?
So, Mr. Chairman, Mr. Treasurer, great question. I will start with the CWDG and then I'll answer that other one.
Yeah.
So CWDG, yes, we had 1 out of 8. Colorado had 1 out of 35. Kansas received nothing. So I felt like we did pretty good. We had to hit very specific areas in the grant. We had to show that these communities were underserved. We were fighting against populations. At the end of the day, California definitely took the majority of that first group of funding. As state foresters, Council for Western State Foresters, Region 2 and Region 4 did not do as well as other areas. And so we've been working with the U.S. Forest Service, with DC staff, and the comments actually just came out on those. And so we've been completely reworking those to be better and to be able to fit very specific needs. We just had, my fuels mitigation coordinator just pointed out, we now have disaster drought noted in about 5 to 6 counties. That'll be perfect because we need to show a disaster associated with needing a project in that area. So we have to make a few connections, do a few things to improve those applications, but we're hoping to be much more successful the next go around.
Yeah.
And then in regards to the smoke, we did not have prescribed fires in Wyoming. There was prescribed fires, from my understanding, down in Colorado. I flew into Denver and they did have signs posted that day along the highway in Colorado. They were doing a prescribed fire, but we in the state of Wyoming did not have any prescribed fire that day.
Yeah, but the Canada thing, because we had a lot of smoke from Canada, so.
We did.
Yeah. Kind of a question on the, Mr. Chairman, on the orchard thing. Something that I don't know whether this would fall into something in the areas, but I know just in the little housing project where we're at, there's like a half dozen trees that basically died in these houses, or like 3 years old, 4 years old. And so there's a lot of places within the city of Cheyenne that I think you could probably knock on the door and say, hey, here's a apple tree, or here's a cherry tree, or here's something like that. And you could probably plant orchards all over Cheyenne just because of the trees that died during this drought. Yeah.
Mr. Chairman, Mr. Treasurer, I'm really excited you recognized it was because of drought. We've been getting quite a few calls, sick tree calls, specifically on spruce trees across the state. Our foresters have been working with our arborists. They've actually been going into bucket trucks to look at the top. We've been thinking it's an IPS issue, for example, and we've been notified that it's really drought, that we're finally starting to see the effects of that significant drought over the last 3 years in our mature trees. In regards to planting new trees, you're absolutely right. There is an excellent program called Rooted in Cheyenne. Wyoming State Forestry had a volunteer team this year and helped plant trees across the city of Cheyenne. The program even helps cost share and will plant the tree properly for the landowner and provide a bag where they can even get their water filled. And it's a great program. I highly recommend. I could send you information. You can share it with your neighbors that they look at signing up for that, because it's a great program.
Thanks. Kelly, I just want to commend you, and I know the president's here. Your work on the Black Hills Forest has been particularly helpful, and thank you very much. It was a huge victory to get that 16 pulse LiDAR survey. That was not an easy lift, and just congrats. Mr. President, I don't think you and I have had a chance to talk, but for the first time, Region 2 has had a chance to talk to the governor of Nebraska, because they had a fire on the Nebraska National Forest. And so they are now working with Mr. Nyman to, Kelly, you helped expedite that. I really appreciate your work because that's going to be very important for Nyman Mills.
Mr. Chairman, thank you, Kelly. Yeah, huge. And, not just Nebraska, the states around us are starting to pay attention now on these forest plans. It's between what you folks done in the governor's office regionally, I've got people reaching out to me now saying, we've got forest plans coming. How do we pay attention to what's happening in Wyoming? So, I think you're going to be in a unique spot to lead community-based forest plans. And I think the states are paying attention. They're getting it. The Forest Service is going to have to step up their management. We're going to help them with it. So I thank you, and I thank the governor's office as well. It's been a long path to get there, and South Dakota is in with both feet now.
Yeah,
so we're moving.
They were putting their toe in the water for a while, but they're now in.
Thank you, Mr. Chairman. Thank you, Mr. Driscoll. One of the things I did have a conversation with Regional Forester Frank Bim was, even though we're in the process of being pretty busy with forest plan revisions, we still don't stop doing the work, the important work of doing the NEPA and getting the work done on the ground that needs to get done. And how can state forestry, through our GNA program, continue to help that movement forward, in particular in the Black Hills? That forest alone has 40 vacancies. And so meeting with the acting forest supervisor yesterday, we had that discussion in particular, and looking at different ways and continuing to move the needle forward on getting work done on the ground, even though we have important work to do in the forest plan revision.
Thank you. Any further comments? Fantastic.
Thank you, Kelly. Mr. Chairman, we have one walk-in matter on the agenda for today, and it is to consider the Office of Administrative Hearings recommended findings of fact, conclusions of law, and order in the matter of conflicting lease application by Farner Cattle LLC for state lease number 1-6929, which is OAH docket 22-032-060. And with that, I would yield to your conflict counsel, Mr. Brown.
Mr. Chairman.
Mr. Brown, thank you.
Members of the board, and this is walk-in matter number one, and thankfully, given your very long day, I think it's the only walk-in matter, so I think it's the last thing you'll have to consider today. This matter is an appeal from a director's decision resolving conflicting lease applications by conditionally awarding the lease to the applicant holding title to lands nearest to the lands applied for, which was a Nimmo Ranch Company, over a competing applicant, Farner Cattle LLC. During and after the application period, the Office of State Lands and Investments made procedural and factual errors. In an attempt to correct those errors, the OSLI reopened the application period to the initial applicants, Nimmo and Farner. Both entities submitted replacement applications. After receiving the replacement applications, the director concluded that the existing leaseholder, Nimmo, had entered into a grazing arrangement which violated the terms of the lease. As a result, the director concluded that Nimmo was not qualified to exercise the preferred right to renew the lease. Although Nimmo was not qualified to match the high bid as a preferred right, the director concluded that Nimmo was still eligible to seek renewal of the lease. To ensure Nimmo did not obtain advantage of the preferred right to renew, Nimmo's bid was reduced to the minimum annual rental amount of $18,171.58. Because Nimmo's reduced bid matched Farner's replacement bid, the director conditionally awarded the lease to Nimmo because Nimmo owned land nearest to the lease area. Nimmo and Farner both timely appealed the director's decision on multiple grounds. The OSLI referred to the matter to the Office of Administrative Hearings to conduct the contested case proceedings. Nimmo filed a motion for partial summary judgment on August 5th, 2022. Farner and OSLI opposed Nimmo's motion on October 13th, 2022. The Office of Administrative Hearings issued its recommended findings of fact, conclusions of law, in order on Nimmo Ranch Company's motion for partial summary judgment. After which, Nimmo submitted the following 3 exceptions to the board, to the hearing officer's recommended decision. Those exceptions were that the commissioners should reject the hearing examiner's recommendation to deny Nimmo Ranch Company's partial motion for summary judgment because the hearing examiner failed to properly consider Wyoming Statute 365104. Number 2, the commissioner should reject the hearing examiner's recommendation to deny Nimmo Ranch Company's partial motion for summary judgment because the hearing examiner failed to properly consider the commission's duty to protect the trust beneficiaries. And number 3, the recommended findings of fact are incomplete as they failed to include Nimmo Ranch Company's original appeal. In the hearing officer's recommended decision, the hearing officer addressed the first 2 arguments identified in Nimmo's exceptions, and you have both the exceptions and the recommended decision in your materials. First, the hearing officer found that neither the Constitution nor the applicable statutes, including Wyoming Statute 365104, appear to show any intent to constrain or limit the board or the director from correcting inadvertent ministerial errors found prior to issuance of a final decision. Second, the hearing officer concluded that to find OSLI powerless to correct inadvertent errors would not further the board's role to administer state lands for the benefit and support of the public schools or other purposes, or to ensure each applicant is provided the same accurate information. With regard to Nimmo's third exception, Nimmo did not advance the third claim from its original appeal, which asserted that it reasonably relied on the acceptance of its original lease application. The hearing officer recommended that Nimmo's motion be denied and that partial summary judgment be entered in favor of OSLI and Farner on those issues. The hearing officer heard the remaining issues at a contested case hearing on March 21st, 2023. On April 20th, 2023, the Office of Administrative Hearings issued its recommended findings of fact, conclusions of law, and order. Prior to the contested case hearing, Farner identified the following issues. Number 1, did the director err in determining that Nimmo was a qualified applicant under Wyoming law? Also take note that Farner filed an exception to the hearing officer's recommendation regarding this issue. Number 2, did the director act outside of statutory authority or abuse the director's discretion when it lowered Nimmo's renewal application to the minimum annual rate? Also, with regard to this issue, Farner filed an exception to the hearing officer's recommendation. Number 3, did the director follow the Board of Land Commissioners rules and Wyoming Statute 365105C when conditionally awarding the lease? And number 4, did the director err when it determined that the office received 2 applications for even rental offers and awarded the lease under Wyoming Statute 365108? The hearing officer addressed the issues raised by Farner. First, the hearing officer found that the statutory requirement for an applicant to comply with the laws of the state refers to those laws that directly regulate the ability of one to transact business in Wyoming. Second, the hearing officer found that the director's decision to reduce Nimmo's application to the minimum annual rate was not contrary to law or an abuse of discretion. Third, Farner's claims regarding Nimmo improperly obtaining the lease through misrepresentations on its initial 2020 renewal application was not properly before the board. And fourth, having found Nimmo violated the prior lease provisions, the hearing officer found that the director did have the ability to remove Nimmo's renewal preference and reduce Nimmo's bid to the minimum annual rate. Prior to the contested case hearing, Nimmo identified the following 3 issues. Did the director err in determining that Nimmo Ranch Company violated the terms of the lease by failing to obtain board approval for Nimmo's agreement to allow livestock owned by a third party to graze the lease. Number two, did the director err in determining that Nimmo was not qualified to exercise the preferred right to renew the lease in Wyoming Statute 365105C? And three, did the director err in determining the Farner's application was complete despite failure to include a deposit for improvements? The hearing officer also addressed the issues raised by Nimmo. First, the hearing officer found that the director properly determined that Nimmo's agreement with a third party concerned, at least in part, the premises contained within the lease during the term of the lease without approval of the director. Second, the hearing officer found that Nimmo was not qualified to exercise the preferred right to renew because it violated the provisions of the lease. And third, the hearing officer found that any error which might be attributable to OSLI for not rejecting Farner's original application for lack of a deposit is harmless. The hearing officer recommended the board uphold the director's decision of March 14, 2022, awarding lease 1-6929 to Nimmo Ranch Company. Mr. Chairman of the board, my recommendation is to accept both of the Office of Administrative Hearings recommended decisions and issue a final order denying Nimmo's motion for partial summary judgment and upholding the director's decision to award the lease to Nimmo for the reasons stated by the hearing officer, and also included with your materials is a recommended proposed findings of fact, conclusions, law, and order, which attempts to achieve that end.
Thank you, Chris. I appreciate that. Are there questions for Mr. Smith? Ms. Treasurer.
Yeah, I guess looking at your recommendation to deny the partial motion for summary judgment, I'm not sure what that accomplishes because if we uphold the decision to award the lease to Nimmo for the reasons stated by the hearing officer. So if we would bifurcate that and just uphold the director's decision to award the lease to Nimmo for the reasons stated by the hearing officer, do we in any way prejudice Farner because they don't have the lease? And what if we don't prejudice Farner because the lease was awarded to Nimmo, what is the reason for upholding the denying the partial motion of the summary judgment?
Mr. Chairman, Mr. Treasurer, just off the top of my head, I'm not sure I'm thinking of any potential bias towards Farner. However, I think there is at least the opportunity for either or both of the parties to appeal this, and I would suspect that Nimmo would appreciate that the issues that it brought forward and took exception to would like to have a final decision on those, so that if this matter goes to the next level, which would be the district court, that they have a full and fair opportunity to argue those issues. So the only way that they can have a final decision on those claims and arguments that they made is if the board takes action with regard to those claims that they made.
So the only way we would prejudice, I guess, Nimmo or Farner, is what you're saying is that if we go right lockstep right down with the hearing officer, but don't we don't prejudice Nimmo if we agree with the hearing officer in this? I mean, why can't they continue to argue their case in front of the district court without the record that we essentially stamp?
Mr. Chairman and Mr. Treasurer, certainly the board has a discretion to do whatever they want with this decision. The board is not restricted to just adopting the recommendations of the hearing officer. Mm-hmm. The board can take a completely different direction if it so chooses. I'm a little hesitant to get any deeper than that if we want to, if the board is interested in getting some additional legal advice with regard to that decision, I would recommend going into executive session. Okay. But I think just to be very clear, you're not bound by the hearing officer's recommended decision. The board is certainly able to make an independent decision that is not consistent with the hearing officer's recommendation.
I guess, looking at it, I think that, and the state really lost out on a lot of money in the recommendation of that. I don't know if we could by arbitrarily, and I don't know whether this gets into legal recommendation or legal advice. Yeah, but I'll ask the question, and you can say that's probably stepping over the line. Is that to just go up to the original amount that Nemo bid in the original deal, which I think was something like 44,000 rather than 18,000 or something. So, you know, that's where I see the beneficiaries really losing out to the process. That even though it was supposed to be up to 77,000, that was an error cause. But there was certainly, you know, on record that $40-some thousand was a reasonable amount because it was bid. And that's the only thing that I see that moving outside of the realms of what you're suggesting here that might be contemplated to get the beneficiaries back in to the at least a not necessarily a totally hold harmless aspect of the whole process, but at least to that was a once agreed to aspect of the process that was higher than what the result was.
Mr. Treasurer, appreciate your thoughts about this. I'm a bit concerned that there are enough awkward concatenations here that if we were to add to those, we would not simplify, but rather complicate things. So I guess I appreciate, and I know because of the sets of circumstances, you're correct. The beneficiaries have lost a substantial amount of money. So. Are there other comments? Mr. Treasurer.
If we do nothing, then everything goes exactly with the last administrative hearings outlook, which is what you have in this particular summary.
Mr. Chairman, Mr. Treasurer, I think you have to do something. And so part of that something or an option under that menu of some things you can do is simply adopt, which is what I'm recommending, adopt the recommended decision by the hearing officer. That's all it is a recommendation. Yeah. There needs to be a final decision in this action, and that's the decision for this board to make. So it's either adopt the recommended decision or do something else. But some final action has to be taken by the board.
If we don't adopt the final, the administrative hearings disposition, which is what you're asking us to do, then there's no final decision. Is that what you're saying? That I mean, I'm not sure if we adopt it or don't adopt it, the result's the same. The last decision was the administrative hearing office.
Mr. Chairman, Mr. Treasurer, if it's the pleasure of the board to do something other than the recommended decision, then I think I could work with the board to figure out exactly what that is. Because at the end of the day, under the APA, you have to come up with, and I believe the board's enabling statutes, you have to have recommended findings and conclusions of law. So we would have to identify those particular pieces in the facts and or the law that the board disagrees with the hearing officer on, then we would fashion the board's findings and conclusions instead of just adopting the hearing officers, which ultimately become the board's findings and conclusions. We would have to fashion those in such a way as to effectuate whatever final decision the board came to.
Okay, well, thank you for the tutelage in the process.
All right, thank you.
Mr. Chairman.
Madam Auditor.
Question for the office. I'm stretching back in my memory, and I feel like this lease was probably caught or flagged in the audit, the internal audit that occurred in, I mean, I know we dealt with them last August, but I can't remember, was the internal audit, it was obviously before that. Was that one of those? Because I remember multiple sort of classes of outcomes, you know, there were leases that had been issued, and we went ahead and honored those, and there were leases that hadn't been issued. Was this part of that group that we had, because I can't find it on the list of ones that we sort of dealt with, or, yeah.
Mr. Chairman, Madam Auditor, our counsel is telling us he's not sure it would be appropriate for us to comment
Oh, okay,
on this at
gotcha.
this point.
Okay,
Thank you.
I withdraw all my questions.
Chris, this is going to call for speculation, which you can say probably doesn't work. But do you believe that there is a way that we can obviate any further legal action should the parties want to pursue it on this particular matter? In other words, can we craft a conclusion here that's going to be satisfactory?
Mr. Chairman, that would be speculation. I think, and it's very unfortunate, kind of the factual errors that were made at the beginning of the process. I think the OSLI did the right thing to identify them, go back and try to correct them. But I think there are colorable claims from both of the parties based upon that unfortunate starting point that I'm not certain, at least sitting here, I can think of anything that would necessarily satisfy both of them. I don't know of a different result, which, and obviously the parties couldn't ever come together themselves and find a result, but not as I'm sitting here.
So just noting our track record with ignoring the Office of Administrative Hearing recommendations, I'm tempted to follow your advice. Mr. Treasurer.
You know, would it be, what I'm wanting to try to avoid is a situation where we award this lease and automatically it's subject to another call of a cancellation due to the sublease requirements of the statute. And I'm wondering if it'd be appropriate, just to make sure that that doesn't happen, is to say that we uphold all of these things and award the lease to Nemo subject to the successful completion of negotiations on a subleasing agreement for the livestock intended to be leased. And I think it would be as the statute is now and as the statute will be as of July 1st. And I don't know whether that, because otherwise I think we might get into a catch-22. We award the lease, bam, automatically foreigner says, oh, no, you can't award the lease because of what we've already gone through.
Mr. Chairman.
Mr. Smith.
Mr. Treasurer, a couple of things. One, I would advise that we need to make sure that the board's decision is restricted to those things that are contained in the record. So it's those things that were put in front of it or as part of the contested case hearings. We need to limit it to those things. The second thing I would advise is that there's a process in the board's rules with regard to cancellation of a lease, and it requires some action be taken by the director on the front end. A lease can't ultimately be canceled until that recommendation, which is appealable by whoever the leaseholder is that has to come in front of the board. So there's not going to be, at least my reading of the board's rules, there's not going to be an automatic cancellation. I think, again, leaning on just the record, I think the testimony that was provided by the office in this case was that the practice of the office is to work with the leaseholders to remedy any deficiency there might be in complying with the lease provisions. If my recollection serves me correctly, I believe some of the correspondence from the leaseholder was, please let us work to assure that we're not in violation of the lease. And so my role as conflict counsel, I've been unable to speak with anybody else in the case, including the office. And so I can't tell you what the current status of that might be. But what I can say is there is certainly a process in place that if a continuing violation were occurring, the process isn't for some other third party to bring a cancellation sort of action. Although, to be very clear, Farmer made those arguments in this case, and should they appeal, they can continue to assert those arguments. But there certainly is a process in place wherein the director has to make an initial decision. The lessee then has the opportunity to have due process with regard to that decision before it ultimately comes to the board, before it can be canceled. The director can't just, and it's my understanding, just cancel the lease.
I guess a question on timing, from what I understand, is that it's a yearling operation now, and there's probably no livestock on it, so they're not in violation of anything until the livestock show up. That's what I guess I would say. There's not subject to cancellation until there's a something that's, a foul on the new lease.
Mr. Chairman, Mr. Treasurer, again, I don't think cancellation's in front of the board as part of this record.
All right. Thank you, Mr. Chairman.
Thank you, Mr. Treasurer. Thanks. Any further comment?
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Chairman. Just on that note, then, perhaps depending on the direction that the board moves forward on the OAH's recommendation, it would maybe be prudent moving forward to have an update on whether or not that agreement is approved by the director, or what direction that moves forward, if that makes sense. Thank you.
Chris, any color?
Mr. Chairman, Madam Superintendent, after this board makes its final decision, then the contested case matter in front of the board is over. And I think it's perfectly advisable for the board to inquire with regard to the leases that the state has. So if that's something the board wants to take up into the future, I, as I'm sitting here, do not see an issue with that.
Thanks. Further comment? If not, what is the pleasure of the board?
Mr. Chairman.
Madam Auditor.
Noting your, I would maybe comment the same note that you made, that I think making any changes, knowing that we have been given a difficult fact situation here, I think changing anything at this point would further complicate future review of these decisions, which I think we all know will occur. So I would recommend that we accept both of OAH's hearings recommended decisions and issue a final order denying NEMO's partial motion for summary judgment and upholding the director's decision to award the lease to NEMO for the reasons stated by the hearing officer.
Madam Auditor, thank you for that motion. Is there support for the auditor's motion? It's been seconded by the treasurer. Thank you, Mr. Treasurer. Is there further discussion?
Mr. Chairman, does my motion need to incorporate the recommended findings of fact, or is that just signed by you and that's encompassed?
Mr. Brown.
Mr. Chairman, Madam Auditor, I think it would be perfectly fine to reference the draft. It certainly, as I mentioned, was intended to reflect the recommendation that I made.
So, Mr. Chairman, as part of my motion, I would incorporate the draft
Findings of fact and.
I've ran out of words.
Findings of fact, conclusions of law and order.
Findings of fact, yes, that. And I'm confident my seconder will agree, I hope.
Mr. Chairman?
Just
For clarity, was there any, I guess, findings of fact that was contested? Sometimes everybody agrees and sometimes they don't, what the facts actually are.
Mr. Chairman, Mr. Treasurer, as I'm thinking about the record, and I'm specifically trying to recall, and I've provided the exceptions that both Nemo made and Farner made in the case. The only finding of fact exception that I am pulling off of the top of my head was from Nemo with regard to the motion for summary judgment. They took an exception that the finding of facts under the recommended decision about the partial motion for summary judgment did not include their initial appeal. And I did address that, or I think it is addressed anyway in the proposed motion, that the first two issues that were raised in Nemo's initial appeal were fully heard, I believe, by the hearing officer. And I did not see anywhere else in the record where Nemo attempted to advance the third claim they made in their initial appeal, which related to, if I recall, reliance on what they styled as the initial director's decision. So that is a very long answer to, I do not believe there was a contest about facts other than, well, let me back up. I suppose part of Nemo's position about whether or not they were in violation of the lease, I think that could be arguably factual based as well.
Yeah. Okay. Thank you.
So, Mr. Treasurer, you accept the amended motion of the, as I say, friendly?
You know, I think that most of it seems like the testimony, I think, would bear out what actually occurred, and that, I think, on its face, I think would that those testimonies are part of the record going to the district court. So the district court, if there is a continuing effort to sway the district court one way or the other, because the testimony's there, they could rely on it and bring that issue back up. Is that correct?
Mr. Chairman, Mr. Treasurer, I believe that's generally correct, yes.
Okay, all right, thank you.
So
I just didn't want to limit anybody to their rights if there was something contested as far as a finding of fact, but as long as the testimony's there and the district court can rely on it, then and I just say that to the district court that don't have any deference in what we're about to do.
And so do I take that to be affirmative that you, okay, that you are seconding? Okay. So we have a motion that includes the findings of fact and conclusions of law. For any further discussion? Any further discussion? Any further discussion? Thank you. All in favor signify by saying aye. Aye. Nays? The motion carries. Thank you, Madam Director.
Mr. Chairman, that concludes the agenda for today, but with your indulgence, I wanted to report that we are making great strides in our hiring for OSLI, and we have some of the new folks here. So if I could just read out some names, some are here, some are not, but so that the board gets an understanding of who we've hired. First, we have Tori Thacker. She's our new Grazing and Agricultural Lease Program Manager. We have Megan Curley. She's our TUP Program Manager. Susan Todd, our Office Support Specialist. She's been helping with some of the minutes today. We do have a new Real Estate Analyst, Kaylee Schultz, but she is not here today. I have some Administrative Services Division folks. I'm not sure if they're down here, but Ben Wolf, he's a Senior Grants and Loans Analyst helping Beth out. Kata Maria Pounds, she's moved over to the Grant and Loans section. Then we have Jade Baylog, she's an accountant in the Fiscal section. Then finally, Ben has been doing some great hiring himself on the Field Services Division. We have Craig Odell, our new Field field supervisor, and we have Nate Nixon. And as you might imagine, with the good weather, they are in the field today. So with that, Mr. Chairman, that would conclude what we have for the board today.
Mr. Chairman, just as a housekeeping, general order of housekeeping, are you moving forward with any negotiations with NEMO on the subleasing, or do you intend to?
Mr. Chairman, Mr. Treasurer, we don't have that issue before us. This was the contested case, and we had to let that play itself out
Right.
until the board makes its determination, but we are not
So
actively
now
doing
that we've
anything.
made that determination, is one of your next steps is
We'll have
entering into some negotiations so you have clarity on the subleasing.
Mr. Chairman, Mr. Treasurer, we will work with Mr. Nimmo and figure out what's going on and what's appropriate, given some of the new statutory things that have been put in place and our rules. But yes, we will be working with them to move forward.
I think pay particular attention to what you do, because I know a lot of people are getting out of the cow business and running yearlings because of the drought, or they reduce their herd in half, and if they're gonna, market their grass, they're gonna probably have some yearlings come in, they may or may not own them. But you're gonna see this across the whole state, and maybe a nice little letter to everybody saying, if you're planning on doing this, this is what you need to do to make sure that your neighbor doesn't rat you out, basically.
Mr.
Okay?
Chairman, Mr. Treasurer, as you know, there are some statutory changes that address that. But yes, that's part of our goal this summer to get the word out. There are numerous changes in several of our rules chapters that we want to make sure that folks are aware of. So we will be sending out some letters to that effect. And hopefully we can get an article or two in the publications with stock growers and Farm Bureau to facilitate
And I
getting the word
apologize
out.
to the board for my politically incorrect analysis.
Great. Thank you very much for a full day. Thanks to staff. Welcome. Staff, don't run away. Some of these can be much shorter, but thank you very much for being here. Thanks to fellow board members. Welcome aboard. I would entertain a motion to adjourn. Been moved by the superintendent. Is there a second? What? Oh, well, Madam Superintendent, the auditor, I think, was asking if we wanted to take public comments. So with that,
I would rescind my motion and
will-
for public comment.
I will open the floor if there are any public comments. Mr. Bump, I don't have anything on. Mr. Secretary.
Mr. Chairman, I do want to mention one thing. We're going a little long in the investment portion, but I've had a few constituents reach out to me about looking on our investments to use more Wyoming managers, and had a little bit of a proposal on that. Wanted to talk with the treasurer a little bit about it in the interim, but maybe in the August meeting, we can bring them in on public comment or, on the agenda, maybe use 4 to 5% of the permanent funds and use Wyoming managers, because we've got a lot of really talented Wyoming managers that are very qualified, and it's an economic development tool. And anyway, I just wanted to, I was going to broach it today, but then we were going kind of long. So at the end, I just wanted to mention it.
Yeah, we just look at the least cost, highest net return. A lot of the Wyoming managers just, when they just have a fee structure that is, unapproachable. But, if they're competitive, they're competitive.
Well, I appreciate the Secretary of State. I've run out of my words too. We can bring that up at a future meeting. We have discussed it from time to time, and appreciate very much the work that's being done. Madam Superintendent, I would.
Thank you, Mr. Chairman, would move to adjourn.
Is there a second? All in favor signify by saying aye.
Aye.